Oh, this is interesting.
Sure.
Good morning, everybody. Just checking in people here from the waiting room. Get people settled in here.
Mr. Klein?
Yes,
Hi, how is your first name spelled? Like, is it Bradley, Ley?
Ley, thank you.
Okay, thanks.
Hmm.
All right. Oh, that's why. That's better, I think. Cannot move while people are pinned. All right. I'm gonna try to set this up so I can move people who are speaking to the top of the gallery, but I don't know how well I'm going to be able to manage that during the hearing, so we'll see. All right, still a few people joining us. Thank you for the people who did connect 10 minutes prior, like I requested yesterday. Oh, there's the Mkenet. I forgot who that was. Was that a WEPCO person?
Yeah, so
Quarles.
that's our witness chair. We don't
Oh, that's
anticipate it being occupied today, but we
Okay.
still got it set up.
Just in case. Yeah, thanks. All right. We got everybody here. Actually, I did have I did want to have a request that I'd like to recall witness Stasek for one or two questions that I forgot to ask yesterday evening. If he's available, if it's possible to take him now, or we can wait when if he's available sometime today.
He's available now, and we'll rearrange for you.
Okay, great, thanks.
Judge Newmark.
Yep. Yes. Go ahead.
This is Priyam Desai with Sierra Club. I was wondering if we could spend a few minutes going back to some of the discussions we had at pre-hearing, specifically regarding the documents that Sierra Club was asked to refile.
Okay. What? Your witness isn't appearing. Is that correct?
My witness is appearing.
It is. Okay. So why don't we
Yeah.
wait? So let's wait for that for when your witness takes a stand, and then we can review if that's okay.
Okay.
All right. Oh, okay. Well, all right. So yeah. So let's get on the record. Welcome everyone back to the second day in 6630 TE 113. I just wanted to hit the ground running and not waste a lot of time at the beginning with our preliminary matters, but I have recalled witness Stasek just for a few questions that in the heat of the evening, trying to get done early yesterday, I forgot to ask. Just omission on my part, so appreciate the accommodation. So I'm going to swear you in. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do, Your Honor.
All right. And you're Richard Stasek, who testified yesterday?
I am, yes.
All right. Thanks. So just to quickly review and ask these questions as efficiently as possible, I did want to just, where's my documents here? Oh, they're right up here. Okay. So I just wanted to review one more time this sort of exemplary electric service agreement that the utility provided me. Can you see the screen share there? With the
I can, yes.
Okay. So I was just curious. I know that CP1 document, CP1 customers will commit to, or in the service agreement, they have a amount that's labeled the measured demand, and in this case it's 5,000 kilowatts. Can you see that there?
Yes, in paragraph 1.
Yes, you're right. Paragraph 1. Thanks. So just wondering, do you know in terms of the current range of the current group of CP1 customers outside of the VLC customers in this case? What's the highest demand in kilowatts that WEPCO currently has for existing customers?
Your Honor, that is confidential information about an existing customer, not a party to this docket.
Okay, I don't want the name of the customer, just the demand level.
I think even the demand level would be confidential. And it's broadly known who the largest existing customer is, so basically anybody could connect the dots there.
All right, let's go in the confidential session then.
Okay.
Let's see, we'll put everyone in a breakout. So let's see, would the confidential agreements that are currently in place cover this item? I would assume.
Believe so.
Yeah.
I don't know
okay.
if there
All
are
right.
people on here that. Oh, signed it.
We can go off the record.
Yeah, if we could go off the record and take a little break here, Your Honor.
Okay.
Great.
You know, I can ask this in a different way, just off the record. Is this something that would be in WEPCO's annual reports?
I don't believe so, Your Honor. It's load data is aggregated normally,
Okay.
It wasn't a discovery, which,
and there was no discovery about
no,
this.
there was a discovery
Oh, there was
request.
a
Jerry
discovery
answered,
request that we answered. We could find it.
Oh, you think it's in the discovery request response?
I don't recall the party that asked it, Your Honor, but there was a discovery request that asked for, I believe it was anonymized for the top, I think it was the top 5 customers I think the company currently serves. That's just going off of memory, but there was a discovery request in this theme.
Okay. Well, why don't you check for that and then get back to me? That's okay. And maybe we can avoid having to go in the closed session. If it's something that's already been filed.
Okay.
All right.
Judge, I think I can, I think I have the discovery request here.
Okay.
It's from the second set of Clean Wisconsin requests. I don't have the response handy, but it looks like that would be where to look.
Okay. So Clean Wisconsin second set of requests. All right. Okay. That might just streamline this. So why don't we check that first, then we can move on. So let's get back on the record. So it appears that we may have an answer to that question already on IRF through discovery request. So the the applicant will just check that out and see if that answers the question. We can just enter that as an exhibit. Otherwise, we'll loop back in here and we'll have to go into closed session to get that figure. All right, thanks. Well, so for now, let's just move on for what we came here for. So thanks for indulging this. So let's begin. I think we had witness Singletary was going to be scheduled first.
Yes.
Okay, great. Thanks.
Cub has 2 witnesses that will be verifying by affidavit. So Mr. Singletary will be our first and only witness today, I think. So we'll call him Corey Singletary now.
All right, I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, thanks. And go ahead.
Good morning, Mr. Singletary. Did you submit direct, rebuttal, and surrebuttal testimony in this proceeding?
I did.
And did you submit 9 exhibits into the record?
I did.
Is your written testimony and the information in your exhibits truthful and accurate to the best of your knowledge?
Yes.
If I asked you the same questions that appear in your testimony today, would your answers be the same?
Yes.
And I'd like to offer some brief surrebuttal from Mr. Singletary.
All right, go ahead.
Mr. Singletary, have you reviewed the surrebuttal testimony of WEPCO witness Mr. Stasek regarding the capacity-only option?
Yes.
And do you have a response to that surrebuttal testimony?
Yes. I know that it was part of an extensive discussion earlier in the hearing on cross-examination of witness Stasek. Considering what was in Mr. Stasek's surrebuttal, as well as the discussion earlier in the hearing, it's my opinion that this modification that Mr. Stasek has offered to the capacity-only option would be preferable to, from Cub's perspective, to the originally filed treatment of capacity-only bespoke resources as part of the application.
And do you have a specific response to the testimony of Mr. Sasek during cross-examination yesterday?
Yes. After following along and thinking on the responses that Mr. Stasek gave to the various scenarios that were discussed on cross-examination, I think I am following and I can appreciate what the intent of what WEPCO is trying to accomplish here. Like I said, I think the protections that would be provided under that modification would be preferable to the originally filed. There is still the question that the commission may wish to consider as it relates to some of the discussion around scenarios where or timings where non-participating customers may experience net costs as opposed to net benefits. And that was discussed early in the hearing. And again, so those are things I think the commission should take into consideration when evaluating one, whether to preserve the capacity only option within any final form authorized tariffs and what that capacity only option would look like.
And to be clear, do you stand by the recommendations for the capacity only that you made in your earlier testimony?
Yes, it's still my opinion that a more straightforward approach would be to not have the capacity only option. But if the commission did elect to maintain that, I believe there are better alternatives to what was originally offered.
Does this conclude your sir rebuttal testimony?
Yes.
Sir rebuttal testimony?
Yes.
Thank you. Mr. Singletary is available for cross-examination.
All right. I think the applicant had some questions. Why don't you go ahead?
Yes, Your Honor. Thank you. Good morning, Mr. Singletary. Joe Wilson on behalf of the applicant.
Good morning.
Mr. Singletary, in your direct testimony at page 21, you recommend that the commission modify the VLC tariff to set an explicit required subscription level, requiring customers to subscribe to Bespoke resources for 100% of their firm service level. Did you perform any quantitative analysis to determine the economic impact of such a mandatory requirement on VLC customers?
No.
Mr. Singletary, in your rebuttal testimony, you said that you and Clean Wisconsin witness Jester are in, quote, conceptual alignment, end quote, on the issue that VLC should be required to subscribe to Bespoke resources for 100% of their firm service level. Both Microsoft and Vantage have stated their intention to do exactly that, haven't they?
I believe that's what they've stated in the record, yes.
Isn't it also true that in his rebuttal testimony, Mr. Stasek agreed to adopt language into the tariff, saying that the subscriptions to Bespoke resources must be sufficient to avoid long-term reliance on fleet firm service or market firm service resources?
That's my recollection, yes.
So does this address your concern on this point?
Give me a minute. I would like to bring up Mr. Stasek's rebuttal testimony to...
Sure, it's on page 53 if that helps, this rebuttal.
Thank you. I just wanted to talk a little bit about the language in response to your question. I believe that this is an improvement, yes, because my concern with the original tariffs as proposed didn't really state any sort of expectations with respect to subscription level. This moves in that direction. I guess I would leave it at this point rather than sort of overburden the record. I believe would leave it to the commission to determine whether or not the specific proposed wording that Mr. Stasek has proposed, where he states essentially the sufficient to avoid long-term reliance on fleet services or market firm services resources, and the intent of that and how that would be enforced or implemented over the life of the tariff. If the commission agrees with the sentiment and the concerns expressed by myself and Mr. Juster, whether or not this sort of rectifies that, but I would agree that this at least puts forth in the tariff some sort of expectation with respect to subscription levels.
Is your understanding that this language we're looking at on page 53 of Mr. Stasik's testimony is in fact word for word the language that Mr. Juster proposed to address this issue?
That's my recollection, yes.
Okay. And you and Mr. Juster again are in conceptual alignment as to the issue, right?
Insofar as there not being sufficient requirements for VLC customers to subscribe to sufficient resources to meet 100% of their firm services load, yes. On that we are.
In your direct testimony at pages 21 and 22, you discuss an insufficient energy charge, which would be modeled after the insufficient capacity charge. You recall that?
Yes.
Did you perform any economic modeling to demonstrate that this additional charge mechanism would provide net benefits to non-participating customers?
No.
And did you perform any cost benefit analysis to demonstrate that there would be benefits to non-participating customers?
No.
Your source rebuttal eliminated some of the questions I was going to ask you, so I'm just perusing here. Judge Newmarker, I think we're going to be in Mr. Singletary's direct testimony for a few questions here.
Okay, thanks.
At page 19 of your direct testimony, you testified that the 100 megawatt floor or band for the insufficient capacity charge should be eliminated entirely or reduced. Did you calculate the actual dollar impact that the 100 megawatt allowance would have on non-participating customers' rates, if allowed?
No.
So you're recommending elimination of this floor without having quantified the harm you claim it would cause, correct?
Correct, because we're dealing with a prospective tariff with no current customers, and so I was dealing with it on sort of a theoretical cost basis.
So WEPCO has explained in the case that the reason for that 100 megawatt floor or threshold is that it recognizes the lumpiness of resource additions. Do you recall that?
Yes.
And WEPCO has also explained that generation resources cannot be precisely sized to meet customer demand megawatt for megawatt in real time. You recall that?
Yes.
Would you agree that allowing some tolerance for the practical realities of resource planning in this respect is reasonable?
The commission could find that reasonable, but I think it should also take into consideration some of the other discussion we've been having about timing and duration.
In your direct testimony, you pages 21 and 22, you discussed the insufficient energy charge again.
Mm-hmm.
And are you aware that Microsoft witness Mr. Gable Frank testified that such a charge would cause the generation system to be overbuilt and would undermine the value provided by MISO's markets? Recall that testimony?
I recall that that's his position, yes.
Did you conduct any economic modeling to analyze whether your proposed charge would result in inefficient overbuilding of generation resources?
No.
So is it safe to assume that you didn't perform any analysis to quantify the risk that your proposed insufficient energy charge would result in
I'm sorry.
overbuilding?
I'm sorry. Can you go back to that? So is it
Yes.
safe to assume that you didn't perform any?
Economic modeling to quantify the risk that your proposed insufficient energy charge would result in overbuilding of generation resources compared to what would otherwise be needed under optimal resource planning?
No.
So is it fair to say that you're asking the commission to adopt an insufficient energy charge mechanism without having modeled its potential effects on resource planning or system efficiency?
That would be one way you could argue it.
Mr. Singletary, at page 25 of your direct testimony, you testified that WEPCO's record, quote, offers no clarity specifically as to how WEPCO will determine net dispatch benefits, end quote, for capacity-only bespoke resources. Subsequent to that, WEPCO submitted in this docket economic analyses for the Foundry Ridge and Red Oak Ridge projects, right?
Yes.
And that modeling included market dispatch modeling prepared by the company and by Brattle Group, right?
That's my recollection, subject to check, yes.
Did you review the economic analyses that WEPCO submitted both in the Foundry Ridge and Red Oak Ridge dockets and in this docket?
I did review it within the scope of my area of expertise, yes.
And would you agree that those analyses included comprehensive market dispatch modeling that incorporated unit-specific operating characteristics?
That was how the modeling was described by the company's witness, yes.
Do you have any basis to disagree with that description?
I don't have any basis to disagree, no.
And among the description of the modeling was testimony that the company evaluated 2,916 cases for each of the two projects and demonstrated that benefits exceeded costs in a majority of the cases. Do you recall that?
I don't recall the exact percentage, but a majority, I think, is accurate, yes.
Did you perform any independent economic modeling to challenge those results?
I did not.
And do you have any basis to dispute the methodology or the results in WEPCO's modeling?
I don't have any basis to agree or dispute with that result those results at this time.
And you would agree, wouldn't you, that the commission wanted the opportunity to evaluate each and every capacity-only bespoke resource individually in acquisition dockets or CPCN dockets, right?
Can I have that question repeated back for me, please?
Let's read it back, sure.
Question, and you would agree, wouldn't you, that the commission will have the opportunity to evaluate each and every capacity only bespoke resource individually in acquisition documents or in acquisition dockets or CPCN dockets, right?
As I sit here today, yes.
Mr. Singletary, at page 7 of your direct testimony, you acknowledge that you're, quote, generally supportive of the rate-making framework represented by the proposed very large customer tariffs, right?
Yes.
And also on page 7 and 8, you recognize that VLC eligible customers have just, quote, distinct service requirements, unquote, and that under more conventional rate designs, they would create, quote, significant risk that incremental capital costs associated with VLC customers could be shifted to other customers, correct?
Yes.
And you would acknowledge, wouldn't you, that the proposed tariffs address those potential harms at least to some extent, right?
I would agree that the design of the tariffs is meant to address some of those harms as the company saw them when it developed the tariffs, yes.
So you would agree that the proposed tariffs are directionally better for non-participating customers than the status quo?
If by the status quo you mean customers that would be eligible under the proposed tariffs taking service under one of WEPCO's currently authorized tariffs, then yes.
Are you familiar with Mr. Nelson's, WEPCO witness Nelson's testimony to the effect that if the VLCs took service under the CP1 tariff, there would be a cost shift of approximately $1.5 billion to non-participating customers?
I believe he had something to that effect in his rebuttal, yes.
And did you perform any analysis to dispute those figures or to quantify the alternative impact on non-participating customers?
No.
And I assume then that you didn't perform any economic analysis to show impact on non-participating customers if the commission were to adopt your various modifications to the tariff. Is that fair?
I believe you asked me about that earlier, but no.
Judge Newmark, we're going to move from one question to Mr. Singletary's rebuttal testimony. It's page 7. Mr. Singletary, at page 7 of your rebuttal testimony, you discuss the 500 megawatt eligibility threshold for the VLC tariffs and suggest that the VLC tariff could be made mandatory above a higher threshold and optional below it. Do you recall that testimony?
Yes, that was an alternative I threw out for the commission to consider alongside what was proposed by the company. Yes.
Okay. And the company itself then subsequently threw out an alternative for the commission's consideration, which would make the tariff mandatory above 500 megawatts and optional between 250 and 500 megawatts. Do you recall that?
I do.
Would you agree that that's consistent with the approach that you had offered for the commission's consideration?
Is directionally consistent, yes.
Mr. Singletary, on February 3rd, 2026, just last week, you submitted direct testimony in Wisconsin Power and Light's case concerning its provision of service to data center customers, right?
Don't remember the exact date, but yes.
And for the record, that was docket 6630 TE 115.
I believe it's 6680 TE 115.
Thank you. Thank you. And in that docket, WPL proposes to provide service pursuant to individually negotiated special contracts rather than pursuant to standard offer tariffs, right?
At this time, that is the company's approach, yes. And by company here, I mean, sorry, I didn't mean to step on you. And I just wanted to clarify. When I say company here, I mean Wisconsin Power and Light, yes.
Thank you. Is it fair to say that as between these two options for providing service to data centers, you prefer Wisconsin Electric's approach of seeking approval of standard tariffs?
That is fair, yes, absolutely.
Okay. Judge Newmark, my colleague, Attorney Proctor Brown, sent around some documents with our initial disclosures. One of them was Mr. Singletary's testimony from the WPL case. Could we pull that up?
Yeah, I have that. I just wanted to review are we expecting, do you have any expectation to offer that as an exhibit, or you just want to discuss this in testimony on cross?
Well, I was hoping to offer it as an exhibit, but is there an issue with that?
Well, let's discuss that now. So my concern is at this point that it is, so we're in the pendency of both dockets. This is the first filing that witness signatory is filed in the WP&L docket. So it's not been verified or corrected. So I just that just may cause a little bit of confusion. So if we could use it as a reference for questions, you can have them read in statements from the document, but to have the document put in this docket as an exhibit just gives me a little concern for those reasons. But I mean, we can see how, if it's necessary, we can think about it again. But
Yeah, let's
I'd
do
rather
that.
not put it in.
Let's take a look at it, and
Okay.
if I think it's necessary to get it in the record, then we can talk about that.
All right. And so I did want, while I put this up, the first correction that I'll be giving is that the docket number on that document's wrong. So it does reference 6630 instead of 6680. So I just want to make sure, one of the reasons why this could be a little more complicated. But okay, so I think that's the document you had sent to me. I just want to make sure that's correct.
It is, yeah. No
Okay.
wonder I was confused. Thank you.
Yeah, no worries. Okay, go ahead.
Okay, could you please turn to page 8 of the document? Mr. Singletary, in your testimony in the Wisconsin Power and Light cases, you cited several reasons.
And I'm sorry, I don't want to interrupt. Can you just have them verify this is the document that?
Oh, sure. Yeah, Mr. Singletary, we're looking at what purports to be a copy of your testimony in the Wisconsin Power and Light case filed February 3rd, 2026. Does this look like that document?
Yes.
Any more foundation needed? Sure.
No, we can move on. That's fine.
All right, page 8, please. In this direct testimony, you cited several reasons why you prefer the approach of standard tariffs to special contracts. Is that right?
Yes.
And I would just want to make sure we have those reasons in the record in this case. So at page 8, you said that standard tariffs allow for the, quote, establishment and application of fair, just, reasonable, and non-discriminatory rates to customers with similar characteristics, right?
And where is that exactly?
Yes. I believe that you're referring to lines 13 and 14 on page 8 of my as it currently exists direct in that case. Is that correct?
Yes.
Okay.
And that was a yes to my question, right?
Yes, that I did state that. Yes.
Okay. The second reason you cited also on page 8 is that standard tariffs increase transparency compared to special contracts. Is that right?
Yes.
The third reason you cited also on page 8 is that standard tariffs provide clear rules of the road for prospective customers as compared to special contracts. And I think that was a paraphrase by me, but that's the gist of your testimony. Is that correct?
Yes, it is. And if it helps in this proceeding, a lot of this discussion is maybe not word for word, but very similar to what was offered in my direct in this proceeding.
Right. And then finally on page 9, you said that standard tariffs streamline the process by which new customers may take service with the utility, correct?
Relative to individual contract rates that have to be approved by the commission, yes.
I think that's all I have.
Okay.
And we don't need it.
Yeah.
The testimony itself in the record, it's fine.
I agree. Yeah, thanks. All right. go ahead.
That's all my
That's all
questions
you have. Okay.
for Mr. Singletary. Yep.
All right. So I didn't have anyone else signed up for questions, but are there any other? Looks like Commissioner Hawkins. Can you turn your camera on, Commissioner? Okay, great. Go ahead.
Hi, Kent. Sorry again. Travel delays last night means another airport today instead of the office. So I apologize for what's likely different airports background noise today. Mr. Singletary, I had some questions on both your direct and rebuttal, but before that, I wanted to ask you a question on the redirect of witness Stasek that occurred yesterday. Were you online and listening to that?
I was, yes.
I was interested in your experience with rate making at the commission. If you're in agreement with Mr. Stasek that the commission has the jurisdiction to assign transmission costs between different customer classes or different customers after they've been assigned costs from MISO or A2C.
I would agree that the Wisconsin Commission, as I'm going to speak generally, state commissions have the rate making authority to assign costs to classes and then to rates at the retail level, based off of the total and specific costs that the utility incurs and is included in the revenue requirement that the commission authorizes.
Thank you. And yesterday we were also talking about ways that transmission costs could be directly assigned to market participants within MISO. And is it your understanding that the applicant is a market participant within MISO?
The applicant, Wisconsin Electric, is a sorry, it's early for me for whatever reason. Yes, WEPCO is a market participant.
So then if costs could be directly assigned to the applicant, the commission would have the authority to further assign those costs to the appropriate customers. Is that your understanding?
Yes, the commission can, through its retail rate making authority, assign the costs in any way it deems just and reasonable. And if the costs were directly assigned to WEPCO, then it would be included in the cost that the commission has the authority to assign in its retail rates.
Thank you. I think I want to move now to your direct testimony, page 26, which is related to the applicant's analysis of the direct assignment of costs.
I'm sorry, the direct
And
what if?
Assignment of costs.
Thank you.
And I don't have a specific line for you, but you raised concerns that not all costs to serve the customer were included in the direct assignment comparison that the applicant did in this analysis. Could you elaborate on what those other costs might be?
Yes. So as I view the transmission cost issue, there's sort of two important, I'll call them bucket of costs to consider. There's what a lot of focus has been on, which is sort of the directly assignable or directly attributable transmission costs, meaning costs that, but for the need to serve the very large customers, would not be incurred either at all or in a way that they are or plan to be incurred. So sort of those directly attributable costs, the sort of but for costs. But you know, as we all know, the transmission grid isn't a series of direct connect pipes. It's, you know, it is an interconnected system. And so in order to serve the VLCs, they need not only those directly assignable costs or those directly attributable costs, but they also need the rest of the transmission system. And so the direct assignment, what wasn't clear to me at the time was whether or not that looked just at sort of those directly attributable costs, whether it looked at that plus some determination of sort of total system costs other than those directly assignable costs, and you know, how that was sort of handled. And that was why I expressed some concern about not really about being unsure whether or not it really captured all the costs associated with serving the VLCs. Did we lose Commissioner Hawkins?
No, he put his
He's
hand
there.
down.
Okay.
Although I'm not hearing him.
He's there.
Sorry, I was on mute to avoid the airport noise and
I
forgot
see.
about it. So I think you answered my question, but then your understanding of what was included in that direct assignment was there was nothing beyond the but-for transmission. Is that correct?
That appeared to be, to me, based off of the figures that were shown, what the direct assignment was intended to capture was those sort of but-for directly attributable costs, and may not have. And I didn't think it captured some of the more like general like transmission costs.
Got it. I will move on to your rebuttal testimony now, page 14, where we're talking about your understanding of the issue with financing of transmission and the CLIP in particular. I'm wondering if you raise this concern of a temporal cost shift caused by how transmission infrastructure is financed by ATC. And I'm wondering if you have a sense of how big these financing cost shifts might be, this temporal cost shift that you're speaking of here in your rebuttal.
Unfortunately, I don't.
Okay, and then later on, I think it's on 15, you recommend that Wisconsin customers might rely upon ATC to do the right thing to transition how transmission is financed. And is it your understanding that ATC has the unilateral ability to do that, whatever you meant by do the right thing there?
If I understand your question correctly, the sentiment I was trying to express here is that, you know, as I sort of noted in here in my rebuttal, and I think consistent with the discussion yesterday that I believe you were present for some of, that there would need to be some modifications to potentially to address some of these issues as it relates to FERC jurisdictional rates. And what I meant to basically what I was suggesting here is that I'm not an attorney, so I can't speak to the Wisconsin Commission's authority over ATC insofar as requiring it to file rates. Obviously, the commission doesn't have authority over the rates themselves, but that in the end, that yes, ATC, if it recognized that there was an issue with, say, this financing issue or any other cost allocation issue, could on its own, you know, if you want to use the term unilaterally, then yes, it could make a filing before FERC or the other relevant entities to modify its rates to adjust for whatever issue needed to be solved.
Thank you. And I believe you suggested that ATC could change that method. And is it your understanding that they could do that simply for a subset of transmission projects and not do that for all of its transmission projects?
My general understanding, and I want to make certain I don't get too far out in front of my skis on some of the sort of wholesale market and transmission and FERC rate issues, but my understanding of, if we're talking specifically about this construction financing issues, is that it is fairly common practice amongst transmission operators, at least within MISO, that that AFUDC rather than current return on QUIP is applied, and for those transmission operators, they will sometimes have an exception to do QUIP instead of their standard practice of AFUDC. And so and my understanding is that the opposite is also true or possible, in that if a transmission owner or transmission operator's standard practice is to do current return on QUIP, that it could do AFUDC for some subset of its projects. I want to be careful that I'm not opining specifically on what that pathway looks like, because that gets a little outside of my specific knowledge. But my understanding is that flexibility happens in some fashion.
Thank you. And can you explain how the AFUDC financing would reduce the temporal cost shift issue that you raised?
So under a current return on QUIP, the revenue requirement of the financing is passed through the transmission rates to the transmission customers before the underlying capital assets are placed into service, in broad brushstrokes. Whereas under a conventional AFUDC approach, those financing costs are accounted for and then rolled into revenue requirement of the transmission operator at the time that the assets are placed into service. And so what that means is that customers don't start paying for the costs inclusive of these financing costs until they are benefiting from that plant, those facilities being placed in service. Whereas the temporal issue arises because customers begin paying these financing costs before the poles and wires are in service and are benefiting those customers.
Thank you. And given that description of the issue, is it your sense that this issue is more pronounced when loads the size of VLCs are being connected to the grid, as opposed to just maybe normal load growth or regular transmission expansion?
I think my sense is there's two aspects of it that I think would bear considering. One is the size, right? And I will admit that the size or dollar value or cost of those directly attributable investments for VLCs, or really any transmission investments needed to facilitate VLC's service, might vary from facility to facility. But relative to what the transmission system needs to take on, compared to, say, a conventional large customer, which is, at least compared to the facilities or the projects we're talking about now with Microsoft and Vantage, or an order of magnitude or more smaller, that there's sort of a magnitude issue with those costs. And then there's also the fact that, again, there's sort of that but-for issue, that but for those customers, those relatively large costs would not be incurred. And so while this timing issue does exist for ATC currently, in a general sense, those transmission investments, setting aside very large things like, the LRTPs, because those have a different sort of cost allocation handling. The usual transmission investment is meant to accommodate sort of the total, I'll call it organic growth of diverse load throughout the transmission operator's footprint, and isn't localized to one particular customer or small number of customers. And so this sort of temporal mismatch sort of is amplified by both the size of the investments for we'll call it a VLC, as well as sort of the concentration of it being, but for one customer.
Okay, thank you. I don't have any further questions.
All right, thanks, Commissioner. Any other cross from parties? Commission staff, any questions? No? Okay. Well, with the Singletary, I did have a couple for you. First of all, I was curious. I know you'd made some references to the CP1 tariff in your testimony, and I think it was page 8. Starting on 8, from lines 8 to 14, you're talking about without the VLC tariffs, the customer at the demand and voltage that's being requested would default under the CP1 tariff. And I just wondered, when you made that statement, were you considering the magnitude of the demand when you defined the CP1 tariff as a default?
Yes, I was looking at the peak demands as we understand them today of the current prospective VLC customers, as well as I believe there was some reference or some mention I had seen somewhere in a discovery response or somewhere along the way related to voltage level. And so it was primarily demand, but I also cross-checked against things like a service voltage level and things like that.
So with a demand, particularly demand level being so high compared to what's currently, as far as we know, everyone's talking about this being extraordinarily high demand level. With that understood, you still feel that the CP1 tariff is appropriate to apply to this application, or should there be? I'm sorry. Is it appropriate to apply to this demand level that's being sought, or should there be some other? Let me get back to this. So let me ask you this. You did mention other tariffs and how the VLC customer could not it would not be appropriate for them to take service off of. I think there's different general service tariffs and other ones that had caps on demand. Do you remember that?
I do.
Okay. So I'm wondering, when you went through that list, did you consider what we were looking at yesterday was special service under WEPCO's tariff? And I can put that on the screen here. It's volume 17, 102.4. Did you consider that tariff when you were thinking about which tariffs may or may not be appropriate for VLC service?
Would you be able to scroll up to the top of that sheet,
Yeah.
please?
Oh, yeah, sure.
No. Well, maybe, I guess, backing up. One, I just want to clarify that my testimony is not that I believe that the application of the CP1 tariff would be appropriate. My discussion here was a little more of a sort of, I guess, factual exercise to sort of to establish, at least from my vantage point, that absent the tariff, what would the customer take service under? So I'm not saying that it's appropriate for the VLCs to take service under that, but merely given the current offerings, that's what they would fall under.
And when you say that, you mean CP1?
CP1, correct, yes. And then some of the other discussions, I think you accurately characterize it. There are various either availability criteria that would preclude at least the two VLCs we're talking about today from taking service under them. Or would be a mismatch with the type of service that the VLCs are seeking, which is generally speaking, high load factor firm service. The special service issue here, I believe this is from the utility service rules.
Correct.
I'm trying to go from memory of the utilities rate book here and from the discussion yesterday, is not, I don't believe, meant to represent a rate offering alternative, but more the rules associated with providing services. And again, here, I believe Mr. Stasek provided a useful distinction here, and that service here is the interconnection to the utility. The services that are special in the sense that they are outside of the range that would be typically offered to customers based off of their service size per the rules of the individual rate schedules in the tariff book. So I believe, again, my memory, I have, 6 IOUs rate books rattling around in my head, but this is my recollection and understanding both from the discussion yesterday and as to what this applies to. And so insofar as your question of whether or not I considered this, no, because this is not, at least from my perspective, a rate offering. This just would describe if, I believe as Mr. Stasek discussed, if a customer needed, say, a higher service voltage or wanted more metering points than the company would normally offer, or something beyond the normal service interconnection offerings or types or design that they normally apply. So
Okay.
no, I didn't think of this.
Okay, so just so I understand, so it's if a customer falls under a rate class, but then somehow needs something other than what's in the rate design tariff that's designed for that rate class, something that deviates but doesn't put them outside of that rate class, you would apply the special services tariff to that special request.
I believe the special service rule here would apply, and in general terms, in the way that you described. Yes.
Okay. Thanks for clarifying that. And thank you for clarifying your testimony that you gave, what's in your direct as well. I think that's useful. It's more of a, you're speaking more in terms of a technical aspects of the application of the rate classes that are currently offered. All right, great, thanks. That's all I have. So there's no other cross, any redirect?
No redirect. Thank you.
All right, thanks very much. You're excused.
So I think Mr. Juster had a conflict. We're just trying to figure out who's getting in the chair next.
I'm sorry, who's talking?
Yeah, let's go off the
This
record.
is Joe Wilson. I'm sorry.
Yeah, let's go off the record. So, yeah, I think there is now, we did hit the time where, although I thought I saw witness Jester here, but I believe this is the time frame where he's not available. That's correct. Yeah. So we were going to skip him at this point, that witness at this point, and move to, if we can take Bernard next.
And Judge, it's Krista Westerberg. While he's taking the stand, I can answer the question about the data request we were looking for.
Okay.
Or about the other users.
Sure. Yeah. Go ahead.
Are you still off?
Well, doesn't really. I mean, we're just point out which one it is. That's fine. We can do that off the record. Yeah.
I'm gonna run.
Oh yeah. Go ahead. Go ahead.
Okay. Yeah. It was.
She's getting more savvy about taking opportunities when she can. Yeah. Go ahead. Sorry.
Sure. It was it was the WEPCO's response to 5 Walnut Way DR8, and then there was an attachment, and those are PSC reference number 574116 and 574117. And I was a little slow on the trigger providing that before my I'm having some trouble with Zoom kind of freezing on me, so I might disconnect and try to reconnect.
Okay, I'll look out for you then.
Okay, thank you.
So I just want to be clear though, I think originally mentioned it was a Clean Wisconsin discovery request. Was it Walnut Way instead, or is there another one out there?
We made a request, Your Honor, in 2CW1 for an anonymized list of maximum annual demands for current customers with aggregate demand over 20 megawatts, annual demand over 20 megawatts, and received only objections to that request.
Oh, okay. Should have requested a motion to compel on that one. Okay, but we do have some that. So the information for is Attorney Westerberg still there?
Yeah.
The Walnut Way information does cover that. What customers have high demand currently?
Yeah, the request was to identify the amount of annual energy consumed by WEPCO's 5 largest de-identified customers for each of the last 5 years.
And it's by customer?
Yes.
It is.
But yeah, and then I just lost my tab, but
Okay.
yeah, and then it's top 5 customers by annual sale, ranked 1 through 5 in the Excel spreadsheet
Okay.
in megawatt hours.
Okay, great.
Your Honor,
Yes.
I'm sorry, just ask. So this is not a response to customer load. It's a response to customer energy use.
I don't know. Yeah, I'm not sure.
Right. I think that's the one Mr. Stasek was referring to, I guess, is my point.
I'm sorry, the one that,
The 5 Walnut Way DR8, I think, is the one Mr. Stasek was referring to, because he mentioned a request for 5 customers, or 5 de-identified usage of 5 customers.
okay.
And that's what that
With sales and megawatt hours. Yeah, so I guess we're looking for
Your Honor, I'm sorry, this is Corey Singletary. I don't
Yeah.
mean to step in amongst the
No.
attorneys. If it's helpful, while we do need to file a revised version of it, I did offer the Walnut Way discovery response as my Exhibit 8, and it is in megawatt hours. So if that helps in terms of what's already in the record.
Well, does that answer my question or not? I guess that's
Of it being in demand?
Yeah.
No, it's in megawatt hours.
Yeah. Okay. Okay. Thanks. All right. So we'll need to swing back and get an answer to that in confidential. But thank you everyone for looking for that.
Yeah, while we're off the record,
Yeah.
I think we would stipulate that no existing customer would qualify for this tariff.
Yeah, that's not what I want to know. I just want to know what is currently the highest demand that's being served outside of the VLC customers that are taking service off of CP1. And we don't need to know the customers, but I know that people could probably figure out who the highest one is. So I totally understand that, but yeah, that's something that I want to have available for the commission to understand, like what's the current world of CP1 and what's the highest one that's being currently served.
So Mr. Stasek has pulled up that data separately, and if you want to take that next, Your Honor, he'd like to just get it out of the way, I guess.
Yeah, that's fine. We can do that. So now we have to do the tricky breakout room thingy. So have we figured out if there's anyone who shouldn't be on this, or is everyone covered under the confidentiality agreements for this information? I would assume it would be covered because everyone's in here for everything else. So,
well, I don't think we've done any confidential information yet.
Well, I thought this information would be confidential, right?
Right.
Yeah. So before we go into the breakout room, just want to make sure and I'm not going to assign anyone. I think people just need to join. So at least that'll be the first step. So join in if you are covered. If you think your confidentiality covers this information, and then I guess if the company thinks otherwise, we can figure that out.
Nobody on the Zoom right now stands out to me as somebody that hasn't.
Yeah, I thought so. Yeah. Okay.
Your Honor, could I clarify? This is confidential and not DCI confidential. There actually is a distinction on our side.
Well, yes, of course. Well, my intention is to get information about current customers other than the VLC customers or the DCI customers. And no customer names are necessary, just the demand, maximum demand requested under their current electric service agreements.
That's our understanding too, that it wouldn't be DCI trade secret.
Okay.
I mean,
So let's do a big breakout room, and I think I'm gonna set it as assigned manually. I'm going to set it as, I don't have it. I'm just gonna set it as assigned automatically, since I think you'll all be in the room as soon as I create it. So just expect that, and then the live stream will just go blank because it won't pick up what's in the breakout room. Here we go.
Okay.
All right, I think this will do it. think we're all muted. So where's Debbie? There you go. All right. So yeah, can you hear me?
Mhm.
Okay. So we're back in the public session. So just so people know, the transcript's going to be a little tricky at this point. That's okay. But you'll see, and I'll discuss this with you, Debbie, offline. But just so people have an idea of, we'll get a confidential public version of this, a confidential version, and a DCI trade secret confidential transcript. And once there is a process by which parties can continue that request, that documents, that the transcript be retained confidentially. So you'll need to follow that process. If you fail to do so, I'll include these sessions, the confidential sessions, in the public transcript. So you could let me know, or you could just by default let that fall away. Let your claim for confidentiality fall away, and I'll make. Well, it's more complicated here. So I'm gonna need Vantage to tell me whether the DCI section of the transcript should remain DCI confidential, and we'll need WEPCO to assert that the regular confidential and the DCI, whatever it feels like, can remain confidential. That's part of the process, but we'll have to have a breakout of those sections so that we send the draft transcript to the right people. So just so you know, you'll expect to see it coming in that format. All right. So I think, is there anything else for, along my line of questioning, anything else for witness Stasek?
Your Honor, I have two very brief questions, if you don't mind.
Yeah, please.
Mr. Stasek, does the CP1 tariff have a cap on demand?
No, it does not.
Has the commission ever considered or just made any indication that it would cap the demand on the CP1 tariff before?
None that I'm aware of since I've been in my role.
Thank you, Mr. Stasek.
Okay, great. Thanks. You're excused. All right. So, witness Bernhardt. So we can take a witness Bernhardt now. I see you there.
Thank you, Your Honor. Whenever you're ready.
Yeah, I will be there in just a second. Where is
You see me? Yep.
I can see witness Bernhardt and
Right here. Good morning, Your Honor.
Are you two together?
No.
No, where's? Oh, there you are. Okay.
Several thousand miles away.
Yes. All right. Well, I'm sorry. Should have done that off the record, but let's get off the record just until I get this settled.
You were.
Okay. You took care of me. Thanks. You got my back. I appreciate it.
But I don't know who the person was that was.
Yeah. So you see the box for Richard Heineman. That's the attorney for Cloverleaf, and then the witness Bernhardt is there. Yeah. Okay. All right. Looks like we're good to go.
And it's hard to hear Mr. Heineman. I don't know why, but it was just hard. I wasn't listening to what you were saying, but I was hearing it, and it sounded muffled.
Can you hear me now? Is that better?
Sounds okay. It's quiet, but yeah.
I'll try to speak louder.
Okay. Excellent. Thanks. All right, witness Bernhardt, I'll swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead.
Good morning, Mr. Bernhardt. My name's Attorney Eduardo Castro. I represent one of the interveners, Walnut Way.
Sorry. Sorry. We're going to have
we haven't.
My apologies. I'm sorry.
That's okay.
No problem.
That's okay.
No problem. We'll get to you. I'm excited.
Yeah.
Yeah, we have a little bit of work to do first. Good morning, Mr. Bernhardt. Richard Heineman, as you know. Can you please state your name and spell your last name for the record?
Yes. My name is Noor Bernhardt, and Noor is spelled N-U-R and pronounced N-O-R.
And your last name?
B-E-R-N-H-A-R-D-T.
Thank you. Did you prepare and cause to be filed rebuttal testimony in this case?
I did prepare the testimony in the case. Yep.
And are the answers you provided in that testimony true and correct to the best of your knowledge?
Yes.
Do you have any corrections or clarifications to your rebuttal testimony?
I do not.
And if I were to ask you the same questions in your rebuttal testimony today, would your answers be the same?
They would.
And do you have any sir rebuttal testimony you'd like to make in response to the sir rebuttal testimony that was submitted earlier this week?
Yes, I do have some additional comments I'd like to make.
So now would be a good time. Why don't we just have you go ahead and proceed? I believe the first sir rebuttal testimony that you're interested in responding to is that of Wisconsin Electric witness Stasek, correct?
Yes, but before I did that, I just want to clarify for the record that I am representing myself and Cloverleaf Infrastructure in this proceeding and not Microsoft. So there could be some confusion considering my former role for Microsoft. Just want to clarify.
Thank you. Go ahead.
Great. So I reviewed the sir rebuttal testimony of Wisconsin Electric witness Stasek. Mr. Stasek indicates in his testimony that the very large customers, including Cloverleaf, are committed to paying their fair share of the generation costs necessary to serve the load and utility service territory. He suggests that if it turns out that actual energy-related and ancillary market revenue for the capacity-only resources do not cover the share of the revenue requirements assigned to the non-VLC participants, that the VLCs would agree to modify the allocation assigned to such customer. I would like to affirm that statement on behalf of Cloverleaf. I would also like to express my support on behalf of Cloverleaf for the mechanism Mr. Stasek proposes to address that issue. Specifically, I support the proposal Mr. Stasek describes on pages 6 and 7 of his sir rebuttal testimony.
Thank you. Do you have any additional comments you'd like to make with respect to other sir rebuttal testimony?
Yes. Clean Wisconsin witness Jester filed sir rebuttal testimony in which he references my openness to modifying the 500 megawatt threshold for VRC tariff eligibility and suggests that my testimony on how the threshold keeps out a riffraff does not make sense. I do support Mr. Stasek's proposal to open the VRC bespoke resource tariffs to customers at the 250 megawatt threshold because I think it's important that VLCs be willing to stand by their investments in ways that insulate the non-VLC customers from the risks of those investments. I believe the proposal accomplishes that and that there should be a high bar for tariff eligibility to ensure there is sufficient capital to support those investments.
Does that conclude your sir rebuttal comments, Mr. Bernhardt?
Yes.
Okay, the witness is now available for cross-examination.
All right, thank you. We did have Walnut Way signed up, so I'm going to ask you first. Oh, I'm sorry, we did have Commissioner, Hawkins. We'll take you first, Commissioner. Go ahead.
Thank you, Your Honor. I had a question on your rebuttal testimony on page 7. The lines 1 and 2 of page 7 state that once the interconnection facilities and transmission system upgrades enter into service, cost recovery falls under the FERC-approved MISO tariff. Is it your understanding that cost recovery doesn't occur until a transmission system upgrade enters into service?
I think I was referring to when does the customer start getting charged for the resource, and they would not, under the current tariff structure, start paying for utilization of that infrastructure until their facility is up and running. But the risk that you run into in this scenario is what if they start the process to develop an interconnection facility, but change tact or change direction or the business changes. So we're trying to address with that is the need for a payment and cancellation agreement to prevent costs from being transferred to ATC's other customers that did not request the interconnection. So from the point of let's do business to it's operational, you're getting charged in rates and you're consuming energy at the site. There's a payment cancellation agreement that's a binding financial commitment to the utility to pay for that. Does that answer your question?
It does in part. So you are then aware that transmission costs are incurred prior to the facilities entering service?
Yes, these
by other customers. Sorry.
Yes, I mean, currently there's a significant amount of upgrades planned across the ATC system, as in the long-term regional plan upgrades in package 1 and 2, and then I think they're under what's called the MTEP program. Those costs are being actually transferred across the MISO service territory, including consumers outside of the MISO Zone 2. So it's they're just because you're going to connect in the future and they're building the infrastructure doesn't mean you're paying for it. It's this giant system of interconnected networks.
I'm sorry, I wasn't clear. I was referring to the facilities to directly interconnect a VLC.
Oh, so actually, you mean the interconnection facilities, not the transmission network? Is that what you're referring to, Commissioner?
Correct.
Okay. For the interconnection facilities, those would be covered under the payment and cancellation agreement with the utility itself. So in the case of Cloverleaf, for one of our projects, we signed a payment and cancellation agreement that broke out the costs for interconnection and then the estimated costs for the system upgrades on the broader transmission network. So in relationship just to the interconnection costs, that'd be covered under your you're covering there is the span from their 345 interconnection to the switchgear and the transformation required, if that's going to be built by ATC, and then also the distribution side of that, if it's going to be built, owned and operated by We Energies. So those costs are broken out and separate from the MISO tariff.
I'm not asking about cancellation of projects. I'm just asking about when costs are incurred and by what customers.
Well, so I guess maybe this is my lack of understanding of when ATC recognizes those costs. Is it as they're incurred or when the facility enters into operation? I think that's a question better directed towards WEPCO Wisconsin Energy or ATC.
Okay, and that's why I was focused on those first two lines of your rebuttal there, to see if that was still your understanding or if that perhaps is incorrect.
Yeah, I mean, I think the challenge that we ran into is in our current structure, ATC is not, they don't have the ability to directly assign those costs and allow consumers to contribute capital. So one way we got around this was by negotiating where the point of demarcation is within the substation. So a large energy user could say, hey, I will cover the switchgear and the transformation on the low side, or from the point of interconnection. You see that in some potential agreements.
And you said do not allow, so customers would be barred from making contributions in aid of construction by ATC?
Or what they could do is a customer could build the infrastructure and then assign it over to ATC in the future. So there's different ways to contemplate it, but I think what wouldn't work is if ATC is take on huge amount of cost to then build out facility. In particular, we ran into this challenge because of what had happened previously with other large industrial projects within Wisconsin. So we were trying to maintain our social license to operate and move quickly, and that enabled us to work with ATC on some of the project. But I guess Yeah, that's about all I can say.
All right, thank you. That's all I have.
All right, thanks, Commissioner. So Walnut Way, you're next.
Good morning, Mr. Bernhardt. My apologies earlier for jumping the gun a little bit here, but just have a couple follow-up questions for you. From February 2016 to June 2024, you worked at Microsoft, correct?
Yeah, that's correct. But again, I don't represent them as proceeding, and I can speak on background, my own experience, but I do not represent Microsoft.
Yep, and just wanted to establish when you were there. And from June 2024 to present day, you work at Cloverleaf, correct?
That's correct. Oh, July 24.
July 2024. Okay. In your rebuttal testimony, I don't know if you have it in front of you, but Judge Newmark, we could go up to page 1. I'm looking at line 11, and it says your testimony states, quote, "I have a deep and long-standing familiarity with the tariffs at issue in this proceeding and was involved in their formation in my previous role at Microsoft." Did I read that correctly?
Yes.
So in both your roles at Microsoft and Cloverleaf, you've been working on their behalf in the formation of these proposed tariffs with the applicant, correct?
Yes, but again, it's definitely a three-party negotiation. You have the applicant, the customer, and then also the commission. At each step in the process, the commission will approve different parts of the transmission interconnection, the generation resources through the CPCN and other building dockets.
So I want to talk about your time with Microsoft. And when Microsoft and the applicant were negotiating these tariffs, do you recall if the applicant ever proposed that VLC load demand could be met in ways other than creating utility-owned generation assets?
Yes, certainly they were open to it, but wasn't right for the demands of the large energy users. They were definitely open to considering options, and I think new customers continue to ask and evaluate if it makes sense for their business.
So the utility was open to non-company-owned generation assets to meet demand?
I don't think we got that deep into the woods on that issue because it wasn't right for that application or that location.
And whose opinion was it? Was it the utilities or the Microsofts that other non-utility owned generation assets were not viable?
Your Honor, I'm gonna.
Thank you.
I'm
Yes.
gonna object here. I don't think that Mr. Bernhardt can speak to the opinion of Microsoft during that time.
And this is Richard Hyndman.
Okay, hang on. Yeah, go ahead, Attorney Hyndman.
I was going to say, I'm also going to register an objection. We've covered a lot of ground in the cross-examination of Mr. Stasek yesterday pertaining to the discussions with the company. I don't see what is going to be gained and what the probative value at this point is of exploring that territory.
Okay, I disagree. I think we can proceed with this line of questioning, but I think the question, the way I heard it asked, we want to make sure that we're inquiring and seeking the direct personal knowledge of the witness. And I don't know if, as long as the questions are elucidating the witness's knowledge, not what the witness might have thought WEPCO thought, I think that's not appropriate. But so just be careful with those questions. And yeah, I think that's all I'm going to say at this point. But another thing, Attorney Castro, is there any way to adjust your camera so we can see your face more fully? I think that would help the court reporter. Okay, excellent, thanks. All right, so why don't you? So I'm gonna grant the objection for the reasons I gave, and just if you could clarify your question.
Certainly. Mr. Bernhardt, during those negotiations, do you recall which party disagreed that, or sorry, let me rephrase. Mr. Bernhardt, do you recall during those negotiations which party took the position that the only way to meet VLC demand would be with utility-owned generation assets?
Yeah. I can tell you, I can speak in generalities about the industry and the approach. And I think I can provide you a good answer, Attorney Castro. And so feel free to ask a follow-up question. But
well, I'm sorry. I think the question was, what's your personal knowledge of the negotiations? That's
it was deemed not fit for service to meet the demands of the large energy user. So a on-site generation resource would not be sufficient to meet the demand on the timeline requested.
Which party took that position?
The customer gets to the customer. So it's mutual. So it'd be like mutual agreement, but it was the customer deciding this wasn't right for this application and this time frame and the approach. These customers are selling reliability, and if you have like an on-site resource, you're losing all the reliability built into the transmission network and redundant systems and redundant generation resources. So you don't want to put yourself in a bind where you have a single point of failure. It doesn't mean that that's a one size fits all solution. You do run into some customers who think it matches their needs. So it just depends.
So I think the question was also who came to the table. Did anyone come to the table with the idea that the VLCs could bring their own generation to serve the demand? Was that something that was offered in the negotiation?
I wouldn't say it was discussed and evaluated. I think there was a openness and willingness to engage in discussions and analysis on both sides. And I think to the utilities' credit, there was what can we do to turn this campus into something that would be right for Microsoft at the time? I mean, the whole community, all the stakeholders involved were very open to discussion.
I don't want to take over the cross, so go ahead. Sorry.
So during the negotiations between Microsoft and the applicant, were there any aspects to the tariff that were proposed by Microsoft but rejected by the applicant?
Sure. There's a lot to learn about Wisconsin energy policy and law and how that can fit together. One example, which we actually discussed with Walnut Way, is how to create a community benefit program where you could, large energy users could pay additional costs.
I'm sorry, what kind of users?
Oh, how large energy consumers,
Thank
sorry.
you.
So we can just call them VLC participants, could contribute. And we were directed towards Act 141, which is an opportunity to contribute to a general fund to help with energy efficiency. So one of the programs that we actually discussed with Walnut Way, this would be several meetings with them as representatives of Microsoft, was how we could increase that program. But unfortunately, it's by legislative mandate and not something the utility can really drive forward without getting that legislative support.
So in your capacity with Cloverleaf, are you interested or committed to doing some sort of community benefit fund?
Oh, certainly. Oh, yeah.
Wait, sir, you need to let him finish the whole question before you talk. I'm sorry, Judge.
Oh, sorry. It's a really cool question, though. I think it's important. Sorry, Debbie.
Did you want to
Okay, so-
finish the question?
No, I think the we
the problem is the record won't reflect
Yeah.
this correctly.
So-
So,
I can restate the question. So, in your capacity with Cloverleaf, is Cloverleaf interested in establishing a community benefit type fund?
Yes. And one approach that we found has worked in other communities is partnering with, utility to where they could provide a block grant to the local city council or other representatives that are directly, in proximity to the facility, and they can use those funds to help offset large, energy costs. One of the concerns that I had when going into this process was 50% of school-age children are on free or reduced lunch in Wisconsin. And so there's a real issue with energy poverty into the winter months. And so we were thinking a lot about how can we use some of these funds to work on that. I don't know where the conversations went with Walnut and Microsoft, but there was a lot of discussion about how we could craft a program around that. So, I think definitely worth having a follow-up conversation with those stakeholders.
So, in your capacity with Cloverleaf, did Cloverleaf make any proposed changes or propose any changes to the tariffs?
When Cloverleaf first became involved in the Port Washington project, we certainly took a review of the tariff, and I don't recall if we had any major changes. Like we had some discussions and may have recommended some changes, but at that point there were other stakeholders involved, and no, I don't believe we had many changes at that point.
What were the changes that Cloverleaf recommended?
I don't actually remember. I think they were very minor. I left Microsoft, and it was 9 months after I left before the tariff was filed. So I am, I'm not privy to the conversations that took place after I left, but 9 months is a long time.
Were any of the changes that Cloverleaf proposed adopted or reflected in the proposed tariffs?
I don't believe so.
Does Cloverleaf still have involvement in the Port Washington project?
Certainly, we continue to provide guidance and insight, but I am not a party to any commercial negotiations or any sort of discussions that the current customer and the utility has. And that, that's why I wasn't on that last breakout session, because I'm not subject to all the confidential information and other things.
Does Cloverleaf have future plans for development in WEPCO service territory?
We continue to explore opportunities. We've been transparent about this. One of the things that we value is transparency and speaking directly with community stakeholders and mayors. And you can read in the news, if you were to Google Cloverleaf, first article will pop up is about Wrightstown, where we met with the mayor, did not ask him to sign NDA. And unfortunately, he took that as a opportunity to, voice concerns in a public forum about data center development with us as the bogeyman. But that's the risk you take when you're operating with transparent approaches.
So there's no current future plans for data center development right now in the WEPCO service territory?
We continue to evaluate opportunities as they come up and talk to potential landowners and communities. Our approach to business is to partner with communities and utilities that are looking to support economic growth and development in their service territory. And one of the really cool opportunities about Wisconsin is you have the 345 kV network that was built out to serve large industrial loads. Unfortunately, those large industrial loads have left. And so you have a significant amount of capacity on the network to support new growth. So, I think we continue to evaluate it. I think it's, you're seeing a real transition in the economic story of Wisconsin, where new jobs are being created in a growth industry like data center development and construction, and it's having a really good opportunity. I definitely wouldn't be the expert to talk to you about the economic story, but I think there's a lot of good stories out there in the media right now.
So just one last question for you. I'm looking at your testimony, and I'm looking at line 13, and it says Cloverleaf is broadly supportive of the VLC tariff and BRT, Bespoke Resource Tariff. Are there aspects of the tariff that Cloverleaf doesn't support?
Nothing comes to mind. I think just with any negotiation or any tariff design, it's a science and an art. The commission has to weigh the risks and benefits, and you're never going to get everything you want or need, and you have to compromise, because this is a 30-year contractual commitment where you're going to be operating your facility there, and you're going to go through a couple cycles of servers within that facility, and it's going to be a long-term asset for these customers.
I don't have any further questions.
All right. So any other cross?
I have a few questions.
All right. Sit you here, and go ahead, just introduce yourself to the witness and proceed.
Sure. Good morning. My name is Priyam Desai. I am an attorney with Sierra Club, and I have just a couple of follow-up questions for you. You testified that you support the modification of the capacity-only framework in the way that WEPCO witness Stasek recommended in his rebuttal testimony. Is that correct?
That's correct.
Is it your opinion that the capacity-only framework prior to the modifications, as suggested by witness Stasek, provide a benefit to VLC customers?
Is your question, does it benefit only VLC customers, or does it benefit all customers?
Only VLC customers.
I don't believe it only benefits VLC customers. I think it provides benefits to all customers.
Okay. Is it your opinion that the capacity-only framework, as modified by witness Stasek, provides a benefit to VLC customers? Only
I believe
VLC
it provides
customers.
a benefit to all customers,
I'm sorry.
inclusive
I'm
of
sorry. Could you
VLC customers.
start that answer again? Because there was an overlap. Could you start the answer again?
I think Attorney Desai asked, does it provide the benefits to VLC customers? And my response was, I think it provides benefits to all customers, inclusive of VLC customers.
Okay. Would Cloverleaf object if WEPCO removed the capacity-only framework and required that all resources become full benefits resources?
Again, this is about what works for all Wisconsinites and how all energy consumers can benefit. If the commission deemed that was a necessary change to gain approval of the tariff, we would support that. But I would also just point out that the capacity requirements to meet MISO's capacity, they have to. We just have to show that they have the accredited capacity to meet new load. And what you're doing with the capacity-only assets is you're shifting the capital requirements to build out the assets onto the VLCs, and then there's a shared benefit to all customers, because those assets only operate during the highest cost, lowest renewable energy generation periods of the year, because the rest of the time they're pushed out of the generation stack, and they're displacing older legacy coal and gas in the generation supply stack, and they're operated economically.
Okay, so if the commission required that resources become full benefits resources, Cloverleaf would not oppose that?
No, we'd certainly provide testimony, and I reserve the right to respond when the proposal is brought forward and to review it. But at the end of the day, it's like what what really can, create the right balance of risk and value to all ratepayers.
Okay. My next question is, isn't it true that of the bespoke resources that have been publicly identified, that the gas resources are being subscribed to as capacity only, and the renewable resources, that is solar storage, wind, are being subscribed to as full benefits? Is that right?
Yeah, I would, I don't know. I think I would recommend asking WEPCO's witness Stasic that question. I haven't kept up with all the, we're up to 1,200 documents in the docket. Maybe you help me if you could reference the actual
Sure.
part of the testimony you're referring to.
Have you reviewed Dr. Fisher's testimony, Sierra Club witness Dr. Fisher's testimony?
No, I have not. I've not had a chance to read that one.
Okay. Well, let me pull up a table that comes directly from some of the information that's in the docket. Could we pull up direct Fisher at page 29, please?
Okay.
Okay. Do you see table JIF-1, Mr. Bernhardt?
I do.
And would you agree that in this table, the two gas resources, Foundry Ridge and Red Oak Ridge, are being described as CO, capacity only, and the remainder of the resources are being described as FB, full benefits?
I think, yeah, that seems reasonable.
Okay. Do you have an opinion as to why a VLC would elect to take gas resources as capacity only as opposed to full benefits?
Yeah, I mean, this was a recommendation from stakeholders early on in the negotiation process, which is how to create a mutually beneficial energy strategy that wouldn't just allow the VLC customers to gain all the benefits from new efficient generation, but allow other consumers within Wisconsin to also get some value from it. The value is the generation output during periods of high demand where wind and solar is not sufficient to meet the energy demand of customers in MISO Zone 2. In that case, you are importing power from other parts of the MISO system at a higher cost, and you're paying a wheeling charge to bring that into the system. You're also subject to flow constraints and other challenges. So, this was a way that the VLCs thought they were helping out all consumers in Wisconsin to lower energy rates and help make that fuel shift from 50% coal towards a more balanced energy mix in line with Governor Evers' decarbonization goals.
Okay, great. Thank you. I have no further questions.
Okay, I just had a quick follow-up from what you just said, Witness Bernhardt. You just mentioned the VLCs were interested in meeting the goals that you just stated. Is this the way this chart establishes which units are being capacity only versus full benefits? Was that something that in your negotiations was proposed by the VLCs?
Again, I don't remember who brought the original proposal forward, and that was back in fall 2022 into early 23. So I'm not, but I think it was more like how could we set the tariff in a way where all consumers can benefit. At the time, the concern was what are we doing to help drive decarbonization and the fuel shift in Wisconsin? So focusing a lot on what is the MISO Zone 2 resource mix. So that'd be ATC service territory, and how the investment from large energy users could help support that transition.
And when you say we, you're meaning that as everyone, all parties to the negotiation?
That's right. Yeah.
Okay. All right. Thanks. Any other cross?
Your Honor, Commission staff has a couple of cross questions.
Okay.
Good morning, Mr. Bernhardt. Evan White's on behalf of Commission staff. I just wanted to circle back to, I guess, your Sir rebuttal that you provided in response to questions from Attorney Heineman. And you were responding to the new proposal from WEPCO witness Stasek regarding, I guess, a rebalancing of the capital split for capacity-only resources. Do you remember that?
Yes, I do remember. That was not that long ago. But...
Just wanted to orient you to the right place. So I have a question. You said that, and again, you were speaking on behalf of Cloverleaf, but I think you kind of hinted at more generally, in your opinion, VLCs are committed to pay their fair share. Do you remember saying that?
Yeah.
Could you define what is it you mean by fair share? How do you conceptualize that concept?
Yeah, that's a great question. I appreciate you asking it. There are a lot of examples of tariffs for large energy users where utilities are building new generation to supply their demand, but they're also adding that into the general rate base. And so current customers who have paid off assets over time and have a lower cost of operation and they're depreciated. So, we call that like a fleet asset. And what happens when a new large energy consumer has a significant amount of load in the system joins that area, and the utility starts building out new transmission and generation resources, is it actually puts upward pressure on all customers because now it's just part of the fleet. It's just part of the generation mix. And what it means to pay your fair share is a cost causal rate structure based on ring fencing the incremental costs that are incurred to serve the new customer. And what you see with this tariff design is a way for Wisconsin Energy to directly allocate the financial risk of building new assets, and then the cost to operate and maintain those assets when operational to a particular customer through the Bespoke resource tariff, through that subscription model that they've developed, where within the tariff there's one subscription you sign up for as a customer in the first part while it's being built, and then the second part when it's operational. And in that sense, you're not setting yourself up where a customer could ask, hey, I want 500 megawatts of new generation, but then for a while they might just use 200. In that case, all customers would have to pay for that generation resource to be built, maintained, and operated. But with this model in the Bespoke resource tariff, you're able to directly assign that cost of building that 500 megawatts directly to the consumer that is requiring it to be built, who has requested for it to be built. In this sense, it's not impossible, but difficult at this point for Wisconsin Energy then to charge other customers for the capacity that the new customer has joined. This is different than other large energy tariffs that want to just put it all into the general rate making pot and then directly assign based on utilization of different customer classes. This is a cost causal tariff.
Thank you for that explanation. That was helpful. I want to ask a couple of follow-up questions, though. So building on this premise that, as you described, fair share essentially means allocating those incremental costs or cost causation directly to the VLCs that's causing the new generation or assets to be built. Am I paraphrasing that part of your answer correctly?
Yes, you said much better than I could.
So I want to ask more about that then and how that relates to the capacity-only bespoke resource concept, because I think you would agree that the capacity-only resources are being driven by a need to meet the load forecast of the VLC customer, correct?
I would disagree. I think there's a broad shift across Wisconsin to update and decarbonize the generation fleet, and I think there were some of these projects were already pretty far along in the development process, and certainly they may have been on they may have planned for phases 1, 2, and 3 into the future, and maybe they're building it. But I think probably Wisconsin Energy would be a better customer to ask. But I mean, from I recall, there's I think it's called the Fleet Reshaping Plan, where Wisconsin is moving away from coal generation towards cleaner, more efficient natural gas resources that will operate, 20% of the year to back up the grid.
Let me rephrase this question and maybe get at what I'm getting at. So under the VLC tariff, is it your understanding that the VLC customer would have to subscribe to enough bespoke resources, whether that be capacity only or full benefits, in order to meet their load forecasts?
I don't think, so this is contemplated in there where they certainly have, so let me back up. I think the requirement as drafted and submitted is they must sign up for at least one bespoke resource. And then there's a mechanism to directly assign costs of the capacity if they have insufficient resources that they've negotiated for. And those costs are prohibitive to induce VLC customers to sign for more capacity resources.
Do you remember listening to the testimony of WEPCO witness Stasek yesterday?
Yes, there was a period where I had to step away to pick up my son and his friends from school. So I apologize if I don't remember every statement made, but
okay.
Happy to entertain a question, and feel free to fill me in where I may have missed something.
Sure. It might be helpful, Your Honor, if we could pull up rebuttal WEPCO Stasek, page 53.
Okay, I think I got it finally.
Okay. And I guess I'm looking at specifically lines 2 through 5. And I'll give you an opportunity to review that, Mr. Bernhardt. Just let me know when you're ready.
What was Stasek referring to as a condition of delivery?
Correct. What you're seeing in lines 2 through 5.
Oh, I'm sorry, Attorney Whites. That was a question. Do you know what he's referring to as? Is that condition to connect to the grid to receive service in their VLC tariff, or would be a qualification to get onto the tariff?
It would be a condition of taking service under the VLC tariff, is my understanding.
So it would be, I think what you're referring to is a change in the requirement from must have one bespoke resource agreement and a load forecast of 500 megawatts to add a third condition. Is that what you're referring to?
Well, you can see the language. So the language says subscriptions to bespoke resources. So that implies whatever the particular customer subscribes to must be sufficient to avoid long-term reliance on either fleet firm service or market firm service resources.
Yeah. I'm sorry. This makes a lot of sense. I think what you're saying is, I think there was quite a bit of discussion in rebuttal and sure rebuttal around obligation requirements as far as how much I think that the challenge is they're always going to have a mismatch between when generation is available and when the customer wants to scale. And so we were trying to address is providing customers the ability to grow their business while the utility is going through the process of acquiring and building and getting approval to build and develop new generation resources. So in a way, this becomes a way where the utility can say, hey, we have length on our CP1 resources, our fleet resources, and we can directly allocate some of that to you all, to the VLC customers, to do that. And then I guess the issue I would run into if I was the customer in this case would be, the utility doesn't always have the generation available right when you need it as a customer, but they do have length on their generation resources or can procure capacity from the market.
So I certainly understand that you can't build a generating resource overnight and just turn on the switch. So setting that all aside, is it not your understanding that, to put it quite simply, if a VLC customer has a forecasted load of 500 megawatts, that they would not need to also subscribe to 500 megawatts of capacity from Bespoke resources?
Yes, I don't believe you have to subscribe under the current tariff for an equivalent amount of Bespoke resources. And in fact, if you look at most of the agreements, they're actually subscribing to probably more than what they need because of the credited capacity value of the wind and solar and BESS resources. And there's also the marginal requirements from MISO. But I guess if your question is, should the tariff be amended to create a requirement? I think that would be a challenge.
That's not my question. Where I was going with this is the need from a planning perspective on the utility's behalf is if you have this new large load with 500 megawatts of forecasted demand, from a planning perspective and the PRA, they're required to have that 500 megawatts of capacity, correct?
Oh, yes. You mean like to do your annual resource planning with MISO so you can accept a new load onto your network?
Correct.
Yes, that's my understanding.
Okay. So the VLC is driving that need for that additional capacity, right?
Correct.
So getting back to where we kind of started all this of paying the fair share, you would agree that that is an incremental cost that's being driven exclusively by the VLC?
I'd say that, like most utilities, Wisconsin Energy has seen increasing demand for new energy exclusive from the VLC customers. I think there's load growth coming from electrification of many industries and cars and heating.
I'm specifically talking about a VLC customer with an additional 500 megawatts of demand. That's driving in a need for an additional 500 megawatts of capacity, right?
Yes, that's totally agree with you. I think they certainly should have a discussion with managers about how best to meet their capacity requirements.
And one way to meet that, which it seems like is implied by this tariff, is subscribing to sufficient bespoke resources, correct?
Yes, I think the question is, well, how do you determine that?
So with that premise in mind, you would agree that paying your fair share is paying for those incremental costs of those capacity resources to meet that load forecast, right?
Yes, I think that's very much contemplated throughout the tariff, both the VLC and bespoke resource tariff. I would agree with that.
So let's talk then about the capacity only construct, because that would assign some of those costs to non-VLC customers, right?
Oh, yes, I think it's pretty clear language there that 25% of those costs, and I think I think certainly there's been a lot of discussion about this in the docket where the 75-25 split was a suggestion early on from key staffers and other stakeholders. So key staffers at PCW, and it was also backed by different rate dockets. I had read through some dockets from 2020, between 2020 and 2022, where this was applied and discussed. And I think I continue to see a willingness to evaluate how to balance that appropriately.
So comparing that then to your premise that fair share means incremental costs, how is it fair share to allocate incremental costs that are being caused by VLC to non-participating customers? That's what I'm trying to reconcile.
I see. I think you're referring to, is there? Well, I guess it depends. Like, are you saying that once it's operational, is there a risk that customers would be obligated to pay for those resources, or does it off, or does the actual generation output offset their costs? Is there a harm to customers, I think is the question, or at least that's what we're discussing today is the statute. Is there a harm to customers of capacity only resources?
And I'm not asking about the statute or harm. I'm because
Well,
I wanted to understand
what
what
Attorney White's. I'm answering your question.
And I want to set the parameters because I was asking about your definition of fair share, which you said was incremental costs.
We are talking about a tariff in the language. I can share my perspective, but I don't represent all the VLC customers. So what I'm doing is referring back to the tariff language and how it's drafted, because that's what's in front of us today.
Okay. Did you hear the testimony yesterday from WEPCO witness Stasek about how this new modified proposal for the capacity only resource, the true up or rebalancing is based on the forecasted revenues from the particular resource? Is that your understanding?
Yes, and that was the point where he was referring to the percentages. So it's always based on the percentage. Is that did I interpret that correctly?
Well, the percentage would be the difference between the forecast and the actual results, right? Are we on the same page?
I don't know. I can't really speak to Stasek's testimony directly on that topic. I would refer back to his testimony.
Okay, well, you were agreeing that you thought it was a good thing, so I guess I'm trying to probe
yes,
your
but you're referring
understanding of
to
it.
testimony yesterday. I have not dived into the numbers, and I just want to be cautious. I don't want to lead you the wrong way and say I fully support a change to the tariff structure without fully reviewing it. That's all I'm not trying to like hide from it. I'm cautious about, because this is a big part of it.
Sure.
That's all. I'm just trying to clarify.
So let's go off the record for a second. Hang on. We're off the record. The transcript won't be clear if we talk over each other. So please, let's wait till each other is done, or if there's a need to interject, please do so. But don't talk over each other the way we've been doing. So go ahead.
And I just want to be clear, I'm not asking about any revisions. I just want to probe your understanding of the proposal and just get your opinions on it, not necessarily asking that you agree to or propose any sort of revisions. So with that...
Oh, thank you.
With that being said, is your understanding that under this modified proposal for the capacity only resources, the forecasted results in terms of the net benefit or costs would be compared to actual results, and then based upon that, there would be a rebalancing of the capital expenditure split?
That's my understanding of how it would be applied. I mean, I apologize, Attorney Whites, that I'm not as in the weeds on that particular issue as you're asking me to be. Unfortunately, I refer back to Stacy's testimony on this issue.
Okay. Your Honor, can we pull up figure 4 of that testimony that you have on the screen?
There we go. Okay, they were there.
I'm happy to follow up on this particular issue after I have a chance to review it, Attorney Whites. I just apologize. I'm not as, I guess, into that issue as you probably want me to be at this minute.
Okay. Well, I'll try just asking a question, and if you don't know, that's certainly, you can say you don't know. Yesterday there was some testimony, and I think there was a specific example from the attorney for the Wisconsin Industrial Energy Group about how there could be some years for a resource where there is a net cost forecasted to non-VLC customers. Do you recall that testimony?
I do.
Okay. How do you reconcile that with your conception of a commitment to pay the VLC's fair share, as you explained it earlier?
Yeah, I think there's going to be years where those resources will be far above, where they'll turn greater benefit back to shareholders and to customers. And there might be periods where they are underutilized and the fuel costs might make it cost prohibitive. But the reason why I brought up this, Stacy's share rebuttal and this approach that they recommend in my opening statement is because I think it's an approach that they will continue to evaluate, and they're committing to providing the information that would allow the commission staff to evaluate that and determine if that 75-25 split is right. I haven't heard anybody so far testify that has to be 75-25. And I think all parties agree there's an openness to evaluate that.
Okay. Last question. Again, comparing the proposal, which, well, let me ask a foundational question. Is it your understanding that part of this proposal and the rebalancing would apply a tolerance band where so long as the actual results in comparison to the forecasted results are within that 5% tolerance band, there would be no adjustment?
Yes, I read that proposal, and I think it's a good compromise.
So my question then is, why include a tolerance band at all? And how does this relate to, again, your definition of a commitment to pay a VLC's fair share?
Well, I can't speak to why that particular issue was recommended by Wisconsin Energy, but I could say that from my perspective as a large energy user, those costs are sometimes lagging, and you don't always know as a utility how those costs come in. You're locking up fuel costs and maintenance charges at your generation asset, and depending on how often you operate and when you operate it, there might be a mismatch. And those costs don't always come in ahead of time, and sometimes they come later. And I think again, I'm not Wisconsin Energy, so I can't speak to how they approach it, but the way I was thinking about it as a large energy consumer was that the tolerance band allows them the space to then pay attention to that and to recognize that there's a lagging cost associated with that. So that was my interpretation of that. And I'm sorry, you're right. You asked a very important question, and the question was, how do I think that this relates to paying your fair share? And I think it does relate to this issue because it's creating a generation asset within MISO Zone 2 to back up the grid during periods of high demand or during a situation like Winter Storm Uri or other winter storms. So providing capacity to all Wisconsin ratepayers that allows them to move away from coal generation towards more efficient better run assets. So that to me is the main benefit, is the capacity side of the equation. And then how costs are passed through over time is discussed in the tariff.
Thank you. I don't have any further questions.
Yeah.
All right.
Apologies, Your Honor and Attorney Whites, for talking over it. It's a fun topic, and my exuberance gets the better of me. So my apologies.
No, it's all good. I'm glad we could get have this this back and forth in a very productive manner. I did have one question for you, though, based on your answers that you gave, actually to a prior witness, prior attorney, had to deal with your statement about existing transmission capacity. If you recall that, you said that there was existing capacity on the 345 network. I wonder if you could just expand a little bit about that, considering the criteria or how this makes the region of the country possibly advantageous to the customers we're seeing in this tariff coming in on this docket.
Yeah, certainly. I think one of the largest attractions for large energy users in Wisconsin is the track record of the utilities and the system operator, American Transmission Company. ATC has been maintaining and upgrading their system throughout the past 20 years, where many system operators have not done large-scale construction or system upgrades. The 345 kV network that they operate is highly reliable and efficient, and they are a very professional group to work with. So when we first started interacting with them as Cloverleaf, we asked them to evaluate different parts of the grid, and that's how we determined what was the capacity available in the time frame that we needed it, through the system impact study process. And that's how we were able to determine, like, this is a good location being Port Washington.
Okay. And do you consider the existing capacity on the transmission system an important factor in terms of citing these VLC customers?
I think it's it's not like it's something just sitting on a shelf that you can pull off, like, oh yeah, we got 100, oh, got 200 over here. It's more that you have to go through that robust system impact study process and really determine, what is the system flows, what sort of upgrades are required to meet the requested load ramp and the time frame. And that's another area of negotiation discussion. I think it's more because you're looking over a period of time. Like, data centers are unique load in the sense that they're not like a factory where you build a factory and you flip a switch and day one it's consuming power. A data center is going to incrementally grow over time as they install the servers, and then their customers start routing internet traffic and storing data and running applications in their data center. That's what drives the demand. So you could have a 100 megawatt data center that's built out and fully allocated, but the demand could be 20 megawatts and then ramp up over time. And that's why the tariff is structured in a way where customers are paying for capacity directly, so that Wisconsin Energy isn't left holding the bag, or non-VLC participants are left paying for capacity that a 100 megawatt customer is consuming 30 megawatts is using.
But would you agree that it would be cheaper for all parties involved if a data center is located where there is excess capacity on the transmission system than if there is no excess capacity?
Yes, I would agree with that, because at that point there's a new large customer coming onto the network that would lower the overall costs for all consumers for equipment that's already been built out.
And would would specific citing have any implications to that, or is this would it matter where you cite within a transmission area?
Yeah, I think it is. I mean, transmission, generation, zoning, available land are part of the Rubik's Cube of large infrastructure development. It takes years to sort out, and I'd say certainly location matters for many factors, including transmission.
Yeah. Okay. All right. Thanks. All right. So is there any other cross based on what we've just heard here or the prior conversation? How about redirect?
Yes, Your Honor. I just have a couple of redirect questions to ask Mr. Bernhardt. Just recalling the discussion that you had with Walnut Way's attorney. I just want to make sure the record's clear on a couple of things. There were discussions about your time at Microsoft and the time when you left Microsoft. Can you just clarify when you left Microsoft?
I think that's on the record, right?
I know. I have some follow-up redirect questions. I'm just starting.
Okay. He does recall. Okay.
Yeah.
Go ahead.
June 2024. End of June.
Okay, end of June 2024, you left Microsoft. And after you left Microsoft, is it the case that discussions, negotiations continued? I think you testified to this in response to or during the cross-examination with Walnut Way's attorney. Discussions over the tariff continued with Microsoft after you had left.
Yes, my understanding that Microsoft continued to discuss. So, the team that was referenced in the exhibit last week, apparently there's a meeting in June at that point where they continue to talk and work with the utility.
Right, for some period of time. And you have no idea what took place during those discussions after you left Microsoft.
Yeah, I don't know which resources were discussed or anything.
And so you really don't know what happened between what at that point would have happened between Microsoft and WEPCO as negotiations over the tariff.
That's correct.
Right. Okay. That's all I have, Your Honor.
Okay, thanks. All right, well, thank you very much, Witness Bernhardt. You're excused.
Can I just ask one question?
Oh, yeah. Well,
and this is for Miss, is it Desai? You were you were talking about witness Stasek. Was that Mr. Stasek? I know it's just a pronunciation, but I just want to make sure there's not somebody else that I didn't hear about.
Yes, that's correct.
All right, thanks.
Okay, great.
Apologies if it was a mispronunciation.
That's okay. I just like to verify in case it's somebody else. And
all right. Okay, great. So maybe we're in need of a break. Given the pace we're going at, I think we're just going to cut this at the 15-minute break. Maybe we can give you another 15-minute break in the near future, but we want to continue on with all the witnesses we have to get through. So 15 minutes gets us back just before noon. Let's see, 11:55. Let's get back, and well, a little bit more than that, but that's fine.
Your Honor, it might be helpful if before we go on break, we identify who's coming up next, so we can all be separated.
That's perfectly
on the record.
Correct. Oh no, we're off the record, or okay. We are now. Sorry. Yeah, so we're gonna skip over. We're still continuing to skip Jester, so we want to move on to Gable Frank. Be next.
Okay, thank you, Your Honor.
We'll keep all the VLCs together. That's a good plan. All right. So let's make it 5 to noon. Get back. That's
I need it to get cold outside again and snow some more. Because I spent my 15 minutes cleaning up a floor of mud. Or teach them how to dip their paws in water or something.
Oh, it was foot traffic you're cleaning. Okay. I feel
Yeah,
better.
foot traffic and then paws, and
Yeah, that's
2 of the dogs were smart enough to stay in the snow, but the other 2 like to go wherever they can that's not snow. Not looking forward to March like most people are.
So the meow we heard earlier was not from Debbie.
Oh,
no.
not my house.
It's not in your house, yeah.
You don't even hear them when they bark, because they bark like every 20 minutes at something, and these headphones are wonderful. That to have to take a Zoom deposition next Friday at my daughter's house in Minnesota. And she's got a dog that barks at everything. And she said, don't worry. I said, don't worry about it. Nobody will hear it.
Well, I think we're ready to go. We have our witness and our witnesses.
Who's the next witness?
Should be
Mr. Gable.
Gable Frank, yeah.
That's not the same as Goebel that you were saying yesterday? Coble, forget it.
Coble,
forget
no,
it.
definitely not.
Well, the BL part.
Right. Whatever it takes to keep these names straight is going to work for me.
And I'm here, just making sure you can hear me.
Yes, thanks. I'm
Awesome.
just adjusting things here. Where am I? Okay. All right, looks like we got everything together. All right, witness Gable Frank, I'll swear you in, so raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do, thank you.
All right, go ahead.
Good afternoon, Mr. Gable Frank. Can you please state your name for the full name for the record?
Yep, my name's Isaac Gable Frank.
Thank you. And where are you employed and in what capacity?
I am the co-CEO of Gable Associates.
And have you prepared and caused to be filed in this proceeding direct testimony, rebuttal testimony, surrebuttal testimony, as well as 6 exhibits?
Subject to check on the 6, yes.
Thank you. And do you have any corrections to your testimony?
I have 1 correction to my testimony. So if you reference page 1 of my direct testimony, line 8, I'd like to strike the word accounting and replace it with the word consulting. A 4th word there on line 8.
Thank you. And aside from that correction, if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
They would.
Thank you. And Your Honor, we do have some brief certiorari rebuttal.
All right. Just let me mention we'll need just to get that corrected version filed by the deadline. Corrected version of his direct filed by the deadline.
Understood. Thank you.
All right. Yeah, go ahead with your further questions.
Thank you. Mr. Gable Frank, did you review Cub Witness Kim's surrebuttal testimony recommending a letter of credit be required for all eligible customers?
Yes.
And do you agree with Mr. Kim's recommendation?
No, I don't. So I am still of the opinion that the commission should reject that proposal. I'm not a banking expert, but I did review testimony from a number of witnesses and parties in this case related to credit ratings. And practically speaking, I looked up Microsoft's credit rating. They've been a AAA rated company for almost 2 decades, according to S&P. And I note that that's higher than many of the banks that issue letters of credit. For example, Bank of America has an S&P credit rating of A-.
Thank you. Did you see Attorney Weitz's cross-examination yesterday of Mr. Stasek?
Yes.
And Attorney Weitz asked several questions regarding the commission's ability to make changes specifically to the allocation of the capacity-only bespoke resources and the related energy service agreement. Do you recall that exchange?
Yes, I do.
So Attorney White suggested that the commission could be allowed to unilaterally make a change to either the classification or the allocation of a bespoke resource at any point during the resource agreement. Do you agree that that's a good option for this tariff?
So I'm not an attorney, so I can't speak to the legality of any of that. But as a policy matter, I don't think that would be a good idea. VLCs under these kind of structures that we're developing are signing long-term contracts. They're taking on long-term and significant costs and risks. So they should be given some level of certainty of kind of what can change and when into the future.
Thank you. So is it your position that no adjustment should be allowed to the tariff or the ESA in the future?
No, not at all. So all I'm suggesting is there should be a clear and defined process from the beginning. So everybody, including the commission, WEPCO, VLCs, and other stakeholders kind of understand the lay of the land and enter into the agreements with a full understanding of all the risks they're assuming and how they can change.
During that same exchange, Mr. Stasek described the process for seeking commission approval of capacity-only resources. Did Mr. Stasek's description of that process align with your understanding based on the language of the tariff?
Mostly, yes. So I agree with him that there's going to be these agreements that are signed. They kind of lay forth the terms for paying for a lot of the long lead time equipment and permitting and issues like that. And then the project is going to be proposed to the commission for approval after that.
So are there any areas where your understanding differs from Mr. Stasek's?
Yes, there are. So Mr. Stasek, at least my understanding of his testimony yesterday was he explained these contracts are signed before the commission seeks approval, and they would designate a project to be either capacity only or full benefits. Based on my plain reading of the tariff, I did not kind of take that same understanding of what had to be inside of those agreements that went to the commission. My read is that, there will be these bespoke resource agreements. They're going to set forth a bunch of terms. The tariff also says that customers can choose whether a resource is capacity only or full benefits, but they don't, at least in my read, explicitly speak to the timing of when an agreement, would go into place or when the designation of capacity only versus full benefits would occur.
So based on that, do you have any suggestions on a better way to address Attorney White's concern about a situation where the commission does not approve a capacity only project?
Yes, I do. So to me, it would seem very reasonable that bespoke resources be evaluated in those permitting documents as both full benefits and capacity only. So in that way, if the commission, determines that a project that was maybe offered as capacity only were not advantageous for other customers, it could be offered to VLCs as full benefits. And then after some amount of time, say 90 days or so, VLCs could elect to take it as a full benefits resource rather than kind of let it fall away on its own. It seemed that would be a much more efficient use of the process.
So the process you just described, is it your opinion that, strike that. Is it your opinion that if the capacity only designation were removed entirely, the tariff would still meet the stated goals of ensuring that a VLC would pay its fair share of costs?
Yes.
And is it your opinion that if the capacity designation were removed, the full benefits option under the tariff would still meet the policy objective of responding to the needs of VLCs making new and substantial investments in Wisconsin, as identified in Mr. Stasek's testimony?
Yes, I believe it would.
And in that case, would the tariffs also meet the other objectives Mr. Stasek described in his testimony, in his direct testimony?
I believe they would.
And so based on what you heard yesterday and some of what you may have heard earlier today, has your opinion on the capacity only option changed at all?
It hasn't. So my belief is that the capacity only option under the right circumstances can have positive benefits for non-participating customers. The commission should evaluate each one of those options for projects, when they're brought forward in their permitting decisions. And the VLC should defer to the commission on what the best option is for the state, whether that be capacity only or full benefits. But VLC should also be able to rely, on that decision for the long term, and have a good understanding and kind of know when adjustments can happen and have that all defined ahead of time instead of kind of, at any point without, notice or any information.
Thank you, Your Honor. Mr. Gable Frank is available for Frost.
All right, great. So we did have some parties signed up. My screen is jumping around here. I think it was. Not sure. Was it Sierra Club? Yeah. All right, let's take Sierra Club for cross first. And then
Sierra Club has no, oh, sorry.
Oh, go ahead. No questions?
I was just going to say no questions from Sierra Club.
Okay. How about Walnut Way?
Yes, Judge, I do have a few questions.
All right. So just introduce yourself and go ahead.
Thank you. Good afternoon, Mr. Gable Frank. My name is Krista Westerberg. I'm an attorney for Walnut Way. Can you hear me okay?
I can. Nice to meet you.
Nice to meet you as well. Thank you. As I looked at your direct and rebuttal and your resume, I saw that you had not testified in Wisconsin before. Is that right?
That's correct.
Have you testified in any prior large tariff docket anywhere in the country before?
I have.
And have you worked on data center issues outside of testimony before?
I have.
You worked on integrated resource planning?
Resource planning and integrated resource planning, yes.
Thank you. You're testifying for Microsoft here, obviously. Approximately what date were you retained by Microsoft to testify?
Subject to check sometime in 2025. I don't truly fully recall.
Okay. Put another way, do you know if the proposed tariffs were filed with the commission by the time you were retained?
I don't recall if I think that an application was put in. I don't remember if the tariffs were filed or not.
Okay, thank you. And have you consulted for Microsoft before in other states?
I have.
You have reviewed the testimony of, or were you here for the testimony of Mr. Stasek yesterday?
Almost all of it.
It was a long day, I understand.
Yeah.
Is it your understanding that Microsoft and WEPCO held meetings over a period of 2 or so years to develop the tariffs?
I heard that testimony, but I have no personal knowledge of those discussions.
Okay, that was going to be my next question, was whether you were involved in those discussions.
I was not.
Okay. So in essence, the tariffs were fully formed by the time you were retained, or almost fully formed? I
don't know the state they were in, but I had no participation in their formation.
Okay, thank you. In your experience in other jurisdictions, have you seen a set of tariffs like this before, with a very large customer and bespoke resource tariff with capacity only and full benefits options?
I think not exactly the same, no.
Okay. And is it fair to say, different states and other jurisdictions are addressing the challenge of the new loads created by data centers in different ways than is being proposed here?
I would say yes. I think we're kind of at the forefront of figuring out a lot of issues with respect to large load customers. And just like any utility rated matter, or utility matter, states approach these differently, and we're kind of seeing the evolution of that right now. So I'd answer that question, yes.
Okay, thank you. I want to direct you to your rebuttal.
Sure.
At page 9.
You can proceed. I'll just be looking for that, but let's not spend too much time waiting for me.
Okay.
Yep, I've got it in front of me.
Okay.
Great, thank you. And at page 7 to 14, you discussed the recommendation of Walnut Way witness, Mr. Ron Nilsson, that large loads be served primarily by clean resources. Do you see that?
I think this section speaks about his testimony as well as Mr. Fisher's testimony.
Yes, thank you.
Was that Mr. Fisher?
Yeah.
Thank you.
Witness Fisher. Yep.
And your answer, you say like any planning exercise, selecting the appropriate level of any resource type should not be done arbitrarily. Do you see that?
Can you point me to the line reference?
I think we're still in the 7 to 14 range.
Is there a specific page for that quote, or?
Yeah. I lost my place here. I'm sorry.
No problem.
Actually, to page, that was the beginning of the Q&A, and now we're down to page 9, lines 11 to 12.
Correct.
It's okay. And when you say like any planning exercise, what did you mean by that?
I think, in any sort of decision-making process, you don't want to do things without thinking about all the consequences of them. An example here is we are having this proceeding in order to bring forth the facts of issues related to the VLC and bespoke tariff. So this would be us, not just randomly choosing a number. We're thinking about the issues. We have parties with a lot of different opinions, debating them, and ultimately offering this evidence up to the commission to, make a just and reasonable decision. So, I'd have to look back at the context of exactly why I made that statement. But I think just generally speaking, you'd want decisions to be made based on evidence and based on analysis if you can.
Do you consider this docket a planning exercise?
I think this docket is planning with respect to how large resources can interconnect to the grid. I don't think it's planning with respect to which resources are going to serve those customers. Sorry, to correct my statement, how large customers are connecting to the grid.
Okay. Would it, generally speaking, your position that the overall resource mix for large users should be?
I'm sorry, you broke up for me. Is it generally?
Your position that the overall resource mix for large users should be planned up front?
Can you clarify that? You mean as opposed to after the fact?
Sort of as on a resource by resource basis.
I think there's lots of ways that planning is done around the country, and there's no perfect way. So I think whether you're looking at every resource individually or many resources together, there should be a process where you're evaluating the merits of that decision and figuring out if it's the best option relative to others.
And my question was, I think, a little different as to large users specifically, and the needs of large users, that the overall resource mix should be considered for those large users and planned up front before they're placed into use.
Can you restate that question? I'm not sure I fully understand the distinction you're trying to make.
Right. I think when I asked about planning, you mentioned that planning, there's different ways planning can be done. or there are different processes. There are individual processes and overall planning processes that consider multiple resources at once. With the respect to the loads from large data centers and the unique challenge presented by large loads, would it be your position that it's more beneficial to consider the resource needs and the resource mix for those large users up front?
The resource, sorry, were you going to add something there? I didn't mean to interrupt.
No, thank you.
So you're asking about the resource needs and resource mix of those customers?
Yes.
And should it be planned differently than for other customers?
Should it be planned up front versus on a resource by resource basis?
Well, again, I don't know that there's one true or right way to do it. But my understanding is that there is a process to file for projects within the state and get those approved. So that would constitute upfront as opposed to retroactively. I mean, you can't know all information at every time, and this tariff is open to, any number of new customers. So you can't, predict whether there will be all new VLCs in the future. But generally speaking, once a VLC is coming on and they need to have load to serve or generation to serve their load, there should be a process to figure out what that generation is.
Okay. Looking at page 12 of your rebuttal, lines 17 to 19.
Mm-hmm.
You discussed the technically and practically reasonable resource mix optimization. Are you offering any opinions here on how that optimization should be achieved?
I'm not.
Okay. Would you agree, generally speaking, that can be done through integrated resource planning?
I think it can be, yes. That's one of the ways it can be done.
Can I direct you now to page 23?
Again, of rebuttal?
Yes, thank you.
Yep, gotcha.
In line 18, which then spills over into page 24, line 7, you're talking about curtailment and flexible loads.
Mm-hmm.
And you say you agree those strategies are reasonable so long as they are voluntary. Is that a fair paraphrase?
Yes.
Okay. And are you offering any opinion here on whether curtailment or flexible loads are things not contemplated in the tariffs, like demand response, not explicitly contemplated, should be an option for serving VLC loads under these tariffs?
Your Honor, I'm just going to object to form. I think we might need to clarify that. Seemed like a few questions.
Sure. We want to rephrase that for us, please.
I will. Thanks. Are you offering any opinion here on whether curtailment and flexible loads should be an option for serving should be an option for VLC loads under these tariffs?
In this testimony right here, I don't think I offer any of that.
Okay. Same question, but for virtual power plants?
Well, I think the testimony up on the screen, I don't offer anything specific there regarding virtual power plants, no.
Okay. And you're not offering any opinion here on whether VLC should be able to utilize behind the meter generation?
Again, nothing explicitly in my rebuttal testimony, no.
Is it your understanding that WEPCO has stated in discovery or testimony that these options are not available to VLCs under the tariffs?
I recall a conversation yesterday that VLCs may be able to participate in demand response programs. It is my understanding that to the extent those type of resources are not owned by WEPCO, they wouldn't qualify as bespoke resources.
Do you know if Microsoft has a position on whether it should be able to, its data centers should be able to employ curtailment or flexible loads or demand response or virtual power plants?
I'm going to object, Your Honor. This is an expert witness. He's not testifying on behalf of Microsoft.
I'm asking if he knows if Microsoft has a position. I think that's fair.
Yeah,
Even,
okay.
even if he does, it's outside of his area of expertise that he's testifying on, to be honest.
I think this is just a fact question, honest.
Yeah, he's not a fact witness. He's an expert witness.
I'll allow the question. Go ahead.
So I'm not a Microsoft employee and I don't have any knowledge of that.
Okay. Lastly, I want to ask you about your surrebuttal testimony.
Sure.
Starting on page 2, which is the beginning of the section on community benefits, which is something Walnut Way had provided testimony on.
I'm there.
Great. You state on lines 11 to 13 on page 2 that eligible customers will provide significant benefits without the need for an additional community benefit, what you call an additional community benefits charge. Did I paraphrase that correctly?
Yes.
Okay. And then on lines 14 onward, you talk about some of the benefits eligible customers will provide under the tariffs as proposed, and starting with contributions to focus on energy. So I have some questions for you about the focus on energy aspect of your testimony.
Sure.
Did you have any familiarity with focus on energy before being retained for this case?
I had heard of the program, but not in-depth knowledge.
Okay. Do you know whether the specific contributions that VLCs make to the focus on energy budget through this tariff would apply statewide or would be confined to WEPCO service territory?
Not explicitly, no.
Okay. Do you know whether those contributions would be confined to projects that are near the data centers taking service under the tariffs?
No, I think generally they're focused on energy efficiency projects throughout the state.
Okay. And is it your understanding that any contributions to focus on energy would also not be confined to areas around bespoke resources?
I don't think they would necessarily be located next to one or the other.
Okay.
No, it's where customers would be located that would, initiate the energy efficiency projects.
Okay. I think you said customers anywhere in the state. Is that right?
My understanding, it's a statewide program, but that would be subject to check.
Okay. And then next you talk about the energy or environmental control charge. Scrolling down a little bit. And that the very large customers could be paying $1 million into the environmental control charge in 2026. Is that a fair statement?
So close, yeah. Basically, based on the 2026 rate, and a very large customer of a hypothetical size and consumption would have paid that much.
Do you know how much paying that amount of money in 2026 would benefit the average residential customer?
I didn't do that calculation, no.
Okay. Do you know how many residential customers WEPCO has?
Not off the top of my head.
If it were a large number of customers, would you agree that spreading out that $1 million over other customers would not result in a significant benefit to other customers?
I mean, I guess it depends on how you define significant, but I think any benefit you're providing, especially when it's one of many and they can kind of pancake together, you want to explore, quantify, and understand. So I don't know that I'd go so far as to say it's not significant. Changing one light bulb in a resident's house may not have a significant change, but overall, if you're looking to quantify and understand the savings to people, you'd want to look at it.
Okay. So if I can summarize that, you didn't analyze what the benefit of to other customers would be of VLCs paying into the environmental control charge.
Objection, Your Honor. She's misrepresenting the testimony. I think the testimony speaks for itself.
Okay, I'll agree with that. We have the questions and answers and the testimony before us, so
okay.
Let's move on.
Sure. On page 4, you talk about shared revenue.
The shared revenue program?
Yes.
Yep.
Are you there? Okay. And you mentioned those are funds provided to local governments, correct?
That's my understanding, yeah.
Okay. Those funds don't go to other organizations directly, correct?
Well, I don't have the full complete understanding of that program. As I understand it, funds are paid by customers through the gross receipts tax. That is one of the funds that goes into this, and one of the allocations that go out has to do with this utility shared revenue program.
Made again to local governments, right?
Yes.
Okay.
Are there
And
other funds that are paid to others? I'm not totally sure.
Okay, fair enough. Do you know if there are any limits on what local governments can spend the money they receive through shared revenue on?
I am not. My understanding is they have some discretion, but I'm not sure if there are specific legal limits. And you probably want to ask a lawyer to review the law on that.
Okay, you don't know if they're limited to spending those funds on things that are energy related versus something like health benefits for employees?
I couldn't say.
Okay. You mentioned toward the end of your testimony the Portage project. The 250 megawatts of solar that Microsoft has supported in Portage County, Wisconsin. Does that ring a bell?
Yep.
And you do you know anything about the model of how that project works? The community benefits aspect, I'm sorry.
Sorry to interrupt.
I just realized my question was unclear, but do you have any understanding of the model for dispersing the $20 million to the community benefits fund works?
I do not.
Okay. Nothing further for this witness. Thank you.
Thank you.
Thanks. Other cross?
Judge, this is Daniel Narvi for Cub.
Sure. Go ahead.
I do have one question for the witness based on his sir rebuttal.
Go ahead.
Good afternoon, Mr. Gable Frank, Daniel Narvi with the Citizens Utility Board. Just one question. Do you have any opinion on whether it would be costly for a company with a triple B credit rating or higher to obtain a letter of credit?
Would it be costly? Meaning, what are the fees paid by a company looking to get a letter of credit, or how much does a letter of credit cost for a company providing the letter of credit?
Yeah, the question is what I'm looking for is whether you have an opinion on whether the company who is providing the letter of credit, whether you have an opinion on the cost or the economics to that company of providing the letter of credit.
So just to make sure I understand, how much it costs a bank, for example, to fund and underwrite a letter of credit for another entity that is looking for a letter of credit?
Not focusing on the bank, focusing on the company, in this case, a VLC,
Okay.
if they were subject to the letter of credit requirements under the tariff. Do you have an opinion on whether it would be, on how costly it would be for a company with a triple B rating or higher to obtain a letter of credit?
Not explicitly. I think one witness did have some estimates in their testimony, but I don't have any testimony on the cost of obtaining a letter of credit. I know that it's not nothing, and especially if you are an entity that already has ample, credit and liquidity, it's a cost that is kind of a double cost to you because you're already kind of have shown that you have the ability to meet your requirements and debts.
But you don't have any opinion on the scope or amount of that cost, correct?
Not explicitly. I haven't done any calculations on that.
Okay, thank you.
Okay, no other cross. So how about redirect? Oh wait, Commissioner Hawkins is here, so let's get you on. All right, great to see you there. Still at the airport?
still at the airport for another 25 minutes, and Madonna is definitely playing in the background, so I apologize.
No, we can't hear it. We
Okay.
probably could use it at this point, but
It's been helpful.
all right. Well, go ahead with your questions, and we'll try to get you in there before you have to leave.
Great. And I apologize for not hearing the earlier discussion with this witness, but I did have a couple questions. In your rebuttal testimony, you were discussing, I think, responding to the minimum billing demand charge. There was a section on that. And I think it was in response to, it's not that part. But anyhow, you raised the concern that adopting a minimum billing demand charge would not protect other ATC customers. And can you just confirm in that situation you're referring to other utilities served by the ATC system?
Correct.
Would you agree, though, that such a charge could protect WEPCO customers that are not participating customers?
It could protect or subsidize. So if that minimum demand was to collect more than just the WEPCO portion, then there'd be an amount above what they needed. So
Got it.
That would be just, but yes.
And you would agree with some of the questions I asked earlier that the commission has the authority to do that?
Setting aside that I'm not a lawyer, and I don't know all the Wisconsin laws, hypothetically, the commission has the ability to set rates for in a WEPCO case for WEPCO customers. Yeah.
Thank you. And then I think later on in your rebuttal, going to the point you were just making about potential for subsidization, you mentioned ignoring the benefits to non-participating customers, potentially. But would you agree that the benefits for non-participating customers are completely tied to the level of demand and how the VLC is billed?
You mean benefits with respect to transmission or any of
Yes, transmission paying for the system.
So one of the major benefits certainly is that, a large load will come online and hypothetically provide some dilution to rates for other customers. That happens as long as that customer's load is being accounted for within the coincident peak that, is used to develop the transmission rate. I do think there are other benefits that can occur even if that customer is not creating that dilution effect. When you look at these transmission upgrades, MISO often is looking at doing upgrades kind of holistically. So they're going to see maybe there's a line that they reconductor and that's an existing line. So other customers are going to benefit that they have a more efficient, more robust, newer system. I think there are other benefits that you can see in there that aren't directly tied to just the load of the VLC, but certainly that's a big one.
Okay. And then on your rebuttal page 2, you list 3 points as to why the as proposed, there they are, 1, 2, and 3. The as proposed transmission charge is appropriate, and you highlight there in number 1, it uses the same approach for cost of transmission as other industrial customers. Is it your understanding that the transmission investment to serve a VLC is comparable to the transmission investment of other industrial customers?
I think it depends on the situation, first of all, and I'm not, tied in directly to any specific project. I heard some testimony today about how Wisconsin already has a robust system and that may impact the costs. On a gross basis, the capacity is larger, so one could expect the cost to be larger. Is it more expensive on a unit basis, meaning per kind of megawatt of transmission capacity? I'm not sure.
Okay, and then just in your general experience, I guess, in this industry, is it your understanding that large data center loads might require specialized transmission or more robust transmission due to their reliability requirements?
You mean like interconnect transmission versus kind of shared grid facilities?
Yes.
I'm not an engineer, but I understand that these type of customers do value reliability. So Hypothetically, they could look for redundancy there, but I couldn't speak to how they do that or the costs of that.
Thank you. I have no further questions.
Thank you. Those were good questions. Appreciate it.
All right. Is that all our cross? Any redirect?
No redirect, Your Honor.
All right. Thank you. Witness Gable Frank, you're excused.
Thank you. Appreciate it.
Yep. And we'll take, let's see, timing. We still have some time before 1 o'clock. So we probably squeeze in another witness before we take witness Chester. Let's keep going down our list and have witness Fisher take the stand.
I'm here.
There you are. Yes, great. Let me just readjust the screen. Okay, I think we're settled there. All right, so and we have WEPCO with questions. So let me move you over there. Okay, perfect. Okay, witness Fisher, let me swear you in. Raise your right hand. And do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead, Attorney Desai.
Good afternoon, Dr. Fisher. Could you please state and spell your name for the record?
Yes, Jeremy Fisher, Jeremy Fisher.
And are you the same Jeremy Fisher who prepared and caused to be filed direct testimony and surrebuttal testimony along with 15 associated exhibits in this proceeding?
I am.
To the best of your knowledge, was your pre-filed testimony true and correct?
It is.
If you were asked the same questions today that you were asked in your pre-filed testimony, would your answers be the same?
They would.
Upon review of your prior testimony, do you have any corrections that you'd like to make today?
Not that I'm aware of.
Okay. Your Honor, we have a few questions on surrebuttal. So that's okay.
Okay. You mentioned that you had some questions about the filings.
Oh, yes, I did. We can cover that first.
Did you want to, is that something we need to do on the record, or are these just clarifications?
I don't think that we need to do them on the record.
Okay, well, let's take a chance and go off the record, and then we can always fall back and revisit that. But yeah, what were your issues there?
So my question was about Exhibit 12, and
are we off the record?
Off the record, yeah.
Okay, thank you.
Sorry, I wasn't clear.
So my question was about Exhibit 12. And if you'll recall, yesterday we talked about the confidential version and the non-confidential version.
Yeah.
So the document that Sierra Club pulled for Exhibit 12 was from a different docket.
Yeah.
It's theoretically the same docket it's theoretically the same document that WEPCO filed as attachment 2 to one of their data requests. It's a response to AJF 4.1.
Okay.
And the PSC ref number is 573462.
So the number you just gave me is in this docket.
Correct.
Okay. So your question is?
So my question is that there is a discrepancy between WEPCO's redactions from the document they posted in the buy-sell docket versus what was posted in response to discovery requests in this docket.
Okay.
So go ahead.
Yeah, that's a good question. Okay. So yeah, and you're wondering which one to use?
Yes.
Okay.
And I can point out exactly what the discrepancy is. It is starting on page 33, table 7, I believe.
Okay.
And if you'll see, there's the is this the docket from, or the document from this docket, or Dr. Fisher's exhibit?
It's the exhibit.
If you could pull up the document, please, from this docket.
Okay.
I can demonstrate the discrepancy.
Mm-hmm. me a minute here. This is a lot more complicated than I thought it was going to be. I thought you're going to ask
Apologies.
me. No, it's not. I thought you were going to ask me, like, should I put a period here or something like that? But okay, so this is the redacted version. So if I put these both on the screen, it's going to be very tight. But I think, oops. So are you looking at specific areas of redaction? That should be able to show that, I think.
Yeah, so table 7 has that yellow value. It's the
Oh, is that-
NPV
Mhm.
savings value.
Okay. Oh, I see. Yeah, and it's redacted here.
It's
Okay.
redacted in the version that was filed in this docket. However, those NPV savings values are mentioned in the preceding paragraphs to the table, so they're written out.
Okay.
So it's unclear why it was redacted in the table.
Okay. Well, I don't know if the company is prepared to answer that right now, but if you do have an answer, I mean, it is already public in the other filings. So my presumption is that we can use the more public version. But did WEPCO have any comment on that?
We don't. I believe that's fine. We presumed it to be DCI trade secret in yellow and inadvertently when we were highlighting it. And so the more public version, I believe, is fine now.
Okay. So the version that's has the yellow redaction. It's in the existing exhibit. That's in the buy sell docket. That document was taken from the buy sell. Okay. So just so we're all on the same page, let's have the company refile this attachment that was so I guess there's two versions of this. It can update this Appendix A with the version that it filed in the buy-sell docket. And then if Sierra Club can use that version to
something already had
fix its exhibit, its Fisher exhibit. I think the important thing, and the table, right? This is in testimony, right? The important thing is we want to take that yellow off because that confuses us with our color coding. But outside of that, I think we also want to use what'll be the new data request response to create a new version of Fisher, both the confidential and redacted version. So the confidential would have these redactions removed.
Okay.
We're clear on that? Okay.
That makes sense. And just to clarify, that would also mean we make some minor changes to references to the documents in Dr. Fisher's direct testimony as well. I don't think we pull any of the numbers, but we do reference the document. So we'll just adjust the citation.
The citations. Okay. So company, have any questions about that? Are we clear about what we need?
Yeah, I believe we're refiling the data request response, and then Sierra Club will get served with that new data request response and carry through the changes from there. As I sit here at 12:45 on a Friday, I don't know when that'll be accomplished, but we will. I believe we understand what's required.
Okay. Yeah, and that's fine as long as we get this done in a reasonable time. That's fine. All right. So any other filing issues?
No, I think that was it. Thank you so much.
All right, great. So let's return. So continue on with your additional testimony.
Back on the record?
Okay.
Yeah, let's get back on the record. Yeah, that's what I meant to say.
At least
Great,
I'm
thank
paying
you.
attention.
Yeah, thankfully you are, yes. Go ahead.
Okay, thank you. Dr. Fisher, were you here when Mr. WEPCO witness Gerlikowski was on the stand?
I was, yes.
And did you hear his testimony with respect to the use of the raw B-storm model results in the economic analysis of the Foundry Ridge combustion turbines?
Yes, I did.
Now, do you understand the company to have a reference case in this analysis?
I do.
And what is the name of that reference case as used by the company in this analysis?
The reference case goes by the name continued fleet change, and has been also referred to, I believe, as reference one, or I'm sorry, future one.
Future?
Future.
Okay.
Can we please turn to page 19 of Dr. Fisher's surrebuttal testimony?
Of course.
Thank you. And we'll be looking at table 2.
All right.
Do the results that you're showing here for Foundry Ridge appear to be the same results as what Mr. Gerlikowski presented in his Sir rebuttal?
Yes, I believe that they are similar.
Can you explain the term excess savings as used in this table?
Yes, I understand that excess savings refers to the difference between the present value of costs that would be attributable to non-participating customers, which is generally the revenue requirements and other fixed costs, and the present value of any revenues that might flow through net energy sales. And that the difference between those two is put forward as excess savings, where a positive value is an increment to non-participating customers and a negative value is a detriment to non-participating customers.
Okay, and when you look at the value of excess savings in the reference case, future 1, what is the value there?
0. Which
Now
means that there's, oh, I'm sorry.
Nope, finish your thought.
Which means that there is no incremental value to non-participating customers.
Okay. Now, in their Sir rebuttals, Mr. Gerlikowski and Mr. Shilendranath also briefly discussed the break-even year that you show in this table. Can you briefly explain what the break-even year represents here?
Yes, the break-even year is the year in which the present value of revenue requirements, including any value provided to customers, reaches the 0 point. It is the year in which customers would realize any benefit after having paid for costs up to that time period.
And what is the break-even year for Foundry Ridge when you use the raw B-store model results in the reference case?
2058.
Okay. And what is the break-even year for Red Oak Ridge in the reference case?
That would be 2042 or 15 years from now.
Okay, and then I just have a couple questions for you based on Cloverleaf witness Bernhardt's testimony. Were you here when Mr. Bernhardt was testifying?
Yes, I was.
And did you hear PSC staff's questions to Mr. Bernhardt about the capacity-only framework?
I did.
And did you hear Mr. Bernhardt state that the capacity-only framework would help in moving away from coal assets towards more efficient gas?
I did hear that, yes.
And do you have a response to his assertion?
Yeah, the gas plants that are being contemplated under the capacity-only framework are peakers. They're put forward to be at the further end of the supply curve and would end up being some of the last plants that are ultimately going to get dispatched. And I think the company even discusses a limitation on their expected capacity factor within their analysis for both of these capacity-only resources. It is therefore very unlikely that they would end up displacing resources that are either lower in the marginal cost supply curve, or earlier in dispatch, and is very unlikely that they would end up displacing existing fossil assets like coal plants. In fact, with the increased demand from these very large customers and the very high load factors, I think it is actually quite likely that the utilization of very high emissions and very high cost plants throughout MISO will probably end up increasing, not decreasing.
Okay. I don't have any other further questions. Does that complete your testimony, Dr. Fisher?
It does.
Thank you, Your Honor. The witness is available for cross-examination.
All right. I think the applicant had some questions, so why don't we go ahead?
Thank you, Honor. Could you bring up the page you just had up, if you
Oh,
mind?
yeah, sure. Sorry to break your stride here. All right, go ahead.
Good afternoon, Dr. Fisher. My name is Attorney Patrick Proctor Brown, and I represent Wisconsin Electric Power Company. We haven't met before, right?
I don't think so. Good afternoon.
Good afternoon. Thanks for being here. So I want to focus your attention on Table 2. Do you see that table in front of you?
I do.
And you were asked some questions about excess savings being 0 in future 1. Do you recall that?
I do.
And that means non-participating customers have been paid back what they paid in terms of capital costs towards the plant. Isn't that true?
It means that by 2058, the last year of this analysis, customers would have at that point recouped the costs that they would have paid for the plant. Yes.
And are you generally aware of how generation planning takes place in for utilities? Is that fair?
I am.
We're talking about long-lived, high upfront cost assets, generally speaking. Isn't that true?
That is true.
So you wouldn't expect a long-lived, high upfront cost asset to be paid off in years, say 1 through 5, would you?
When a long-term, long-lived asset is being built at the behest of customers, no, I do expect that those customers would not have an immediate payoff from those. But I think it's very important in this case to distinguish that these are assets that are being built for the capacity purposes of the very large customers as bespoke resources.
But when we're talking about these capacity-only resources, non-participating customers are retaining the energy benefit from these units, correct?
If an energy benefit is realized, they would retain that energy benefit, yes.
And if the VLCs end up terminating or leaving for some reason, the asset would still exist within LRZ2 and still be providing
I'm sorry,
the
the asset
capacity to generate.
I'm sorry, the asset would still exist
Would still exist within LRZ2 and provide the capacity to generate electricity for the benefit of customers in LRZ2, right?
That is true.
And just generally speaking, the capacity planning framework is different than how we actually generate electricity for customers. Would you agree with that?
Certainly, it should be representational, but it does not reflect exactly what occurs.
Because we have to generate electricity essentially instantaneously to balance load and demand, right?
Of course.
And you can't tie a particular electron from a generation resource to a particular customer. Do you agree with that?
Agreed.
So the fact that this unit exists inside this area means it's likely providing electricity in some way to non-participating customers, right?
The resource is providing electricity to all customers, both those of the utility and those within the greater interconnected grid. The question I think at hand is who is paying for and who is benefiting from those resources.
And as you sit here today, can you say that non-participating customers will not benefit from these resources?
Over the long run, I really don't know. But my testimony is that the risks and the potential for costs to be incurred by non-participating customers is inappropriate in the context of being able to serve these very large customers.
Okay. And that gets me to your direct testimony. So I think I'm done with this, Your Honor, if you wanted to take it down.
Sure.
You just mentioned risk. In your direct testimony, you testified at length about what you characterize as concentration risk, correlated market risk, and speculation risk posed by large data centers taking service. Is that a fair synopsis of some of your testimony on direct?
I believe that's correct, yes.
Would you agree that a risk in the economic sense is something that can be quantified and measured?
With sufficient information, yes.
In your direct testimony, did you provide any quantitative analysis, any dollar figure, percentage, or range of the alleged harm to non-participating customers from these theoretical risks?
I did not.
Okay, thank you. Are you aware that Wisconsin Electric has a statutory obligation to serve all customers in its service territory?
I am not
Objection
sorry.
calls for a legal conclusion.
It asked for his knowledge. If he's not aware of it, he can say that.
Yeah, I'll overrule.
I'm not familiar with what this specific phrasing is within Wisconsin's statute.
But are you aware that regulated public utilities generally have an obligation to serve customers in their territories?
Yes. However, there are clearly boundary conditions around that obligation, as even demonstrated by the presence of this very large customer and bespoke tariff for issuing conditions of service.
Okay, but generally speaking, you have a statutory obligation in most circumstances to provide electricity to all customers on a non-discriminatory basis. Do you agree with that synopsis?
I agree, yes.
Thank you. Isn't it true that you did not analyze what rates non-participating customers would pay without the proposed tariffs?
I did not, no.
Are you aware that Wisconsin Electric's analysis shows that non-participating customers would be allocated approximately $1.5 billion in additional capital investments if VLCs took service under the existing CP1 tariff instead of the proposed tariffs?
I reviewed I apologize, Stake's testimony, where he asserted that $1.5 billion differential.
Did you also review Mr. Nelson's testimony?
I don't recall.
Okay. Did you conduct any analysis of your own comparing non-participating customers' rates under the proposed VLC tariffs versus the CP1 tariff?
I did not.
I don't know if we need to bring this up, but at pages 24 to 25 of your direct testimony, you acknowledge that the proposed tariffs include critical improvements relative to other large load tariffs because they seek to bill VLCs for the entire book value of distribution, transmission, and bespoke generation built to serve their purposes. Subject to check, would you agree that that's part of your testimony on direct?
Yes, an important term in that phrase was the seek to. And as I state later in my testimony and elsewhere, there are important caveats for the correction of these tariffs to ensure that they actually accomplish that outcome.
Okay, but you agree those are critical improvements over tariffs in other areas, right?
I do.
Given that the VLCs have already invested hundreds of millions of dollars in Wisconsin Electric's service territory and are legally entitled to service under WISTAT, legally entitled to service in the territory, under WISTAT section 1961922BM, isn't any analysis that compares the tariffs to a hypothetical world where the VLCs don't exist fundamentally flawed?
I guess I'm concerned that the question that you phrased has a supposition in it that the amount that's been invested within Wisconsin is sufficient to demonstrate that these customers are, in fact, in it for the long run without guarantees on the system that are required under many large load tariff equivalencies. There is an extraordinary amount of money that's being invested in data centers by technology companies, including in Wisconsin. And I think there is very little evidence right now about what the long-term market is going to look like for that level of investment. one of the questions that you asked earlier is whether I was able to analyze the risk that these no longer occur. And I think that's a macroeconomic question for which very few economists currently have any form of answer. Whether the amount of money that's being spent in these data centers is actually something that's going to ultimately pan out with marketable outcomes. My testimony with respect to the risk is that that unknowable component of it puts Wisconsin at risk. And similarly, my answer to your question here is I don't think it's necessarily a reasonable supposition that those customers will successfully be maintained over the long run based on the type of investment that they're making today.
Right, but they're entitled to serve us as customers within the service territory. Wouldn't you agree?
Yes.
So it's not reasonable to assume that they just don't exist to judge all of the risks and benefits to non-participating customers. Isn't that fair?
No, I think you need a counterfactual to assess costs and benefits. And so one form of a counterfactual is if those customers do not exist, what does the system look like? If those customers do exist, what does the system look like?
But you just acknowledged that they're here making hundreds of millions of dollars in investments. You're saying the counterfactual should be assume away the VLCs and see what happens to rates? Is that your testimony?
No, not at all. I
Okay.
think
I want
I'm
to turn
sorry.
to wholesale market revenues.
May I finish
Dr. Fisher,
my
I think
response?
you answered the question. You can
Okay.
your counsel can ask you follow-up questions if she chooses. Dr. Fisher, are you aware that under the capacity-only bespoke resources tariff, non-participating customers retain 100% of the forecasted energy and ancillary services revenues from the MISO day-ahead energy, real-time energy imbalance, and ancillary services markets?
That was my understanding, yes.
And you're familiar with the analysis presented by Mr. Shilandranath and Mr. Gerlikowski of an expected net benefit of $430 million in net present value terms across the Red Oak Ridge and Foundry Ridge projects, correct?
I did see that in their testimony, yes.
In your direct testimony, you asserted that the economic analysis for Red Oak Ridge did not reflect the variable cost of fuel, which you characterized as a large error. Do you recall that in your direct testimony?
I believe I said it may reflect that error, and then I saw the response to that within the testimony from WEPCO, and I understand that that net fuel cost was accounted for within the testimony or within the analysis.
So you just misunderstood the analysis before you filed your direct testimony? Is that fair?
For that specific element, I was unclear at the time, and I have not since continued to investigate that issue.
Did you seek to withdraw your direct testimony in this docket?
I did not.
What is NERC?
NERC, I believe, stands for the North American Reliability Council.
The E is energy, right?
Subject check, yes.
NERC is formally designated by FERC as the Energy Reliability Organization for the United States Bulk Electric System. Do you agree with that statement?
Subject check, yes.
Are you aware that NERC publishes an annual long-term reliability assessment?
I am.
Are you familiar with NERC's 2025 long-term reliability assessment?
I don't believe that I have formally reviewed it yet.
And Judge Newmark, this is one of the documents I sent you on Wednesday, if you don't mind bringing that up.
Okay. So is that NERC LRTA 2025? Is that the file?
Yes, Your Honor. Yes. And Witness Fisher, you said you hadn't formally reviewed it. Have you informally reviewed this document?
I have not.
I think I maybe this is the 2025 assessment, but it came out in January of 2026. Do you see that?
I do.
And Judge Newmark, if you go to page 8. If you look at the top of right there, thank you. You look at the top of this chart, you see MISO listed there.
I do.
It says MISO is and that chart says MISO is projected to move from elevated risk in 2027 to high risk beginning in 2028 due to escalating demand forecasts and generator retirements. Do you see that?
I do.
Judge Newmark, if you could go to page 14, please. The top line in this table is again MISO. Do you see that?
I do see that, yes.
If you go across to anticipated reserve margin, by 2030, NERC projects MISO's reserve margin to be just 4.3%, which is barely more than half the 8.5% reserve margin they would like to see in MISO. Is that fair?
Roughly speaking, I think that is correct.
And given these tight market conditions, wouldn't dispatchable resources like the proposed capacity-only bespoke resources be positioned to earn substantial wholesale market revenues for the benefit of non-participating customers?
Well, first, I think there's an open question about which resources are taken into account in NERC's long-term reliability assessments as a general matter. And again, having not reviewed this one specifically, I don't know which of the resources in MISO's interconnection queue have been accounted for versus those that have been otherwise not accounted for. But that has historically been a disconnect between NERC's long-term assessments and what sits within those generation interconnection queues. As a second matter, I would note that this is actually a pretty clear illustration of the potential detrimental impacts that we can have to a system from very large customers who have very high concentration risks and very large impacts on the system over a very short period of time.
Right, customers that you acknowledge are here in Wisconsin right now, correct?
Yes.
Thanks. And I do want to focus a little bit more closely on my question. So tight capacity and energy markets would tend to create greater energy margin for dispatchable units like the capacity only bespoke resources you've criticized in this docket. Do you agree with that?
Can you please restate the question?
Yeah, so
let's you want a clarification or just a repeat?
Just a repeat would be fine.
Okay, let's read it back.
Thank you, Your Honor.
Yeah.
I want to focus a little bit more closely on my question. So tight capacity and energy markets would tend to create greater energy margin for dispatchable units like the capacity only bespoke resources you criticized in this docket. Would you agree with that?
Thank you. They could. Tight capacity market might not. A tight energy market could. But again, this goes back to which resources are accounted for successfully within this assessment. MISO's interconnection queue is currently quite flush still, with quite a few low variable cost renewable energy resources. If those end up being successfully built on the system, we'd actually expect, like SPP, to have many times during the year in which wholesale market electricity prices are actually quite low. So I don't think that that type of future was reflected in WEPCO's analysis for either of the capacity bespoke resources.
You said you don't think, you don't know one way or the other exactly what was reflected in the analysis. Is that true?
In WEPCO's analysis, please?
Yes, in WEPCO's analysis.
As far as I'm aware, there is a singular future 4, that included what was called additional renewable resources. It also appeared to have a substantially higher energy price associated with it, which I assume was due to a carbon adder in that circumstance. I don't think it was a representation of a system in which there's a substantial amount of organic build out for renewable resources.
But you didn't review the actual B-store analysis or the actual Plexos analysis. You just reviewed the results. Isn't that true?
I reviewed all of the work papers that were provided, including the underlying Plexos output runs that were provided by the company.
Yeah, the
in
outputs,
WI.
the outputs, but not the inputs to the model. Is that true?
I was not provided the inputs to the model, no.
Right. So you don't know one way or the other what renewable resources are reflected in that model. Isn't that true?
I know all of the renewable resources that were assumed to have been brought online by WEPCO.
But
Yes.
you don't know the other renewable resources that were part of the model and contributing to the energy prices in the B-store model or the Plexos model. Isn't that fair?
Sure. Yes.
Thank you. And you mentioned that there's a substantial amount of renewable generation in the MISO queue. Do you recall that testimony just now? Those renewable generation portfolios, they're variable energy resources. Fair?
They are.
So when you talk about times where prices are going to be very low for solar resources, that's generally when the sun is shining between noon and 3, maybe 3:30 on summer days. Is that fair?
For solar, sure. Though solar has a much broader, longer portfolio. I think we tend to get quite low prices in California for fairly substantial periods of the day. Yes.
California is not Wisconsin, right?
No, it is not.
Thanks. So you would acknowledge that there are going to be times when the sun is not shining, the wind is not blowing, but these capacity-only resources will be able to generate electricity for customers, right?
Yes, but again, the value of having an interconnected system like MISO is that we have a quite broad geography of wind and solar that will be able to contribute to that system if those resources get built. But yes, there will be hours in which those resources are not operating. That's correct.
Thank you. Judge Newmark, if you could go to page 15 of this, I think we're on 14. On this page, NERC reports that small amounts of natural gas-fired generation and signed interconnection agreements do not offset planned generator retirements in MISO, resulting in projected shortfalls in planned resources for winter peak periods. Is that consistent with your understanding of some of the information here and the broader market?
Again, I have not reviewed this particular document in depth.
Okay, that's fair. Dr. Fisher, would you agree that gas-fired combustion turbines can start and ramp quickly, making them well-positioned to respond when real-time prices deviate from day-ahead prices due to load forecast errors, renewable output variability, outages, or transmission constraints?
Both storage and peaking resources are able to meet those criteria.
Storage also has problems with ride-through that NERC has identified in other long-term assessments and this one. Would you agree with that?
Again, I have not reviewed their specific outcomes in this assessment.
But natural gas-fired CTs provide all essential reliability services, and BESS does not. Is that true?
I think the definition of all reliability service is a little overbroad. We have definitely seen periods in which gas resources have not had availability due to frozen lines and frozen pumps and availability of gas during those time periods.
And that's more about the resiliency of the gas delivery system than it is the actual units themselves. Would you agree with that?
But it has an impact on the overall availability, which is why we have I think D ratings of some of those gas units relative to their availability to meet capacity requirements in some RTO systems.
Do you have any knowledge of the status of Wisconsin Electric's generation fleet in Wisconsin?
Not specifically, no.
So you're speaking about other units operated by other utilities just now. Is that right?
I'm speaking in broad terms about the way that I understand the system to operate.
And are you aware that the MISO generator interconnection queue is dominated by solar and wind requests, and that those collectively exceed battery storage capacity by approximately 2 to 1 over the 2026 to 2030 period?
I don't have a specific number in front of me, but I'd be happy to take a look at that if you'd like to put it up.
Okay, but you're generally you talked about the interconnection queue just minutes ago. You understand that variable energy resources dominate the MISO queue right now. Is that fair?
Again, I don't have the specific numbers sitting in front of me. I know that there is a lot of storage capacity in that queue, but I don't have the specific number that you just cited for the 2 to 1 or otherwise.
But you're aware that there's an imbalance between wind and solar and BESS in the MISO queue, right?
I don't have that specific knowledge, no.
Would you acknowledge that non-participating customers will receive a reliability benefit from Red Oak Ridge and Foundry Ridge?
I'm actually unclear on that matter because I understand that the expected load factors for the very large customers are likely to be quite high, meaning that the purpose of the capacity in order to be able to serve customers during periods that are short may not actually be available to other customers when those very large customers are using those capacity resources. I'm sorry, that was badly phrased, but I can restate it if you need.
Well, I believe your testimony was that these generation units will serve all customers earlier today when I was asking you about these resources. Do you agree with that?
You had asked whether the electrons from these resources flow to all customers, and I answered that, of course they do. We are an interconnected grid. I did not answer that the benefits would specifically flow to those capacity benefits would flow to non-participating customers.
And I didn't ask about capacity benefits.
Please restate your question then.
Yeah, so these units can operate when variable energy resources aren't operating. You acknowledge that, right?
Yep.
They can operate when there are transmission outages and other grid stresses. You agree with that?
I do.
And so generally speaking, because these units are going to operate to serve the whole grid, those reliability benefits will also accrue to non-participating customers. Do you agree with that?
Notionally, to the effect that we need to have a grid that actually operates, yes.
Right. Thank you. Appreciate it.
Sure.
If energy prices are higher than forecast, non-participating customers will benefit from those prices too, correct?
Yes.
If Red Oak Ridge and Foundry Ridge are full benefits resources, it's the VLCs that will benefit from high energy prices. You agree with that?
That's correct.
So in your surrebuttal testimony on page 16, if you can pull that back up here, mind?
Okay, 19.
16, if you don't mind, I swear.
Sure.
So that paragraph under the chart, you state using raw B store values, quote, reduces overall savings in the base case from 287 million to 231 million for Red Oak Ridge. Do you see that?
I do.
If Red Oak Ridge was a full benefits bespoke resource, that $230 million benefit would belong to the VLCs, correct?
It would. The benefit and the risks and the costs would all belong to the VLCs, and I believe that is appropriate.
So you're actively proposing to eliminate the option for capacity-only bespoke resources and eliminate this $231 million benefit to non-participating customers. Is that a fair summary of your testimony?
That is correct. I am proposing that we completely ring fence these other customers by having them own both the costs and the benefits that would flow from the resources that they take responsibility for. Yes.
And Your Honor, if you could bring up Exhibit SC Fisher 10, I would appreciate it. Were you involved in the creation of this report?
We had a review of the report and provided some input into it. But
You
we did not.
personally did?
I'm sorry. Did we catch that answer?
Mhm.
Okay. You're better than I am. Okay, go ahead. Sorry.
Both I and others at Sierra Club and at Grid Lab, which sponsored this report.
And Good Lab, did you say?
Mm-hmm. That's correct.
And so in this report, you reviewed an assumption of wind capacity up to 3,000 megawatts in the renewable only scenario on page 27 of this report. Or I guess I would strike that. I withdraw the question. You personally reviewed the assumptions in this report. Is that true, Dr. Fisher?
I did not have editorial input into any of the assumptions that were made in this report.
But you're aware that you were aware and you reviewed the assumption of 3,000 megawatts of wind capacity in this report, right?
I did.
And this study also assumes capacity factors of 55 to 74% for combustion turbines. You're aware of that?
Yeah, although I'm not actually sure that that's inconsistent with outcomes that would have been presented within the company's modeling had the company not capped the capacity factor of the bespoke resources at 20% in its modeling.
And you're aware that that capacity factor is consistent with current air regulations published by the EPA, right?
Actually, I'm not. No.
Are you aware of the clean air regulations related to new natural gas resources published by the EPA?
Yes.
So the cap is 20% for resources of that type. Do you disagree with that statement?
I don't have that sitting in front of me.
Okay, that's fair. Would you acknowledge that relying heavily on out-of-state renewable resources, as this study appears to contemplate, would be riskier and potentially subject to different MISO pricing than local resources in LRZ2?
I think there's a supposition in the question that is not necessarily reflected in the study. I think the study was contemplating the question of whether, again, don't have the study up in front of me, but I can pull it up, whether the 3 gigawatts worth of wind or other resources built would be within WEPCO's service territory. Functionally, the study is asking just a simple question. It's asking, if we have a system that's more focused on gas resources, what does the risk of high gas prices look like relative to what is a system that is focused more on renewable resources look like? And asking the question of how does the potential for fuel cost risk shift within that that framework?
You done any analysis to determine whether 3,000 megawatts of wind can be constructed within LRZ2?
No.
Are you aware of plans to construct that much wind in LRZ2?
I am not specifically aware of plans to construct that amount of wind in LRZ2. Again, this is a representation of hypotheticals extending into the future for a renewable heavy system. I suspect that the results would have been broadly similar had that been focused on solar.
Well, when
rather
you
than
say
wind.
you suspect, that's speculation about an analysis that's not in front of you, right? So you suspect, you're just speculating about a different analysis. Is that fair?
The conclusions that I drew from this study were that a system that
Well,
was
that's not my
focused.
question, Dr. Fisher. I'd appreciate if you pay attention to my question so that we can get out of here today. When you say that you suspect something, you're just speculating about what a different analysis might show that's not in front of you that you haven't reviewed, right?
I'm sorry, poorly phrased. The conclusion that I drew from this study was that.
But again, I'm not asking you about your conclusion. You just said, I suspect. When you said, I suspect, you're just speculating about different analysis, right?
Sure.
Thanks. So if it were not possible to construct 3,000 megawatts of wind in LRZ2 and you had to construct it more geographically remote from load, that would create additional risks for customers in LRZ2, right?
I really don't have the evidence one way or the other to say so.
You don't know whether constructing wind in Montana imposes greater risks on customers in Wisconsin than constructing resources in Wisconsin? You're not aware of that concept?
No, I don't have the evidence in front of me to be able to say one way or the other where resources could or would get built and what impact that would have on Wisconsin customers.
But
The
you're
hypothetical
aware
that you're extending is not one in which I have familiarity.
And I'm just looking at one specific change. You built generation in LRZ2 to serve customers in LRZ2. Is that more or less risky than if you built generation in Montana to serve customers in LRZ2?
I really couldn't tell you. I have not done that analysis or assessment.
Okay, thank you.
So hang on, before we move on, I wanted to talk about 3 gigawatts in this study. I haven't specifically found that number.
I'm sorry, gigawatts or megawatts?
Well, 3 gigawatts, 3,000 megawatts.
Okay.
Yeah, sorry. But tried to search both in there. That didn't pop up on my search. I just want to make sure that that's the premise in the study. Can we just confirm that this exhibit relates to this, theoretical 3,000 megawatts somewhere? Is it stated there somewhere?
That's my understanding, Your Honor. Mr. Fisher reviewed the report. If he wants to dispute it, and is what is.
I don't think there's any dispute. I just want to confirm that that's the premise of the study, and I didn't see that number in there, but maybe I'm just searching it incorrectly. So if someone can point me to where it does.
Judge, if I may, table 6.
Okay.
I'm sorry, what did you say? What 6?
Table 6.
Table 6, thank you.
Okay, yeah. Okay. So that's the premise of 3,000 megawatts of wind in the last column, one row from the bottom. Last column to the right, one row from the bottom. That's where the reference is for 3,000 megawatts of wind.
I believe so, Your Honor. Yes.
Is that correct, Witness Fisher?
I think that's what the council is asking for, but that's my understanding.
I mean, when everyone was talking about 3,000 megawatts of wind being evaluated in this study, that's where we could point to saying, well, that's where it's referenced in the study. Or no? I just want to know.
I believe so, Your Honor. That's what it says, right? 3,000 megawatts.
Yeah. And that's what's intended in your answers when you referred to 3,000 megawatts as it exists in the study. This is what you were intending to refer to, Witness Fisher?
That is, yes.
Okay. I just want to make sure we got the right thing. Okay, great. Thanks.
Thank you, Your Honor.
So we're done with WEPCO's questions. And do we have other cross? Nothing? How about redirect?
No redirect, Your Honor.
Okay. All right. So let's move on. I think do we have witness Jester available now?
I see him on the Zoom, just if we could confirm that he's here. But I'd also request just a very brief bio break.
Okay, so can we do a 5-minute break? Will that work for everybody? All right,
Yes,
so
for me.
1:35, let's keep it quick, and we'll get back with everybody in the next round here. Thanks.
Yes. And Dr. Newmark, I am here available.
All right. Well, Doctor New, I've never been called doctor before. I hope no one seeks any services for me as a doctor. All right.
Judge Newmark, I have to jump off at 2:00. So Attorney Westerberg will be handling rest of our testimony here today, but I just didn't want you to think like I'd fallen off or was in the way to room or anything like that. So
all right, I appreciate you mentioning that, and thanks for being here with us. I'll see you next time. So hopefully we'll not see you on this case again, but we'll see. All right, take care. Witness Jester, I see you there. We've spoken about this before. Any way you can turn off your background? Not that I don't enjoy looking at that, but
Give me a moment.
okay. All right, thanks. Okay, do we have everyone we need?
Oh, just so you all know, I have no threats on my device.
Okay, good.
Why did that just pop up now? I don't know.
Well,
Running things well, and I'm not paying attention.
Better than someone freezing your computer at the moment. All right.
That's called too many hits of the keys. I'm kidding.
So let me get situated here. All right, so we have Witness Jester. Let me swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead, Attorney Cordy.
Good afternoon, Mr. Jester. Could you please state your name for the record?
My name is Douglas Jester, Jester.
And Mr. Jester, are you the same Douglas Jester that prepared and caused to be filed direct, rebuttal, and surrebuttal testimony and associated exhibits Jester 1 through 13 in this docket?
Yes.
To the best of your knowledge, are the answers you provided in your pre-filed testimony true and correct?
Yes.
And if you were asked the same questions as in your pre-filed testimony, would your answers be the same today?
Yes.
Do you have any corrections to your testimony?
I do not.
Thank you, Mr. Jester. Your Honor, the witness is available for cross.
All right. I think the applicant had some questions.
Yes. Good afternoon, Mr. Jester. My name is Joe Wilson. I'm a lawyer for the applicant. How are you?
Well, thank you. Good afternoon.
Good. I reviewed your biography, and I must say it's quite varied, and you've certainly had a very interesting career. Are you a licensed professional engineer?
No.
And do you have an engineering degree?
Yes, one of my master's degrees is in industrial engineering and operations research.
I'm sorry, industrial engineering and
Operations research.
thank you.
You testified in your surrebuttal testimony that you're a former manager of data centers. Is that right?
Yes.
What data centers did you manage?
For most of the decade from 2000 to 2009, I was employed by what was initially WorldCom, a company which went bankrupt, was reorganized as MCI, and then purchased by Verizon. In that capacity, I headed a business unit that did large-scale systems integration and business process outsourcing. And within my business unit, there were 3 data centers, all owned by that company in its various guises. And those were operated under my supervision.
Do you know the size of those data centers and megawatt demand?
It is long enough ago that I can't tell you exactly. My recollection is that they were on the scale of 40 or 50 megawatts. They were pretty large for the time. And that would be each.
You've never managed a data center campus on the scale of the Microsoft or Vantage facilities that we're talking about in this case, have you?
No, few people have, especially until recently.
Mr. Jester, in your testimony before, you stated that Wisconsin Electric's strategy to use bespoke resources and direct assignment of costs is directionally correct. Is that right?
Yes.
You still believe that today?
Yes.
And you further testified that Wisconsin Electric's approach generally serves to isolate and identify costs caused by a VLC and facilitate direct assignment of those costs to the customer, correct?
Yes,
And do you still believe that today?
I do.
Would you agree that without the VLC and bespoke tariffs, there would be a greater potential for cost shifting to non-participating customers than with them?
Yes.
And would you agree that the proposed tariffs provide protections to non-participating customers that do not exist under the CP1 tariff?
Yes.
I want to talk about the threshold for eligibility for the tariffs. You recommended lowering the VLC threshold from 500 megawatts to 100 megawatts. Is that right?
Yes, it is.
You didn't perform any independent economic analysis to determine what threshold would be appropriate for Wisconsin Electric's system, did you?
No.
You didn't conduct any production cost modeling to support your recommended threshold, right?
Well, I did not, because I don't think that production cost modeling is relevant to the question.
Did you evaluate the administrative feasibility of applying the tariffs that have been proposed to customers as small as 100 megawatts?
I did conceptually, yes.
What does that mean?
The company's argument was that the administrative and general costs associated with customer operating under these tariffs would be, in, as I recall, the company's language, too large to be supported by customers smaller than 500 megawatts. I think first that the scale of support for a 100 megawatt customer might not be the same as 500 megawatts. I did not undertake to calculate what that might be, but I also looked at the tariff as providing protections to other customers, and that if those were necessary, it would still be appropriate to have a 100 megawatt customer pay those administrative costs in order to be under this tariff. So that's the way I looked at it.
You didn't attempt any sort of break-even analysis to determine what size of customer might be able to support the administrative costs embedded in these tariffs, did you?
No.
Isn't it true that Wisconsin Electric has offered a compromise position to make the tariffs mandatory for customers above 500 megawatts while allowing customers between 250 and 500 megawatts to opt in?
I read that proposal in Mr. Stasik's testimony.
Do you believe that
testimony?
I'm sorry.
I was just clarifying that it was in the Surrebuttal testimony.
Do you believe that potential modification of the tariff is directionally correct?
I do believe it's an improvement. I would prefer that it go further.
Talk about the insufficient capacity charge, okay?
Okay.
You had initially supported potentially a reduction in the 100 megawatt curb on that insufficient capacity charge. Is that correct?
Yes.
And you later amended your recommendation to advocate eliminating the curb altogether. Is that right?
I want to be specific that it was to eliminate the allowance for 100 megawatts of capacity allowance in excess of that where it was acquired as bespoke resources. Yeah.
Thank you. Did you conduct any economic modeling to study the impact of eliminating that 100 megawatt allowance on VLC operations or costs?
No.
Did you conduct any economic analysis to study the impact of eliminating that 100 megawatt allowance on non-participating customers?
I didn't do any calculations of, dollar values. The issue here is who's responsible for the costs, not whether the costs would be incurred. So the nature of the analysis is not what would it cost, it's who pays.
And you have not done any economic analysis to show that the existence of this 100 megawatt allowance would in fact shift costs to non-participating customers, right? It's a hypothesis.
A persistent gap of 100 megawatts between the firm capacity required by VLC and what that VLC supplies or pays for WEPCO to supply as bespoke resources would mean that someone is owning the additional 100 megawatts of capacity, whether it be WEPCO, with it being paid for by non-participating customers or other MISO market participants.
And whether that imposed a cost on non-participating customers would depend on the relative cost of owning capacity versus buying energy in the market, right?
You said buying energy in the market, and
or acquiring capacity in the market, excuse me.
Yes, it would. Correct. That's where I was going.
Right. Would you agree that some flexibility is needed to account for unpredictable planning and permitting and construction timelines that may be out of a eligible customer's control?
Yes, and I testified that I thought that having a period such as the 36-month period proposed by WEPCO in this case, where there could be a non-persistent gap that's shorter than that, made good sense to me, but that it should be limited to situations where it is due to those kinds of timing and planning issues rather than a failure to plan for adequate bespoke resources.
Would you agree that large generation resources come in discrete sizes and take time to build, plan, acquire, and place in service? And this is sometimes referred to as lumpiness, right?
Yes, although I believe the company's testimony about lumpiness is misleading.
And would you agree that it's difficult and maybe impossible to exactly match changes in demand with resource additions in real time?
Yes.
You recommend eliminating the capacity-only variant of the bespoke resources tariff, is that right?
Yes.
You have not provided any quantitative analysis demonstrating that capacity-only bespoke resources would harm non-participating customers, have you?
No.
With respect to the 75-25 split for the cost of capacity-only resources. Have you reviewed Mr. Stasik's rebuttal testimony, in particular the proposal he makes with respect to potential changes to that allocation?
Yes, I have.
Would you agree that the changes to the bespoke resources tariff that Mr. Stasik discusses in his rebuttal testimony would address the uncertainty about the fairness of the allocation to both VLCs and non-participating customers?
I view them as an improvement over the prior proposal, but there are some remaining questions and risks to the costs that would be allocated to non-participating customers.
On balance, do you support Mr. Stasik's proposal as compared to the tariff as filed?
As compared to the tariff as filed, yes.
Are you familiar with Wisconsin Electric's economic analysis, which projects that non-participating customers will realize?
I'm sorry.
Sorry.
It got garbled for me. I don't know why.
Yep.
Can you start that over?
Are you familiar with Wisconsin Electric's economic analysis that shows that non-participating customers will realize net present value savings in 80% of the scenarios for Red Oak Ridge and 67% of the scenarios for Foundry Ridge?
I did read the testimony on that topic by witness Shilendranath and witness Karlikowski.
Do you have any basis to dispute the findings of those modeling runs?
No.
And you understand that Wisconsin Electric has committed to only offering resources as capacity only if they show net benefits to non-VLC customers, right?
I do understand that that is the representation that WEPCO has made, yes.
And you understand, correct, that the commission will have the opportunity to evaluate each specific capacity only resource in separate dockets and proceedings before approving them, right?
Again, that's what I understand to be the company's representation. I don't have any other knowledge of it.
And you understand that among the questions the commission will consider is whether the resource is justified as a capacity only or full benefits resource, right?
Yes, I both read that in the company's testimony and heard it discussed yesterday.
And you don't have any basis to dispute that that's what's actually going to happen, do you?
No.
I'd like to turn to your recommendation about behind the meter resources and wind resources from outside MISO zone 2. You would like to see those available as bespoke resources. Is that fair?
Yes.
Would you acknowledge that there are capacity basis risk, energy basis risk, and catastrophic disruption risk associated with resources located outside of MISO zone 2?
I'd like to sort of take them one at a time. MISO's capacity market uses the local resource zones, such as LRZ2, as units of analysis. And if capacity is in a different zone, there could, under certain circumstances, be either a higher cost or an inability to count that capacity as meeting WEPCO's obligations under the MISO resource adequacy construct. So on capacity, the answer is yes, but only under certain conditions. And specifically, it would be if the local resource requirement in zone 2 could not be met. That would arise only if there was enough capacity being imported to overwhelm the capacity import limit identified by MISO. Energy is not, the energy market is not operated by MISO with respect to the zones. It is modeled on the transmission network, and they do not take account of the zones in any respect. So there's nothing magical about whether it's in or outside of the zone in thinking about whether there might be a basis risk. And then I'm sorry, the third.
Catastrophic disruption risk.
Yeah. That is a sort of, complicated question because there are so many ways of having catastrophes. In recent experience, the most risky conditions in MISO for being able to meet demand have been large storms causing an imbalance of supply and demand within MISO, which has been resolved by importing over the transmission network over long distances. And so in that sense, the use of transmission has been the protection against catastrophe rather than the cause of catastrophe. In general, transmission itself is highly reliable. So any difficult conditions in zone 2 are likely to be the result of either of demand and supply imbalances, and therefore likely to be helped by transmission.
So are you saying that there is not a catastrophic disruption risk for resources being imported from outside of zone 2 into zone 2?
I do not see it, no.
Okay. Could you please pull up page 15 of Mr. Jester's surrebuttal testimony? Mr. Jester, on line 5 of page 15 of your surrebuttal, you're talking about Mr. Arndt's testimony, and you said that he specifically cites capacity and energy basis risk and catastrophic disruption risk as reasons not to consider resources from outside zone 2. Do you see that?
Yes.
Let's go to line 12, where you say, in response to witness Arndt, all of those risks are valid consideration. You see that?
Yes.
So I believe you just told me in the last 5 minutes that energy basis risk and catastrophic disruption risk are not valid considerations. Is that right?
No, not at all.
Okay. You're going to have to clear this up for us then.
Right. I agree that those risks are valid considerations in WEPCO's planning. I do not agree that they're associated with whether the supply resources are in zone 2 or outside of zone 2.
No. Line 7. You recite Mr. Arndt's testimony in which he says these are risks with resources outside of zone 2. And then in line 12, you say you agree that those are all valid considerations.
A valid consideration in my mind does not mean that it is so. It's something to think about. It's a consideration.
I'm sorry, does not mean that it is
So.
Oh, okay.
Yeah.
So your testimony is that they're valid considerations, but also not valid considerations.
I didn't say not valid considerations. I said that I didn't assess them as being risks that are associated with whether the resources are in or out of zone 2. Let me give a specific example just to clarify the point. As I look at the transmission maps of the United States, as I understand the capacity of the transmission system in various places, I will tell you that I believe a wind farm in northeastern Iowa presents a lower risk to WEPCO's power supply than a wind farm in Michigan's Upper Peninsula. Michigan's Upper Peninsula is part of Zone 2. Northwest Iowa is part of Zone 3. Northeast Iowa is part of Zone 3. It's not about the zones, it's about the network.
Be familiar with WEPCO witness Nelson's testimony about the costs that would be incurred by non-participating customers if the VLCs took service under the CP1 tariff?
Yes.
And he estimated that cost at approximately $1.5 billion on a certain set of parameters, correct?
Yes.
Do you have any basis to disagree with that estimate?
No.
So would you agree that the VLC and bespoke tariffs are necessary to prevent cost shifting that would otherwise occur if the VLCs took service under the CP1 tariff?
I do. I would say that it's possible that in some future rate case, the cost allocation methods used to allocate costs to various classes or rate schedules could be modified in an attempt to correct that problem. But I have said from the beginning that I think this approach, as proposed by the company, is a superior approach to solving the problem of fair cost allocation.
Would you agree that rejecting these tariffs would not prevent large loads from coming to Wisconsin, and it would just mean that in the absence of some other data center specific tariff, they would take service under tariffs that exist and would provide fewer protections to non-participating customers?
I think that is probably correct. The testimony from the erstwhile VLCs indicated that their interest in Wisconsin was in part because tariffs like these would enable more rapid location and development, and I'm not sure that that would happen in the scenario that you described. But in general, I would say that yes, this is better for non-participating customers than those customers coming in under CP1.
That's all I have. Thank you.
You're on mute.
I don't know how that happened. I think I sneezed and I turned it off. All right. Any cross? No? Any other cross? Redirect? Okay. Thanks very much.
Sorry. Your Honor, I did.
Okay. You weren't on mute. Okay.
Yeah. That was quick.
Yeah. Go ahead. That's right.
Mr. Jester, in your cross-examination, you described WEPCO's testimony about lumpiness as misleading. Could you explain why you view their testimony about lumpiness misleading?
Yes. First, that testimony was in support of a 100 megawatt size, that somehow related to the lumpiness of resources. The natural unit of nominal capacity for rice engines and for storage battery energy systems is about 20 megawatts. You also can acquire combustion turbines on that scale. The scorekeeping here is in terms of accredited capacity. And so a 100 megawatt solar or wind farm would have accredited capacity on the order of 20 megawatts. And the tariff provides for bespoke resources to be split between a VLC and other VLCs or non-VLC customers, so that there can be fractional ownership even within something as small as 20 megawatts. And finally, the capacity requirements are structured so that if the bespoke resources happen in a given year to exceed the requirements of the customer, then that capacity can be sold into, or can be transferred to non-VLC customers if WEPCO has that need, or it can be sold into the MISO capacity market, and the revenue from that would come back to the VLC that for whom that is a bespoke resource. So the economic loss from being over in a given year is not necessarily large, and the amount of deviation from the required level of firm capacity that is driven by what is characterized as the lumpiness of these resources in no way justifies 100 megawatts.
Thank you. No further questions.
All right. All right. Thank you, sir. You're excused.
Thank you.
And let's go off the record. So it looks like we have 2 more witnesses from the interveners. Am I getting that right? And then 2 from staff. So let's take a 10-minute break and get back with our intervener witnesses. So we'll go in order. I think it's Vantage and then Walnut Way. So 10 minutes, roughly, what is it, 2:17, 2:18, be back. All right. Looks like we're back on track here and have our witness available. Thank you. So let's get started. We're going to call witness Phillips, and we have you there. So let me swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right. Go ahead, Attorney Brewer.
Actually,
not
Your
my
Honor,
witness.
that would be my witness.
Oh, I'm sorry. What? No. How could I get that mixed up? Oh boy. Okay. Go ahead, Attorney Maluli.
Thank you, sir. Mr. Phelps, could you state and spell your name for the record?
My name is Nicholas L. Phillips, Nicholas. Last name is spelled Phillips.
And did you prepare, or was prepared under your direction, direct rebuttal and one exhibit for this proceeding?
Yes, I did.
And is that testimony and the exhibit true and accurate to the best of your knowledge?
Yes, sir, it is.
And if I asked you those questions today, would your answers be the same?
They would.
All right. Your Honor, Mr. Phillips is available for cross.
All right. I have Walnut Way signed up, so why don't we start with you? Go ahead.
Thank you, Judge. After this witness, I may need to disconnect again because I'm still having a few Zoom issues, but I think I'm good for the moment.
Okay, yeah, we'll play it by ear.
Thank you. Good afternoon, Mr. Phillips. I'm Krista Westerberg. I'm an attorney for Walnut Way. I do have a few questions for you about your direct testimony. But before we get to that, can you tell me, first of all, you're not an employee of Vantage, correct?
No, I am not.
You were retained by Vantage to testify in this docket, is that correct?
Yes, I was.
Do you recall approximately what date you were retained by Vantage to testify in this docket?
My firm was retained by Vantage, I believe, around August of 2025. When the exact decision was made to sponsor testimony, I do not remember.
Thank you. Have you consulted for Vantage before in other states?
I personally have not. Our firm has represented Vantage in other matters.
Okay. Thank you. Have you personally worked on large load issues before?
Yes, I have.
And have you worked on integrated resource planning?
Yes, I have.
Were you here for the testimony of Mr. Stasek yesterday?
Yes, I was.
Okay. And there were some questions that I posed to him about Vantage's, when they were involved in discussions with WEPCO. Do you have any basis to disagree with the timing that Mr. Stasek testified to?
I have no basis to disagree.
And basically, is it your understanding, but that by the time Vantage started discussing the tariffs with WEPCO, they were more or less fully formed?
That is my understanding.
Do you know if Vantage has a position on whether it should be permitted to use behind the meter generation, virtual power plants, demand response, or other non-carbon options?
Could you clarify what you mean by other non-carbon options?
Well, how about stick to the three examples that I provided?
I have not had specific discussions with about those resources with Vantage as they would relate to the portfolio of Bespoke resources.
Okay, thank you. I'm going to refer to page 8 of your direct testimony. And you were talking on lines 13 to 17 about that Vantage is investing a minimum of $175 million to make critical regional infrastructure upgrades. Do you see that?
Yes, I do.
And is it your understanding that those upgrades are being implemented in a tax increment financial district created by the city of Port Washington?
I have been made aware of that through the discovery process, yes.
Okay. Is it also your understanding that while Vantage is paying for those upgrades, it will be reimbursed by the city of Port Washington for those upgrades?
There was a discovery response regarding this. I would like to review the discovery response if it's available. My recollection is that that reimbursement only occurs under certain conditions, and that Vantage is fully funding all of the investments up front on its own.
The witness referred to a discovery response, Judge. That is one of the documents we emailed yesterday or on Wednesday at 1:30. If we could pull that up, please.
And which one is that?
It was the Vantage response to Walnut Way 1 Walnut Way 10.
Okay.
Mr. Phillips, is the document that's just been pulled up on the screen the discovery response you were referring to before?
Yes, it is.
Okay. And you were one of the people who answered that response?
I was sponsoring it as the witness in the case. The majority of the input was developed by the internal company representative listed.
Is that the Scott Wright who's on the line with you there on the answered by line?
That's correct.
Okay. And is it your understanding based on this response that Vantage would be obligated or that Vantage would be entitled to be reimbursed the cost that it is fronted for that $175 million infrastructure investment under these circumstances described here?
Yes, the last sentence of the response states that to the extent the improvements in the lighthouse actually generate tax increment.
Okay. And do you know if Vantage would be entitled to interest on its the amounts that it is fronted if it is reimbursed? Sorry?
I do not.
Okay.
I do not know.
Okay, sorry about that. I didn't mean to step on you. Okay, that's all I have for this witness. And can we move admission of this exhibit, please, Judge?
I don't know if it's really going to be that useful. I mean, we did get the answer from the witness. Is there something significant here that we need to document for?
I can get by without it, Judge. That's fine.
Okay. Yeah, that'd be fine. Thanks. All right. So other cross? No, redirect?
No, Your Honor.
No, you shouldn't have taken a break. I thought this was going to take a lot longer. All right. Thank you very much. You're excused.
Thank you.
Now we are all fresh for witness Nelson. So let's take Walnut Way next.
Yeah.
All right. Try to move people, but it's not letting me. Here we go. Huh. All right. That'll work. All right. Witness Nelson, I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead, Attorney Westerberg.
Thank you, Judge. Mr. Nelson, would you please state your name for the record?
Ron Nelson?
And you are testifying on behalf of Walnut Way Conservation Corp., is that correct?
Correct.
And are you the same Ron Nelson that submitted direct, revised direct rebuttal and surrebuttal testimony in this proceeding?
I am.
And did you
can I just interrupt, Mr. Nelson? Can you move your screen up so I can see more of your face, please? Or down?
That?
That's good. Thank you. Sorry about that.
It's okay.
Mr. Nelson, did you also sponsor exhibits 1 through 40 and a corrected version of exhibit 1?
Yes.
And are those, is the testimony true, and the testimony and exhibits true and correct to the best of your knowledge?
Yes.
And as you sit here today, would you give the same answers as you did in your written testimony?
Yes.
If I may, Judge, I have just a very brief amount of sir rebuttal.
Go ahead.
Mr. Nelson, were you present yesterday for the testimony of WEPCO witness Schlindrath when he was responding to pages 15 to 16 of your sir rebuttal testimony?
I was.
And did you hear him talk about the answers that you had provided about projected capacity in the MISO market?
Yes.
And do you have a response to his testimony?
Yeah, I have a high-level response.
Okay.
The witness's testimony doesn't change my position and the point that I'm making, that there's a lot of massively changing variables right now. Having provided testimony in several large load dockets and evaluating utility forecasts over the last probably 2 years, we're seeing significant changes and downward adjustments to some of the large load forecasts. So I think that's important to note when we're looking at modeling assumptions.
Okay. Did his testimony change any of the conclusions in your sir rebuttal about forecasts in the MISO market and the resource mix evaluated by the applicant?
No.
And then have you also had the opportunity to review Mr. Stasik's sir rebuttal testimony that's been referred to several times, I think yesterday and today, at page 5 about the modification to the 75-25 split as to capacity only bespoke resources?
I have.
And do you have a response to our position on that?
I do.
Okay. What is your response to that proposal?
The proposal still doesn't address significant concerns that I have with the proposed tariffs. For example, it still doesn't address the need to be looking, at a broad, cost-effective portfolio that includes more comprehensive sets of resources, including demand response and behind-the-meter resources. It also still does not address the potentially billions of dollars of socialized transmission costs.
Those are the only questions I have on that. The witness is available for cross.
All right. Do we have cross? Looks like WEPCO signed up, so we'll start with them.
Thank you, Your Honor.
Right.
Mr. Nelson, my name is Patrick Proctor Brown. I'm an attorney for the applicant, Wisconsin Electric Power Company. Have we met before? I don't think so.
I don't believe so. Good afternoon.
Nice to meet you. Thanks for being here this afternoon. I want to start with the development of your testimony. First off, did Mr. Butts reach out to you first to hire you, or did Miss Westerberg?
I believe it was Miss Westerberg. I'm not sure I recall who originally reached out.
Have you worked with Miss Westerberg in different cases?
No, I haven't.
Have you worked with Mr. Butts in other cases?
I have not.
Have you met Mr. Butts or any employee of Walnut Way?
Yes.
In person?
On video.
Did you develop your testimony independently, or did you develop it in collaboration with the employees of Walnut Way?
Objective form.
Oh, in what way? Can you explain that? I don't know if we know what you mean by that.
Is that to me or to
Attorney Westerberg? What's your basis for your claim to forum objection?
I don't know exactly what's meant by collaboration and collaboration with.
Okay.
Mr. Nelson, do you know what the word collaboration means?
I also don't. I'm not really clear on what you mean.
Okay. Did you?
I can explain how normal consulting projects work, if that's
I don't
helpful.
need to hear about normal consulting projects. I'm asking about this project. Did you discuss the subject matters that you should testify about with Mr. Butts or any employee of Walnut Way?
Yes, that's necessary for contracting.
Okay, so Mr. Butts and Walnut Way decided what topics you should discuss, or Ms. Westerberg did?
I do not recall.
Did Mr. Butts or any employee of Walnut Way provide any edits to your testimony?
Not that I recall.
Did you send your draft testimony to Walnut Way, or did you just develop it with Ms. Westerberg?
I believe Walnut Way was CC'd.
Did you discuss the testimony with them, or did you just keep them on copy?
Can you clarify? Are you saying, did I discuss the drafts?
Yes, did you discuss the drafts?
I don't recall each meeting that we had and whether it was to discuss a draft or other issues within the case.
So I take it you don't recall whether your Walnut Way had any specific ideas about how your testimony should be submitted in this docket. Is that true?
No, I mean, I had discussions and then I proposed topics to include in my testimony.
But then you drafted it and you don't recall any communication, any specific topics, any specific feedback that you got from Walnut Way in your testimony.
I don't believe that I received any red lines from Walnut Way, but that would be subject to check.
Did you receive any feedback at all?
I'm not sure that we discussed it, frankly. I was in an accident in December, and so the deadline was of me getting the draft was probably a little late. So I don't know if we had a meeting after I got the draft to him or not.
Did you have a meeting with Ms. Westerberg?
I'm pretty sure that I did.
Did you receive red lines from Ms. Westerberg?
I received at least comments.
And you addressed those comments?
Yes.
But fair to say you received input on your testimony from Ms. Westerberg, and you don't recall receiving any input on your testimony from employees of Walnut Way. Is that true?
Again, objective form, are we talking about the drafts or the finals?
Either. He said he doesn't recall any input from Walnut Way.
The input from Walnut Way was early on.
Before you developed any drafts or submitted any testimony. Is that fair?
I think that is fair.
Did you ask employees of Walnut Way about their discussions with BLCs related to community benefits programs?
I believe I asked if they had ever, if any of the BLCs had ever reached out to them.
What was the answer?
I believe the answer was 1.
Did you inquire about the content of those discussions?
No.
Did it matter what the VLCs had already offered to Walnut Way?
I'm not aware.
No, did it matter to you what they offered?
I'm going to object to this line of questioning, Judge. I don't understand the relevance to the testimony.
He's submitted multiple pieces of testimony on community benefits agreements, and I want to understand if if it even mattered to him what the discussions to date have been.
Yeah, I'm just beginning to understand your line of questioning, so I'll let it keep going. So go ahead.
Did it matter to you what communications had already happened before you submitted testimony talking about community benefits agreements?
My testimony was on community benefits agreements from other areas and how they could be applied in this circumstance.
Yeah, but that's not my question. My question was, did it matter to you what discussions had already happened between the VLCs and Walnut Way?
I figured if it was material, it would be brought to my attention.
So you just relied on Walnut Way to decide whether it was material. You didn't actually ask about it. Is that right?
I believe I've already answered that question.
I'm clarifying. You believed that if it was material, Walnut Way would provide that information to you. You didn't actually ask for it. Is that your testimony?
I asked Walnut Way if any of the VLCs had reached out to them. And that was the end of that discussion.
You didn't ask any follow-up questions about those discussions. Is that true?
I'm not engaged with them to discuss any of these issues with the VLCs directly. I'm testifying in this case.
How did you come up with $30,000 a megawatt?
I backed out of the Google deal that was done in Arkansas.
So
Roughly.
just the Google deal in Arkansas? That's the basis for 30,000 megawatt?
Well, I believe that Amazon just did $1 billion in Illinois or Indiana. So I think it would be much higher if that was included. But that was the main basis to drive a number.
Okay, and neither one of those agreements were forced on those companies by the Public Service Commission in those states. Is that true?
Objective form by forced on, do you mean in an order?
I think that would be one way that it could be forced on them, but it's within his knowledge. He just testified to it. Was they ordered to? Were they forced by a Public Service Commission to enter those deals?
I am not aware of whether those two deals were required. PPL is now requiring 10 million for their large load customer class.
I'm sorry, what's PPL?
Pennsylvania Power and Light.
So the utility.
Yes, they proposed that in their recent filing.
Okay. It's proposed, but it has not.
It's a.
I'm sorry, I didn't hear the rest of what you said, Judge.
It's proposed, but not approved by the, is it Public Utility Commission in Pennsylvania?
It is ongoing. It's an ongoing case. It is, Sir rebuttal has been filed. And PPL has proposed that the large load class that they are proposing be assigned 10 million in universal service charges, even though they're connecting at the transmission level.
Okay. All right. Thanks.
Did you talk about those deals with Walnut Way?
Can you be more specific? Or?
I believe you've referenced 3 different out-of-state community benefits arrangements. Did you discuss any of those 3 with Walnut Way?
Yeah, I probably brought them up. Probably not the PPL, and maybe not the Amazon. And I'm not even really sure that I had these conversations directly with Walnut Way. I mean, just to be clear, of my lack of clarity is that Walnut Way was not in all the meetings we had about the case. So creating a difference between when they were and were not there is the challenge that I'm having.
Okay, you started out saying I probably brought it up with Walnut Way, and then you said
probably brought
probably
it to
not.
Arkansas.
Yeah, hang on.
Hang on a second.
Can't talk over each. We're going off the record. Please let attorney ask the question, and then we'll get the answer. We'll proceed in an orderly fashion. We'll get everyone's words on the transcript, but let's proceed with respect and some dignity in the process. Okay. Let's get back on and go ahead, Attorney Patrick Proctor-Brown.
Thank you, Your Honor. So I believe you just testified you probably brought it up with Walnut Way, and then you said probably not the PPL deal, maybe not the Amazon deal, and then you were just generally confused about who was in the various meetings you had. Is that a fair summary of what you just testified to?
I'll clarify. I'm saying that we had several meetings about the case. Walnut Way was in some of them and not others. So you're asking me if I shared it with Walnut Way. That is why it's challenging to answer your questions. Because I don't remember what meetings they were in and were not in. I would assume they were aware of the Google project or the Google fund. I don't know if they were aware of the Amazon, and they probably were not of the PPL.
Okay. I don't want you to assume or speculate. I want to know your personal knowledge, your personal memories of what you discussed with Walnut Way. Are we on the same page here?
Yes.
Okay. Do you
Can I
have a
see
recollection?
I'm sorry, I just want to interrupt. If I can see a clarification, Attorney Proctor Brown, you're making a distinction between Walnut Way, the organization, and then the Walnut Way's attorneys representing Walnut Way in this case. And when you say Walnut Way, are you making that distinction?
I am.
Okay, and
Mr. Nelson,
go ahead.
what's the basis for that? I want to understand.
What's the relevance of that is my question.
I think the relevance is that they're the organization that's here. Our supposition is that they haven't necessarily been involved in what's happened in this case, and I want to explore that supposition. I think it's relevant to the positions that Mr. Nelson has taken. If they're directed by Walnut Way as an organization, or if they're directed by their attorneys.
Judge, I would agree. I think the basis for Mr. Nelson's testimony is in his testimony, and there's a number of attachments and exhibits to the testimony that explain the basis for how he arrived at his conclusions on community benefits. I don't know whether the testimony, and I think he's answered the questions as best he can at this point about who he discussed the aspects of the testimony relating to community benefits agreements with. So I'd object to the continued line of questioning.
So I want to get what's probative into the record. I'm just concerned, and maybe other interveners or staff can help me understand if there's a distinction with a difference between saying the organization and the attorney representing the organization, while the attorney is working for the organization in order to create in its participation in the case. I've never really seen that to be a situation where that matters so much, but I'm just not sure if we need to parse out whether the witness talked to an employee of Walnut Way, or if talking to Walnut Way's attorney who's working on behalf, the legal representative of Walnut Way, as maybe an intermediary. I guess it doesn't really matter if an attorney is developing testimony with a witness on behalf of an organization or a company, why we need to know whether the company is, I guess we assume that attorney is representing the company. So, or is there something I'm missing here?
Yeah, Your Honor, I think what that's missing is that Walnut Way received intervener compensation because of what they thought they said.
I'm sorry, who received?
Yeah, I'm sorry, I went too fast.
No, I just didn't hear what you said. Oh,
Walnut Way. Yeah, Walnut Way received intervener compensation based on a representation that they're bringing something specific, some specific perspective. And if this witness never talked to Walnut Way, right? If it's all we're getting is an attorney's perspective and a consultant's perspective, I think that's not a useful use of intervener compensation, for one. And I think I'm entitled to explore some of that, particularly when he's talking about community benefits. And you would expect a community benefit program to at least talk to the community organization that he's purporting to represent. To Ms. Westerberg's point about who's testified to the best of his ability, I don't think I've even asked the follow-up question to understand his complete knowledge. He's never said that he's testified to the extent of his knowledge on these questions so far.
But Judge, I mean, if Mr. Pacterbaum has questions about the intervener compensation, there's a separate intervener compensation docket for that. I think Mr. Nelson did testify that he spoke with Walnut Way, and to the extent that other communications may have occurred with counsel involved, I think that invades attorney work product and potentially attorney-client communications. The fact that Walnut Way was not on a particular call doesn't mean their view was not represented. So I remain concerned about this line of questioning. I don't understand. I'm sure that WEPCO will seek rate recovery for its attorney's time in this case. So but I've not asked questions about attorney time and how that's being spent of WEPCO's witnesses.
I haven't asked any questions about attorney time at all. I've asked about Mr. Nelson and whether he inquired with the community organization he purports to represent about the community benefits agreements he wants to require as an element of this case. I think that's pretty fair game.
So I'm sorry. Let me just ask it. I mean, if we have other interveners here, does this issue pose any? Can I get any?
Judge, this is
their perspective. Okay, go ahead, attorney.
Daniel Narvey here for Cub. I mean, over our history, we've had in-house counsel and we've had outside counsel. The applicant has outside counsel. Most of the interveners here have inside counsel, but Walnut Way has outside counsel. I mean, I don't think that there's any meaningful difference between parties being represented by inside counsel or outside counsel. So to the extent that they're trying to draw the distinction between Walnut Way's attorney versus the client.
I haven't asked any questions about attorneys. To be clear, I haven't asked any questions about communications with attorneys. No questions about attorneys. I don't know where that's come up.
All right, let's just go off the record for a second. Okay, it's back on the record. Anyone else wish to share a perspective on this? No. Oh. Okay. So, yeah. So far the questions do not inquire into attorney privilege information, as far as I can tell. I don't think that's where we're headed, and I'm not afraid of dealing with that if necessary. But I guess I'm just not seeing the distinction between talking with an organization or talking with the organization's attorney. I think it's pretty typical that an organization that hires an expert in a proceeding such as this is going to be communicating primarily with the attorney to design and frame the testimony. That's what I've seen with years of practice. So I don't think it's surprising or really needs inquiry in this docket. I mean, Walnut Way's presenting what it wants to present. If the commission feels like this did not add value to the proceeding, I believe our administrative rule PSC3 can deal with that issue in terms of what amount of money gets dispersed to the organization. But that's on the face of the information provided, not on how the information was created. There may be an issue. I think maybe the thrust of the applicant's questioning is that if there is a proposal for community benefits here, but the Walnut Way is ignoring it somehow, and why is it doing that in its testimony? Why isn't it addressing it directly? Why is it proposing other community benefit programs instead? And I think that's valid. That's totally in the record and can be vetted. But I don't see that we're benefiting at all anymore from looking at how Walnut Way got to its position. Its position is before us, and if the applicant or anyone else wishes to scrutinize that at this time, feel free to do so on the merits, on the as it appears in testimony. So let's proceed with that.
I just want to understand that a little bit better, Your Honor, because we've had a lot of cross-examination about the tariffs and the negotiation of the tariffs.
Mm-hmm.
Mr. Nelson was retained, at least on its face, by a community benefits organization. So you would think the best information about how to implement a community benefits program might be with his client. And that's all I'm getting at here. I think we've spent more time arguing about it now than the questions would take. But I just want to understand what the scope of his discussions about a community benefits agreement were with the actual community organization. Does it make sense to them? Did he inquire about it? That goes to the credibility of his testimony and the basis of his proposal.
Okay, well, they filed his proposal, so that's their position. You'd have to assume that for now.
He's right here, Your Honor. I don't understand why I can't. I don't understand why I can't.
Because it's my ruling. Because it's my ruling. We're going to move on.
Okay. Thank you, Your Honor. Mr. Nelson, you acknowledge in your surrebuttal testimony that you are not a lawyer, correct?
Correct.
Despite that acknowledgement, your testimony offers legal interpretations of WSTAT 196.192(2)BR, doesn't it?
Can you point me to the page, please?
Page 3 to 4 of your surrebuttal talks about that and continues from there. Three to 4. Your Honor.
I do offer some non-legal interpretation.
What is non-legal interpretation of the statute?
I do it in many proceedings.
Okay.
I'm not a lawyer, so I wouldn't. So it's not a legal interpretation.
Okay. So you're not a lawyer. You're just reading the language. Is that what you're saying?
Yep. Reading it and interpreting it.
Okay. You have not submitted to this commission any economic modeling quantifying the dollar amount of the alleged harm to non-participating customers from the proposed tariffs, have you?
I did not do any independent quantitative analysis.
Would you agree that Wisconsin Electric has a statutory obligation to serve all customers in its service territory, including the VLCs?
Yes.
If the VLCs are not served under the proposed tariffs, they would take service under the existing CP1 tariff by default, right?
That is the current option, but there are many other possibilities.
Many other possibilities that would require new tariffs being approved by the commission, right?
Yes.
The only tariff available to the VLCs right now is CP1, correct?
That is my understanding.
You have not performed any analysis comparing the costs to non-participating customers under the proposed tariffs versus if the VLCs were served under the CP1 tariff, have you?
No.
But you're aware that Wisconsin Electric's analysis shows that absent the proposed tariffs, non-participating customers would be allocated approximately $1.5 billion in additional generation plant costs if VLCs took service under CP1, right?
If there was no other action taken, yes.
You have not presented any quantitative analysis to rebut that figure, correct?
No.
Is it fair to say that your testimony asserts harms to non-participating customers without calculating whether those harms exceed, equal, or fall short of the benefits the tariffs provide, right?
Objective form, the economic benefits of both the very large customer and bespoke resource tariffs. Current, like, are we over what time frame?
Have a time frame. I don't think there needs to be a time frame.
Okay.
Is that you're still
Do you need the question read back, Mr. Nelson?
Please.
Do we still have an objection or not?
It sounds like there is no time frame, so if the witness can answer it as phrased, then I don't have an objection.
Okay. So did the witness want it read the question read back?
Please.
Okay. Let's do that.
Question, is it fair to say that your testimony asserts harms to non-participating customers without calculating whether those harms exceed, equal, or
Fall short of is what I
was
meant to
just going to
say.
say fall short. I have authority, but it's fall short of the benefits the tariffs provide. One key different. Do you need that again, sir?
Oh,
Do you need that again?
no, that's fine.
Okay, thank you.
So the company's analysis looks over a long period of time and calculates a net present value, but the benefits to customers and the rate impacts are going to vary over time. So if you look at capacity, in that sense, the tariff doesn't address the socialized costs of transmission, and so the non-participating customers will absorb transmission rate increases. And then it's possible they can absorb some of those rate increases in the near term for generation as well, because the large customers are triggering incremental costs that increase that increase the marginal costs that all customers are paying, and their embedded rates are under that. And so, as Mr. Fisher discussed, there's going to be a break-even point at some point.
Your Honor, I didn't ask anything about Mr. Fisher's testimony. It was a pretty straightforward question, and we've gone off to somebody else's testimony. If you don't mind, I'd like to go back to my question. Is that okay?
Let's hear it, yeah.
Is it fair to say your testimony asserts harms, but doesn't calculate what those harms would be? That's my question. Do you understand the question?
There's transmission upgrades in the record that are quantified.
Did you calculate any harms that you've asserted in your testimony yourself?
No.
Thank you. Would you agree that under the proposed tariffs and service agreements, the VLCs are obligated to pay for the cost of generation resources and distribution facilities built to serve them, even if their load doesn't materialize or they cease taking service?
Under the terms proposed.
So yes.
Under the subject to the terms that are proposed by the company, yes.
You have not calculated any probability-weighted expected costs to non-participating customers across any modeled scenarios, have you?
No.
You acknowledge that Wisconsin Electric modeled nearly 3,000 distinct cases for the capacity-only bespoke resources, correct?
You're speaking to the rebuttal?
Yes. Yes, you acknowledge this in your rebuttal at 10 to 11.
Sorry, are we talking about the Gerlikowski? Could you refer to a specific witness, counsel?
Yeah, Mr. Gerlikowski presented, it's not quite a Monte Carlo analysis, but it's a scenario analysis with 3,000 distinct cases for capacity-only bespoke resources. Do you recall that testimony?
I do.
In the majority of those modeled cases, non-participating customers are projected to receive net benefits, correct?
That is the company's testimony.
In your surrebuttal testimony, pages 11 to 14, you criticize Future 3 as representing a scenario where non-participating customers do not receive net benefits. Do you recall that?
I do.
And Future 3 assumes the lowest load growth, poor economic conditions, and high inflation consistently projected over the entire 30-year study period, right?
That's my understanding.
You've not provided any independent analysis demonstrating that Future 3's assumptions are more likely than the assumptions in the other 3 planning features, have you?
No.
In fact, you acknowledge that Future 3 could be considered a stress test designed to bound risk rather than characterized expected performance, correct?
Where can you direct me to where you're?
Yeah, you cite to on surrebuttal, your surrebuttal testimony at 11, you acknowledge Mr. Gerlikowski's testimony that Future 3 is useful to stress test the model, right?
Which page, line number, Council, please? Thank you.
I didn't hear anything.
I don't know if that's correct. Just searching
Oh.
it up.
Oh, well. In any case, you're aware of Mr. Gerlikowski's testimony that Future 3 is a stress test of the model, right?
Subject to checking his testimony.
Do you have any analytical basis to claim that low load growth combined with high inflation over 30 consecutive years is a plausible scenario?
Objective form as to what analytical basis means.
Do you have any analysis of the probability of high inflation over 30 years combined with low load growth?
Are you asking me if I calculated the probability?
Yeah, what have you calculated the probability? Have you done any analysis?
Okay, hang
Wait,
on.
you can't
We're
both.
off the record. Can't be talking over each other. So I know it. You want to both do your best to make sure everyone's clarified, but please wait for everyone to speak. Let's get back. I don't know where are we?
The last question I have is, have you calculated the probability?
Is that a full question,
That's
Attorney Proctor Brown? Is that the
Probably
end?
not. I'll withdraw that one. And
You're going to withdraw it. Okay, moving on. All right, let's get back
No,
on.
I'll just withdraw that question and pose a new one.
Okay, go ahead. Let's get back on it.
Thank you. Mr. Nelson, have you conducted any analysis of the probability of low load growth combined with high inflation persisting over 30 consecutive years?
I've not conducted that specific analysis.
Can you point to any period in U.S. history with 30 straight years of low load growth, poor economic growth, and high inflation?
Not 30 years, but over on an average potentially.
On an average
But I
across
didn't-
30 years? Is that your testimony? You think there's been a period where
I'm sorry,
on
can you start
average-
that? Can you start that again? Council.
Yeah, so you said on average, so you think there's a period of 30 years in US history where on average there was low load growth, high inflation, and poor economic growth. 30 years, that's the average.
So in the 60s, there was a boom of manufacturing, heating load, electric, air conditioning load. Utilities overbuilt the system and many gigawatts of generation was stranded. Then the 70s hit the oil embargo crisis, and then the 80s had high inflation. I mean, that's all I'm thinking of. I don't think that it's going to be exactly fitting your modeling scenario. That was just what I was thinking of, was the 60s to the 80s.
All right, thank you. Earlier, you mentioned the Indiana Amazon case for NIPSCO. Do you recall that testimony?
I don't remember mentioning NIPSCO.
But you mentioned an Indiana Amazon case related to large load tariffs. Recall that?
I just referenced the crediting mechanism that Amazon did, not the case itself.
So I'm sorry, so we're on the right page. I have it Nelson Surrebuttal 44, a reference to Amazon. Is that where where questions are being directed towards?
That works for me, Your Honor. I was referring to his testimony today, but in front of you right now, Mr. Nelson, is your surrebuttal testimony with a citation to the title of the document is NIPSCO to supply 3 gigawatts to Amazon data centers in northern Indiana. Do you see that?
I do.
And you mentioned a $1 billion payment in your live testimony today related to Amazon. Is that related to this case in the citation in front of us on the screen?
Yes.
And you mentioned that in the context of a community benefit payment. Do you recall that being the context of you mentioning it live today?
I object. I think Ms. Stace, the testimony is to like the term payment, but other than that, fine.
Okay, well, the witness can qualify and explain while answering.
Yeah, sorry, Judge.
It's all right. Go ahead.
Yeah, I don't know how I would have to look back at how I exactly described it earlier today, but it kind of my testimony speaks for itself. It's a rebuttal.
Right, but however you want to qualify $1 billion, it was in the context of a community benefit agreement as you spoke about it today live on the stand. Is that fair?
I don't recall whether I called it a community benefit agreement. I just knew that it was a rate credit.
It's a rate credit to all customers, and it's going to be paid over 15 years, right?
Yep.
So it's not a $30,000 a megawatt requirement to enter into community benefit agreements with non-governmental organizations. True?
True.
Thank you. Mr. Nelson, I'll switch gears a little bit, and Your Honor, this line of questioning will be on the NERC long-term resource assessment, or reliability assessment, sorry, that we had up earlier.
All right, let's go off the record and give me a second. So that's the LRTA, LTRA?
Yes, Your Honor.
All right, let's...
I guess while we're off the record, it doesn't matter to me whose witness we put it in as, but I would like to offer it as an exhibit to either Mr. Nelson or Dr. Fisher.
Okay, well, let's... Okay, why don't I ask first if there are any objections to that?
Are you on the record?
Oh, yeah, we're off. Yeah, okay, let's get back on the record.
Okay.
So, yeah, so the applicant has, we brought up on the screen the LRTA 2025 document from NERC that has a date on it of January 2026. And the applicant is requesting to move that into the record. Are there any objections? Okay, with that, I think we've already heard this document discussed with Fisher. So who has less exhibits? I think it's Fisher. Yeah, so why don't we make that Fisher 16? And if we want to refer to it like that from now on, would be fine.
Thank you.
Let's just go off the record for 1 second here so I can document that for myself. All right, I think that will do it. So proceed with your questions, Attorney Patrick Proctor-Brown.
Thank you, Your Honor. Mr. Nelson, what is NERC?
North American Energy Reliability Council, perhaps?
I said it's the North American Energy Reliability Corporation. Would you have any reason to doubt that representation?
No, right there at the top left.
Yeah, thank you. And NERC is formally designated by FERC as the Energy Reliability Organization for the United States Bulk Electric System, correct?
I'll take your word for it.
Are you aware that NERC publishes an annual long-term reliability assessment?
Generally aware.
Do you believe NERC is an authoritative organization or purveyor of information about reliability in the United States?
Yes.
Are you aware that the NERC 2025 Long-Term Reliability Assessment, which is dated January 2026 and on the screen, identifies MISO as facing elevated resource adequacy risks beginning in 2027 and reaching high-risk status by 2028?
Yes.
And Your Honor, if we go to page 15, I believe.
I'm sorry. 15?
15 is where I wanted to go, yes. The NERC 2025 assessment states that MISO forecasts its coincident total internal demand to peak at 127 gigawatts in summer 2026 and grow to 143.7 gigawatts by 2035, with data centers representing the largest contributor to this demand growth. Is that consistent with your understanding of demand growth within MISO?
It's my understanding of this document.
And the assessment further indicates that MISO's projected resource additions do not keep pace with escalating demand forecasts and announced generator retirements. It's at 7 and 15 of this document, I believe. Is that consistent with your understanding?
That's what the document states.
You acknowledge that flexible dispatchable resources like gas-fired combustion turbines can provide critical reliability services when solar output declines during evening hours and when the wind is not blowing. Is that an accurate statement?
Are you referring to my testimony?
Yeah, I believe at 14 you talked about, you acknowledged Mr. Shilendranath's testimony that volatility can increase the value of gas-fired combustion turbines.
Are we on the Sir rebuttal, counsel?
Yes, Sir rebuttal, sorry.
Yeah, I'm there. Do you mind repeating your question or having it read back?
Let's read it back.
I believe at 14 you talked about, you acknowledge Mr. That long name, testimony that volatility will increase the value of gas-fired turbines.
I'm sorry, I'm not sure that I understand the question as it's stated.
That's fine, I can ask a new one.
All right.
Right there in the middle of the page, you quote for Mr. Shilendranath's testimony, price volatility increases the value of gas-fired combustion turbines because these resources are designed to cost-effectively and quickly respond to price changes. I don't see you disagreeing with that quote. Do you agree with it?
Yeah, I'm not disagreeing with it.
So you would agree that when volatility increases, dispatchable resources like combustion turbines should have higher energy margin and be able to create greater energy benefit for customers. Is that a fair statement?
Any resources that can provide those grid services, including storage. Yeah.
And gas-fired resources can provide those services under different circumstances than storage. Would you agree?
Objective form as to what different circumstances mean.
They don't provide those services exactly the same way as BESS. Would you agree with that?
You can define grid services in different ways, and it's possible that you can define it in such a way that gas provides a different service than storage.
So both of those types of resources can provide grid services that could be valuable to the broader grid. Would you agree with that?
Yes.
So if you, for example, have a 4-hour battery and have tight conditions greater than 4 hours, your CT might provide more benefits to customers than that 4-hour battery. Is that fair?
In that specific example, yes, that's how I would say grid services work at a high level.
And that's in contrast to variable energy resources, which aren't dispatchable, so can't provide the same types of benefits to the grid as dispatchable resources like BESS and CTs. Would you agree with that?
I don't really get to that level of granularity in my testimony. You can create hybrid resources and compare the grid services to what the needs are. And that's how I understand most integrated resource planning to work. So you're going to a need and creating a portfolio to provide the overall needs of the system.
Right, and different resources provide different benefits to that diversified portfolio. You agree with that?
Yes.
But you mentioned hybrid resources, solar and wind standing alone are not dispatchable, right?
Correct. I mean, they are dispatchable, that you can ramp them down.
You can limit how much energy they're provided to the grid. You can't increase it
Yes.
without solar or wind environmental resources, right?
Yes.
So they have less ability to take advantage of tight or insufficient capacity on the grid at any given hour of the day, right?
Which is why many sources are hybrid.
Essentially, when the sun isn't shining and the wind isn't blowing, you have to rely on more dispatchable resources like BESS and CTs, right?
Depending on the overall portfolio, but generally, yes.
Okay. And the NERC 2025 assessment states that planning reserve margins in MISO are projected to fall below required levels in summer, driven by generator retirements and load growth outpacing new resource additions. Are you aware of that?
Are you reading from page 15?
It starts on 14 and then there is some paraphrasing on page 15.
Okay. 14. 14's a table.
So that shows some of the
okay.
inability to meet the summer peak on the table, and then I was paraphrasing some of it.
So based on the table, that's what you're basing your statement on. Okay, I thought you were reading from it. That's why I wasn't sure. Okay, go ahead.
I think there was a pending question. I don't know if you need it right back, Mr. Nelson.
I believe you're just reading the document to me, and I think it states what you read.
Okay. Tight or insufficient capacity is likely, all else equal, to lead to higher energy prices, right?
Are you still reading from the document, or is this?
No, I wasn't reading from the document. That was My question to you.
Can you please read that question back?
Yeah, let's read it back.
Question, tight or insufficient capacity is likely. Sorry. Got big boxes. I'm sorry. Equal, qualified. Tight or insufficient capacity is like or equal to load equal to high energy prices, correct?
It would depend on the portfolio and then most likely the net load, and it would depend on the portfolio mix as to how the energy prices fluctuate over the year.
But tight or insufficient capacity is more likely to lead to higher energy prices than being long and having sufficient capacity. Would you agree with that?
If you're assuming the same resource mix and different load levels, presumably, yes.
It's kind of a basic principle of supply and demand. Your supply is down, demand is the same, prices should go up, right?
Correct.
And the CTs that have been identified as capacity only resources are more likely or are likely to be able to take advantage of those higher prices. Is that true?
More likely than variable renewables? Yes.
And the NERC assessment warns that new resource additions in MISO are increasingly dominated by solar and wind generation, which makes it for a less flexible dispatchable grid. Would you agree with that?
Is there a portion, Council, of the report you're referring to?
It talks about it a little bit here on 15, and then again on 31.
I'll object to the extent the document speaks for itself. And if he wants to have the witness comment on various parts, I don't have an objection to that. But I think that was a paraphrase.
Yeah, it was a paraphrase. Do you have any reason to dispute that generalization about the report?
Can you define what you mean by flexibility?
Well, if your generation portfolio on the grid is made up of more variable energy resources, the grid as a whole has less flexibility to respond to disturbances or to high prices. Would you agree with that?
It would depend on your supply side resources, partially.
Well, that's what I mean. The generation mix is changing to be more variable, more wind, more solar. That has less flexibility to respond to disturbances on the grid or to high prices. Do you agree with that?
Yeah, I'm just looking at your supply side first. Yeah. I would say at a high level, that is probably accurate.
So have you read Mr. Fisher's rebuttal testimony? Dr. Fisher's rebuttal testimony? You have not?
No.
Okay, you're aware of Mr. Kurlikowski's rebuttal testimony that identifies $430 million in net present energy value savings for the capacity only resources in this docket, right?
Yes.
And your recommendation is that the capacity only resource option should be eliminated from this tariff. Is that a fair summary of your recommendation?
Yes.
And that would eliminate that $430 million benefit to non-participating customers. Would you agree with that?
The claimed benefit from the company, yes.
Do you agree that non-participating customers will also receive a reliability benefit from Red Oak Ridge and Foundry Ridge?
I didn't analyze those projects and their reliability benefits.
Okay, you did talk about the capacity-only resources, and you are aware that the two that have been identified are Red Oak Ridge and Foundry Ridge, right?
Yes.
And you're aware that those are combustion turbine-based projects?
Yes.
You agree that as combustion turbine-based projects, those units will provide a reliability benefit to the grid as a whole?
By that, you mean all else constant, they're going to lower the loss of load probability?
Yes.
That would be true of adding most generation, but yeah.
Okay, and specifically CTs can provide grid benefits that can't be provided by variable energy resources, right? Talked about that.
I think you have to look at this from a portfolio perspective. When you're zeroing in on one thing, again, it's not taking the system needs into mind and how you cost effectively address those system needs. So your questioning is just looking at one thing, but when you're doing a planning process, you're looking at more than one thing.
Right, but I want to focus on one thing because those are the capacity-only resources that have been identified before today, and you've criticized the capacity-only resource concept. So I want to focus in on those two units for that reason. Is that fair?
Yeah, I'm looking at it from a tariff perspective, and I'm not analyzing reliability studies.
And I'm not asking you to analyze it. I'm saying you've talked about harms to non-participating customers. I want to talk about some benefits. One benefit of an additional CT resource that will accrue to everyone on the grid has to do with reliability. Would you agree with that?
Can you read that back, please?
Sure, go ahead.
I want to talk about some benefits. One benefit. I'm sorry, everything is not lining up for me. I'm sorry, Mr. Proctor Brown. One benefit, and I have one benefit of, I'm sorry, I'm getting extra letters. One benefit of an additional CT resource that will include everyone in the grid has to do with reliability. Would you agree with that?
I apologize that I could not hear that.
Can you
hear me? Can you hear me now?
Now I can, yeah.
Okay.
It was just a little low, I'm sorry.
I apologize. I want to talk about some benefits. One benefit of additional CT resources is that it will include everyone on the grid that has to do with reliability. Would you agree with that?
It would probably increase reliability. It's the cost to create that reliability that's uncertain in my mind.
Okay, but setting aside costs, it is possible to quantify in various ways the reliability benefit that will be enjoyed by the grid after adding Foundry Ridge and Red Oak Ridge, right?
There are methods to do so.
And you've reviewed Mr. Gerlikowski's analysis of the net savings to customers, correct?
At a high level, correct.
Does that analysis quantify the reliability benefits to non-participating customers of Red Oak Ridge and Foundry Ridge?
That is the company's testimony.
I don't think it is. I think the testimony has to do with net energy margin and market revenues, Would you agree with that?
Can you point me to the conclusions that you're referencing?
I believe it's in Mr. Gerlikowski's rebuttal testimony on, I want to say page 2 or 3, the conclusion. That's this paragraph right here, Mr. Nelson, is the summary of the conclusions. And it talks about the average savings of 400 million for Red Oak Ridge and 31 million for Foundry Ridge. You've reviewed this before?
Yes.
These average savings compare the revenue requirement payments assigned to non-participating customers to the energy margin and ancillary services margin that these units deliver to non-participating customers. Don't include any quantification of reliability benefit, correct?
Correct.
So I believe your testimony is you can quantify reliability benefit. That would be in addition to the $431 million in net savings addressed in this paragraph, right?
Well, you'd have to net out the reliability costs caused by the VLC, and those could be significant. NERC is investigating large loads tripping offline and how to address those contingencies. Dominion lost 1,500 megawatts of data centers and almost caused cascading blackouts in the PJM territory, which would cost a lot of money in reliability costs and lost load. So I think you got to have two sides of the equation.
Hang on. Let's hear the rest of the answer.
You got to have both sides of the equation. If you're going to quantify the benefit of the CT for serving the VLC, you got to quantify the VLC's costs that are required to serve it from a reliability perspective. And they're having to reevaluate the protections needed at the transmission network to serve those loads.
Right. So you agreed, I believe earlier today, that Wisconsin Electric has an obligation to serve the data centers as a public utility in Wisconsin, correct?
Correct.
So the reliability costs related to data centers you just discussed, that would be true with or without the CTs that are the subject of this paragraph, right?
You're talking about average savings, though. So I would think you'd want to be netting costs and benefits.
The costs related to the data centers will accrue in both cases, with or without the CTs, right?
Well, I guess what I'm saying is that I don't think that we have quantified the reliability costs that NERC is still investigating around related to serving data centers.
Right, but those costs will exist with or without this tariff and with or without the CTs, right?
Yes.
Okay, so it wouldn't be fair to say the CTs are causing or costing reliability because the data centers are taking service, right?
Can you read that back, please?
Yes, go ahead.
So it wouldn't be fair to say that CTs are causing or costing reliability because the data centers are aren't taking service, right? Excuse me.
Yeah, I think I'm identifying just a cost allocation issue. Cost identification and allocation.
Related to the data centers, not the CTs, right?
Yeah.
So the net reliability benefit of the CTs has nothing to do with the data centers. Should focus on the reliability of the CTs themselves if we want to quantify their reliability benefit, right?
Yes.
And that net reliability benefit for the CTs would be in addition to the $430 million identified in this paragraph of Mr. Gerlikowski's testimony, right?
In theory, yes.
And your recommendation is that the commission deny non-participating customers these identified benefits by eliminating the capacity only option, correct?
Correct.
Thank you, Your Honor. That's all I have for this witness.
Okay. Other cross? Last chance? Oh, go ahead.
Yes, Your Honor.
I'll let the clean go first, Your Honor.
Oh, sorry. I didn't remember you were on there. Okay. Go ahead, Attorney Cordy.
Thank you, Your Honor. Mr. Nelson, my name is Brett Cordy. I'm an attorney with Clean Wisconsin. Good afternoon. I'm going to try to refer back to a line of questioning that I don't know how long ago it happened now during cross-examination. So bear with me and hopefully we can do it without having to go back to the transcript. A little earlier, you were asked by Attorney Proctor Brown about the impacts on non-participating customers of the VLCs taking service under CP1. Do you recall that line of questioning?
Yes.
And you were asked along the lines of if the VLCs are not served under the proposed tariffs, they would take service under the existing CP1 tariff by default. And you answered that that is the current option, but there are many other possibilities. Does that sound about right?
Yes.
And then you were asked if those other possibilities would require new tariffs to be approved by the commission. And you answered yes. Does that sound right?
Yes.
Is it your understanding that CP1 could also be amended or changed?
Yes, it could be.
All right. No further questions. Thank you.
All right. And commission staff, you had questions?
I do. Thank you. Good afternoon, Mr. Nelson. Your Honor, if we could pull up the 2025 long-term reliability assessment that there was some questions on before and go to page 8.
I think we have it here. Go ahead.
Thank you. Mr. Nelson, earlier, Attorney Proctor Brown asked you some questions about this particular long-term reliability assessment and projected energy margins for the upcoming years. Do you remember those questions?
I do.
And there was some conversation about the relationship between energy prices and whether or not a particular entity is projected to be either short or long. Do you remember that?
Yes.
On page 8, well, let me ask this before I get to the page 8 table. And then you were shown some projections in this long-term reliability assessment showing a forecasted, I guess, either shortfall or short in terms of capacity for the MISO region. Is that a fair assessment?
Yes.
Okay. On page 8, the very top line where it says MISO, do you see that?
Yes.
And then on the right-hand side, there's some text where it talks about the risk summary. And the second sentence says, The recently approved Expedited Resource Addition Study, or ERAS, process is expected to result in additional resources in the MISO system beginning in 2028 that are not included in the model for the 2025 LTRA. Timely implementation of ERA's resources will eliminate reserve margin shortfall and improve expected unserved energy metrics. Do you see that?
I'm sorry, and improve.
Unserved energy metrics.
Thank you.
I do.
Does anything about that explanation change any of your answers or your opinion?
Well, this would address a lot of the energy price issues because there will be less scarcity. And as the exchange discuss, it's a simple issue of supply and demand. So supply is going to go up and lower the price. And there will be a lower level of scarcity in the MISO market.
Okay, thank you. I don't have anything further.
Okay. No other cross redirect?
Yes, Your Honor. Thank you.
Okay.
Mr. Nelson, just getting to that very last line of questioning from Attorney Proctor Brown about the reliability benefits of the CT projects. Is it fair to say that if there were no data centers, there would not be those CTs to begin with?
I believe so.
Okay. The other, I want to get back to some of the questions from the beginning of Attorney Proctor Brown's examination. Starting with his questions to you about economic modeling and whether you had conducted economic modeling or quantitative analyses of the harm to non-participating customers of the tariffs. And you said you had not conducted those kinds of analyses. Was it necessary? My question to you is, was it necessary to do modeling or those kinds of quantitative analyses to render the opinions that there would be harm?
No, it wasn't. It's really just an issue of tariff design and cost allocation. And the structure of the tariff allocates costs to non-participating customers. And that's going to have a rate impact, and it has a risk that comes with it. And my position is that there's several better ways to design a tariff than what's being proposed here. And the tariff, omits transmission cost allocation for the most part. And those are significant harms to the non-participating customers by being allocated to socialized transmission costs, as well as a significant risk.
You were also asked some questions about that it was your understanding, or whether it was your understanding, that the utility has the duty to serve all loads that come to it, including these large data centers. Is it your understanding that the commission is, we'll strike that. Is it your understanding that those large loads must be served in all ways and in all manners in which they demand service?
No, it's not. I mean, they have to be served, but how is the question that we're determining here? And you don't have to build the CT plants that are proposed and in construction. There's different ways to provide service, and there's different options for providing service. And the tariff restricts a lot of the options to provide service to VLCs around demand response, around using behind the meter generation, around using flexibility. And so, those restrictions are going to escalate the costs most likely. of serving those customers. So we want to be serving these customers at a reasonable cost, and you still have to have just and reasonable rates for all ratepayers.
I'm going to turn now to the NERC report you were asked some questions about. And you specifically were asked about the benefits that the CTs could provide in, I think the term was in tight circumstances, versus other options like a 4-hour battery. Does the NERC report discuss any other ways to resolve those scenarios?
Yes, you can resolve those scenarios, with any portfolio of resources that can generate similar services. And so that's why having a more broad planning process can lead to lower cost solutions, is because you're looking at how the portfolio provides services as opposed to what one unit does. And then additionally, increasing transmission, which seems to be considered in the NERC report as well, can change the needs on the system as well and provide services.
I want to draw your attention to page 47 of the NERC report, Your Honor.
Okay, sure.
Does this report also discuss storage as an option?
Yes.
And does it make any projections about storage?
Yes, at the bottom of the page, it's discussing the increased interest in battery storage with more than 500 megawatts currently online. And the Q projects identifying more than 100 gigawatts of battery or hybrid fuel type projects. And 7 gigawatts by 2035.
Would those be alternatives to addressing energy needs to the CTs?
At least in portion. Again, we would want to be looking at how they fit in with the portfolio. But in combination with wind and solar, these can provide similar services to CTs.
Okay. In your direct testimony, also, you discuss options such as flexible demand. Would those be other ways to address tight circumstances or tight conditions like Attorney Parker Brown was mentioning before?
Yeah, and I believe that the NERC report also references the expectation in discussion about large loads on page 45. There at the bottom of the left just cites large loads as DR resources being an issue, and essentially the tariff makes it so they can't do demand response. So that's a hindrance to providing flexibility and benefits into the MISO market.
You were also asked earlier about if the combustion turbines went away, that would also remove the $435 million benefit to non-participating customers that Mr. Gerlikowski testified about. And I was just wondering if you had anything else you wanted to say on that subject. I wasn't sure you finished your answer.
Yeah, there's a level of uncertainty with whether those benefits will materialize. And there are other ways that you can design large load tariffs that could insulate non-participating customers from having to take that risk on of whether or not the benefits are going to materialize.
Is there anything else you wanted to address from the cross-examination we haven't already covered to complete your answers?
No, I don't think so.
Okay, I have nothing further then, Your Honor. Thank you.
Okay.
Your Honor, I had 2 follow-up questions on Mr. White's questioning. If you don't mind.
I knew you would. Go ahead.
So page 7, I believe, is the chart, Your Honor, if you pull it up. Maybe it's 8.
8, I believe.
8. 8. Thank you. Mr. Nelson, Attorney White's asked you some questions about the expedited resource addition study process in the chart in front of you. Do you recall those questions?
Yes.
Are you aware that the commission verified that the Red Oak Ridge project is eligible for the expedited resource addition study process?
I'm not aware of that.
You have no reason to question my representation that the commission verified the Red Oak Ridge project is eligible for the ARIS study process, do you?
No.
Thank you. That's all I have.
All right. Thanks. Any redirect?
Nothing. Thank you.
Okay, great. All right. Thanks very much, Witness Nelson. You're excused.
Thank you.
So just go off the record and just take a stretch, stand up, whatever you want to do. Just don't go anywhere.
I'm going to get
Except
up and
for
walk.
you can go. You have to. Okay.
I can go take a nap. I'll
A
be ready.
nap? Oh, well, no, not a
No, I'm not even tired.
Good.
Beyond
Your
that.
Honor, who do you think is next, or may I ask? During my stretch, I might relocate, depending on what your answer is.
I think it's staff, right?
Yeah, I think we're to commission staff, and just in terms of order for Attorney Proctor Brown, my intention was to call staff witnesses that don't have any identified cross-examination first, just so that they could be excused after a rather long day, and then move to Attorney Field and Witness Field and Witness Millimans.
Thank you. Then I will go stretch in a different spot. Thank you.
All right.
Oh, so he decided to go away. Oh, not too far.
Said don't go anywhere. I'm just, off camera. It's okay.
That's okay. I had to have somebody do a number on my arm, and that worked wonders.
Oh, good. Good thing you have support.
Well, now I do. He was gone all day. I call it the, do you remember that as a kid when people twisted your arms? What was that called? Something. But he does that, and I need it opposite ways.
Snake bite, I think, right?
What was it?
Snake bite, where you twist the.
It twisted the
Yeah.
opposite ways. I get like a little cramp, and that's the one thing that relieves it that I can't do by myself.
Yeah, that would be pretty much impossible, right? All right, well, it looks like we're going to get started. So just want to warn everybody, because I didn't give you time to come back, but basically it's whenever Debbie gets back. That's when we'll start. So let's take commission staff witnesses. We'll start with Attorney White's to call the first one.
Thank you. First, we would call witness Greshel to the stand.
I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right, go ahead.
Good afternoon. Could you please state your name for the record?
Anna Greshel.
And in this docket, did you file or cause to be filed direct testimony, sir rebuttal testimony, and one exhibit?
Yes, I did.
Are the statements and representations in your testimony and exhibit true and correct to the best of your knowledge?
Yes.
And if asked those same questions here today, would your answers be the same?
Yes, they would.
Do you have any additions or modifications to make at this time?
No, I do not.
All right. With that, the witness is available for cross.
All right. Do we have any questions? Hearing none, you're excused. Thanks.
Next, commission staff would call witness Coble to the stand.
All right. See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Good afternoon. Could you please state your name for the record?
My name is Will Coble.
And witness Coble, in this docket, did you file or cause to be filed direct testimony, sir rebuttal testimony, and 4 exhibits?
I did.
And are the statements and representations in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
If asked those same questions, would you give the same responses here today?
Yes.
Do you have any additions or modifications to make to either your testimony or exhibits at this time?
I do not.
Thank you. The witness is available for cross.
Any questions? Hearing none, you're excused. Thanks.
Next, commission staff would call witness Probst to the stand.
Okay. Move you around a little, and if you are able to center your camera a little bit better, yeah, there we go. Thanks. All right, raise your right hand. Sorry, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Thank you. Good afternoon. Could you please state your name for the record?
Deborah Probst.
And in this docket, did you file or cause to be filed direct testimony and sir rebuttal testimony?
Yes, I did.
If asked those same questions here today, would your answers be the same?
Yes, they would.
Are the statements and representations true and correct to the best of your knowledge?
Yes, they are.
Do you have any additions or modifications?
No, I do not.
All right. With that, the witness is available for cross.
All right. Any questions for the witness? So at the risk of breaking our stride, I do have one question for you, witness Probst. This is a minor issue that I wondered if maybe you had an opinion on. And I was just curious in terms of the proposed rates, if they were to be approved by the commission, does that raise any issues with how the utility would format or the information it would need to provide in its annual reports?
So as everything that is currently in the docket, I'm not aware of anything that would cause an issue with the annual report filing. However, when the commission makes its decision, if something would come up that would impact the annual report filing, we would have to seek guidance of what to do with that, but I'm not aware of anything that would cause a problem.
Okay, so as you sit here today, there's no changes or recommendations you have to how they would submit the annual report.
Correct.
Okay. And when you say you may find out that there may be some issues, when would you know that to be the case? Would it be after the tariff's approved?
So it's if the commission would make a decision that is, based on the record, but goes a different path than what we're currently seeing, I'm not able to predict what that impact would be. But based off of what I see is in the record, I'm not aware of anything that would impact the annual report system.
Okay, so that might be something that we'd have to deal with after the fact.
Correct.
Okay, all right, that's fine. Thanks very much. So any follow-up questions from anyone about that? No? Okay, great, thanks, and you're excused.
All right, next commission staff would call witness Shield to the stand.
There you are. Raise your right hand. And do you swear or affirm to the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good afternoon. Could you please state your name for the record?
Jolene Shield.
And witness Shield, are you the same witness Shield that filed direct testimony and one exhibit in this case?
Yes, I am.
Are the statements and representations in your direct testimony and exhibit true and correct to the best of your knowledge?
Yes.
If I ask those same questions here today, would your answers be the same?
Yes.
Do you have any additions or modifications to make at this time?
No, I do not.
Thank you. The witness is available for cross.
Any questions? Okay, hearing none, you're excused. Thanks.
Thank you.
Next, commission staff would call Dr. Witzling to the stand.
There you are. Raise your right hand and do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good afternoon. Could you please state your name for the record?
Laura Witzling.
And Dr. Witzling, did you file or cause to be filed direct testimony, rebuttal testimony, and 9 exhibits in this case?
Yes.
Are the statements and representations in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
If asked those same questions here today, would your answers be the same?
Yes.
Do you have any additions or modifications to make at this time?
No.
Thank you. The witness is available for cross.
Any questions? Okay. Hearing none, you're excused. Thanks.
All right, circling back to the top of the list, commission staff would call witness Field to the stand.
Okay, there he is. Excellent. All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right, go ahead.
Thank you. Good afternoon. Could you please state your name for the record?
My name is Andrew Field.
And witness Field, did you file or cause to be filed direct and rebuttal testimony in this case?
Yes, I did.
Were you present yesterday for the testimony of applicant witness Gerlichowski?
Yes, I was.
And did you hear witness Gerlichowski's rebuttal that mentioned some discussion of your rebuttal testimony and a specific table in a data request response?
Yes, I did.
And do you have a response to that rebuttal testimony from witness Gerlichowski?
Yes, I do.
And what is that response?
I would like to add that after applicant witness Gerlichowski pointed it out, I rechecked the spreadsheets that were provided in the response to data request PSCW AJF 3.4 and found the drop-down menu that I had originally missed in my previous review that would show all 4 future scenarios in the first tab of that spreadsheet versus just the future 1 scenario.
And after reviewing that additional, I guess, tab or drop-down menu, does that change your opinion or testimony in any way?
It does not change any of my conclusions in that after reviewing all 4 futures, the general trend of the highest cost in the first year, decreasing in subsequent years, and the lowest revenue in the first year, increasing in subsequent years. Those trends were the same across the board for all four futures that were available.
Okay. Is there anything else that you want to say in response to that Sir rebuttal from witness Gerlikowski?
There is not.
Okay. With that note, are the statements and representations in your pre-filed testimony true and correct to the best of your knowledge?
They are beyond the issue with just the future one scenario mentioned already.
Okay. Do you have any additional corrections or modifications you would like to make at this time?
Nope.
Thank you. With that, the witness is available for cross.
Okay, we have the applicant signed up, so we'll take applicant first.
Yes, thank you, Your Honor. And for the court reporter's benefit, this is Lauren Rosso for the applicant.
Thank you.
Go ahead.
Good afternoon, Mr. Field. You've expressed concerns about the 75-25 cost allocation for capacity-only bespoke resources, correct?
That's correct.
Have you reviewed Mr. Stasik's rebuttal testimony?
Yes, I did.
You understand that in response to concern raised about the capacity-only bespoke resource option, Wisconsin Electric has proposed a process to review the 75-25 cost allocation, correct?
Yes, I'm aware.
And under this mechanism would allow the commission to reset the revenue requirement allocation for an individual VLC's portfolio of bespoke resources if the actual costs and benefits to non-participating customers are outside a 5% symmetrical tolerance band compared to modeled projections, correct?
That is my understanding.
You'd agree that this proposal would provide the commission with additional oversight how capacity-only bespoke resources affect non-participating customers, right?
I don't know that that would change the level of oversight that the commission was entitled to. It is a different proposal. It's a different option that the applicant witness has proposed.
It would allow the commission to analyze whether non-participating customers' share of the cost of capacity-only bespoke resources is offset by energy and ancillary services revenue, correct?
My understanding is the commission would have the option to review. I don't necessarily agree that it is the proposal itself that gives the commission the authority to review. That's more of a legal question.
Sure, but under this proposal, Wisconsin Electric would provide data on forecasts and actual costs in rate cases, correct?
Yes, that's my understanding of the applicant's proposal.
And so long as the modeling projects net benefits or net zero costs to non-participating customers, you would agree that by allowing the commission to reset the revenue requirement allocation for an individual VLC's portfolio of bespoke resources to match those modeled projections, this proposal would protect non-participating customers, right?
Your Honor, I'm going to object. I'm not sure that that entirely captures.
I'm sorry. Who's speaking?
I apologize. Attorney White's.
I don't see you. Well, go ahead. As long
Okay.
as I know who. Yeah.
I'm not sure that that entirely accurately captures the discussion from witness Stasik yesterday, because my recollection was that there was a potential scenario in which the forecast could be a net cost.
Right, and Your Honor, that wasn't my question. I said so long as the modeling projects net benefits or net zero costs to non-participating customers.
But I guess it could be a cost, was my understanding from the testimony.
My question is a hypothetical.
Okay. Well, maybe I misheard the question then. So maybe with that clarification that this isn't capturing the full extent of the proposal.
Okay. Let's read the question back, and so the witness has that fresh in the witness's mind, and then make sure that it's read with that understanding, or heard with that understanding. So we try to find that one, Debbie.
Yeah. Okay. So long as the modeling projection net benefits or net zero cost to non-participating customers, you would agree that by allowing the commission to reset the revenue requirement allocation for an individual VLC's portfolio of bespoke, is it bespoke?
Yeah.
Resources to match those modeled projections, this proposal would protect non-participating customers, correct?
Can you clarify what you mean by protect?
Prevent cost shifts outside of the tolerance band.
I don't necessarily agree that it will prevent all possible cost shifts.
But it does provide the commission an opportunity to reset the revenue requirement allocation for an individual VLC's portfolio of bespoke resources to match modeled projections outside of the tolerance band, correct?
Yes, on a forward-looking basis.
Does this proposal alleviate your concerns about the 75-25 cost allocation?
No, it does not.
You'd agree that it does help protect non-participating customers from significant cost shifts, correct?
I believe it might reduce the risk without eliminating the risk.
And you understand that the company, I'm sorry, Wisconsin Electric does not strike that. You understand that Wisconsin Electric would only propose capacity only bespoke resources that it anticipates providing net zero costs or net benefits to non-participating customers, correct?
That's my understanding of the applicant's testimony.
You'd agree that the commission will be able to evaluate every proposed bespoke resource in construction and or buy-sell dockets, correct?
Yes, that's my understanding.
That's it for me, Your Honor.
All right. Any other cross? Redirect?
No, Your Honor. Thank you.
All right, great. Thank you. You're excused.
All right. Thank you, Your Honor.
And we got...
Your Honor, we're switching one last time.
All right. So we have witness Mumans. I'm going to swear you in. Raise your right hand. You swear or affirm, tell the truth, the whole truth, nothing but the truth.
Yes, I do.
All right, go ahead.
Good afternoon. Could you please state your name for the record?
Tyler Mellemans.
And witness Mellemans, in this docket, did you file or cause to be filed direct testimony and rebuttal testimony?
Yes, I did.
And will you also be sponsoring the commission staff data request response and public comment exhibits?
Yes, I will.
Are the statements and representations in your testimony true and correct to the best of your knowledge?
Yes, they are.
Same question for the exhibits.
Yes, they are.
Were you present yesterday to hear the testimony of applicant witness Rich Stasek?
Yes, I was.
And did you also have an opportunity to review the rebuttal testimony of witness Stasek?
Yes, I have.
Do you have any general comments on, I guess, what's now being termed the new Stasek proposal on the capacity-only resources?
I have some general high-level thoughts. Sort of given the timing of when this proposal came in, it's a little difficult to have concrete thoughts. I guess more so I would characterize them as questions that need to be answered rather than thoughts themselves. But, those questions would include, if we are comparing performance compared to a forecast at the time of acquisition or construction, it's unclear how potential cost overruns would be factored into that sort of adjustment. I have hesitancies about the timeline and reevaluation period, especially given some of the discussion yesterday with, I believe it was with witness Stasek, related to, much of the attention here has been on Foundry Ridge and Red Oak, but it appears that there are other facilities potentially closer to operation date that could also serve as capacity only resources. And that did not appear to be contemplated in this timeline. And then as it relates to the 5% threshold, I'm a little wary there. It appears, at least at a surface level, it's suggesting that non-participants should have to accept some cost associated with serving VLCs.
Are there any other thoughts, or does that conclude your reaction to the modified proposal?
At least as it relates to his modified proposal, I think those are my initial thoughts right now.
Okay. Do you have any additions or modifications to make to your testimony at this time?
None that I can think of.
Thank you. Witness Mellemans is available for cross.
All right, and we have the applicant lined up for cross, so why don't we start with you?
Thank you, Your Honor. Mr. Mellemans, do I have that right?
Yep.
Okay, thank you. I'm Attorney Patrick Proctor Brown. I represent Wisconsin Electric. I think we've crossed paths in last year's rate case, maybe briefly. Nice to see you again today. I'll start with the Stasek proposal, which I think you just testified about. Do you have that topic in mind?
Sure.
And I want to kind of contrast it, talk about it in the context of one of your proposals in your rebuttal testimony, kind of at 9 and 10. I characterize that as a rider-style tariff. I think that's a quote from your testimony. Do you have that topic in mind?
Yes.
And I think you testified here this afternoon that you haven't had a lot of time to process the Stasek proposal. Your rider-style tariff was presented in rebuttal as well, right?
Correct.
And so the parties have had a similar amount of time to discuss or analyze your rider-style tariff as Mr. Stasek's proposal, right?
A similar amount of time, but I am not proposing implementation in this proceeding of my rider-style tariff.
Oh, okay. So what are you're proposing that in a future rate case, the commission might discuss a rider-style tariff? Is that your proposal?
I believe my testimony speaks for itself. I propose that this be considered in the applicant's 27 and 28 test year rate case.
Okay. In any other case, both proposals are targeted on a similar thing, right? Looking at actual results and allocating costs based on those actual results. Is that fair?
At that high level characterization, yes.
And so Mr. Stasek's proposal may, I don't want to put words in your mouth, it may address some of the same concerns you have with the proposed tariffs prior to the Stasek proposal. Is that fair?
In part, but certainly not in whole.
Okay. So I want to go to your surrebuttal testimony at pages 6 and 7. So at line 20, you write, then VLCs would likely default to the CP1 rates. And then you say the applicant has other optional tariff offerings that these customers may qualify for and could elect to take service under. And then there's a footnote 5 at the bottom. Do you see that testimony?
Yes, I do.
And footnote 5 refers to the RTMP and RTP riders, right?
Correct.
Are those the only two options that you had in mind when you drafted that sentence about optional tariff offerings?
Those were certainly the first two that came to mind. I know the applicant has tariffs related to firm and non-firm load. Based on everything we've seen in this proceeding, these VLCs seem to be particularly interested in firm load, so those seem like non-starters to me.
Okay, so if we're talking about taking firm service, you've identified three options: the CP1 tariff, and then the two optional riders, RTMP and RTP. Is that fair?
From the applicant's current offerings, yes.
And I believe in this footnote, you talk about the caps on enrollments in RTMP and RTP, right? In the footnote?
Correct.
Fair to say both of those offerings are fully subscribed right now, right?
I can't speak to that.
You have no reason to question my representation that they're fully subscribed?
I have no reason to question that.
You say that the caps on enrollment would likely need to be altered to facilitate, it's a tough word, 4:30, full enrollment of VLCs. Is that what the footnote says?
That is what that says.
Okay. And you reference that, I think, because the VLC's load is larger than the enrollment caps. Is that fair?
Correct.
But even those optional tariff riders would require a commission change for the VLCs to take service under them, right?
Correct.
And the RTMP and RTP, they're not embedded cost riders, right?
Correct.
So in fact, if the VLCs took service under those riders, they would pay less towards generation than if they took service under the CP1 tariff, right?
I mean, they'd be paying market, by and large, they'd be paying market prices. I can't necessarily speak to the specifics of your question there.
They don't have direct assignment of generation costs in those two tariff riders, right?
Not that I'm aware of.
And the proposed tariffs here, they have both market prices and direct payment of generation costs, correct?
That's correct.
Would you recommend that the VLCs take service under RTMP or RTP?
I never made that recommendation.
Okay, and you're not making that recommendation now, right?
No.
A little bit earlier in your testimony, your survey testimony, pages 2 and 3, you discuss Mr. Nelson's testimony related to cost of service studies. Do you recall that testimony?
Yes, I do.
At the top of page 3, there's a sentence: absent a directive to separate all costs associated with VLCs, and absent a cost inclusive of VLCs, commission staff will note the commission may not have a mechanism in place to facilitate future analysis on the potential cost and revenue impacts of the VLC and bespoke resource tariffs. Did I read that correctly?
I believe so.
Did you review Mr. Zagantz's testimony in this docket?
Briefly, yes.
And broadly speaking, Mr. Zagantz says in the upcoming rate case, the Wisconsin Electric's intent is to separate all costs related to the VLCs at the entity level or at the same level as the Wisconsin jurisdiction is separated from the wholesale jurisdiction. Is that your general understanding of Mr. Zagantz's testimony?
That's my general understanding, yes.
And you talk about a directive in your testimony, but if Mr. Zagantz accurately and subject to audit by the commission staff separates those costs, you would agree that a cost of service study would no longer be necessary. Is that fair?
If everything is done 100% accurately, it would appear that cost of service is necessary, but I certainly couldn't commit to that statement here as a matter of fact today.
And I maybe misheard you, but I believe your testimony was it might be accurate that if the costs are separated at the entity level, then a cost would not be necessary. Is that true? Is that your testimony?
Not precisely. Provided that all of the information from the applicant is provided to commission staff and it is entirely accurate, captures every single cost associated with serving VLCs, then it would appear that a cost of service study is not necessary.
And the reason I asked is because the first time around, I didn't hear if you said not necessary or some other testimony. You did say it would not be necessary if the costs are separated, correct?
And
I don't want to go back and forth too much, but
yeah, that's not exactly what he said, but I think
okay. Well,
it had to be accurate too, accurate and include all of
right.
this.
So accurate separation of costs at the entity level, a cost would not be necessary.
Sitting here today, I can't think of a benefit that a cost of service would provide.
Okay, thanks. And it's your understanding that that separation would be subject to audit by commission staff in rate case proceedings, just like any other revenue requirement analysis submitted by the applicant, right?
That is my understanding.
Okay, thank you. So you also provided some testimony in response to Mr. Reese, and that's on page 8 of your testimony. Mr. Rebuttal. Sorry, maybe I have that page number wrong.
I believe it's 3. Is that what you're looking for?
3 into 4, yes, thank you. One thing you discuss is Exhibit WEPCO Reese 3, which is referenced at least once on the bottom of page 4. You see that?
I do see that reference.
And that's a S&P Global December 2025 credit report, right?
Correct.
And you acknowledge that S&P Global is one of the 3 major corporate credit ratings agencies, right?
I will take your word for it.
So you would accept the representation that S&P Global provides credit ratings that are relied upon by investors and creditors worldwide to assess financial risk. Is that fair?
If your previous statement is correct, that seems fair to say.
Okay, but you reviewed Exhibit WEPCO Reese 3 before you submitted your testimony, right?
Correct.
And you would agree that this is a credit report for applicant issued by S&P Global, right?
Yes.
And at page 2, the report says, we expect the tariff will enhance WEPCO's credit quality by protecting existing customers from the significant costs associated with generation investments needed to serve the new load, as well as from long-term credit risks posed by the data center counterpart. See that?
I'm sorry,
Oh, yeah, we missed
the last bit, long-term credit risk proposed.
By the data center counterparts, correct?
Thank you.
It's right there in the middle of it.
That is what this report says.
And your testimony says it's not clear if S&P Global's report about the proposed tariffs is more closely tied to the overall tariff structure and termination provisions as compared to a potential conclusion that S&P Global's report is tied to the proposed ROE. Is that true?
That is generally what my testimony says.
But the report at page 2 says, if approved, we expect the tariff will enhance WEPCO's credit quality, referring to the tariffs as a whole, right?
I would assume they are referring to the tariffs as a whole.
And one component of the tariffs as a whole is that set fixed ROE for the bespoke resources, right?
I believe my testimony acknowledges that.
And you're not an expert in what these credit ratings agencies are looking at when they make their credit determinations, are you?
No.
So you have no basis to conclude that S&P Global's analysis was incomplete or flawed in any way, do you?
No.
Mr. Reese testified in his rebuttal testimony at pages 16 and 17 that the proposed ROEs will not be paid by non-participating customers, but by the VLCs themselves. You have no reason to dispute that, do you?
I believe I said so in my own testimony as well.
Okay. And given that S&P has indicated that the proposed tariffs support Wisconsin Electric's credit quality, you would not recommend the commission reject the tariffs based on credit concerns, would you?
Purely based on credit concerns? That's generally not how I would draw my conclusions.
Okay, thank you. Are you recommending that the commission reject these tariffs?
Commission staff tends to not take a position in these proceedings and just attempts to complete the record and provide the commission with as much information and options as possible.
Okay, so the answer is no, you aren't recommending the commission reject the tariffs. Is that fair?
I don't have a recommendation.
At all? You have no recommendations at all?
Your Honor, I'm going to object at this point. I think the witness's answer speaks for itself on this particular topic.
That's fair. I'll withdraw. That's all I have. Thank you, Mr. Mellemans. Mellemans, right? M-E-L, Mellemans?
Whatever you say is fine.
I'm sorry. I really apologize. I thought I had it, and I think I lost it, so my fault.
I've heard every possible permutation. It's all good.
Sure. Oh,
I think
my apologies.
50% accuracy is probably all as good we're going to get.
That's right. Well, thank you very much. I appreciate your time.
Okay, so that's all our witnesses.
Your Honor, could I just ask one question on redirect?
Yeah. Let me ask if there's any more cross. No? Okay, so redirect, go ahead.
Thank you. Earlier, you were asked whether or not the STASIC proposal modifying the capacity-only bespoke resources would assuage your concerns that caused you to propose a rider in your rebuttal testimony. And you gave the answer in part, not in whole. Do you remember that?
Yes, I do.
What concerns would not be addressed by the STASIC proposal?
Broadly speaking, any cost not related to a capacity-only resource would not be addressed by the STASIC proposal.
And do you have any specific examples that you can think of that might be those sorts of costs?
The first one that comes to mind is transmission. I know there's been a lot of testimony on transmission, certainly covered by other witnesses, but that is the first one that jumps to mind.
Thank you. I don't have anything further, and I know everyone has had a long day, so I'll stop there.
All right. So I did want to just review something with you. witness Melman's that I reviewed with witness Singletary, speaking of that special service tariff, and if your understanding is the same, were you here when we were asking questions of witness Singletary?
Yes, I was.
Okay, so we can maybe forego a lot of the preliminaries. So I do have that on the screen here. And I was just wondering if you're, well, maybe I don't have it yet. Sheet 15. Okay. And I was just curious if your understanding was the same. Do you recall that he spoke of the special service tariff being, if I can describe it correctly, sort of a modification to standard tariffs if something about the way the customer's connecting to the system deviates from what's considered standard arrangement? Did I get that right? First of all, is it well? I don't know. You were there when he spoke. Is that yours? Do you agree that that's what witness Singletary was talking about?
I believe so. My understanding of this portion of the tariff would be heavily influenced by the testimony given by applicant witness Stasek yesterday and cub witness Singletary this morning.
Not something you're necessarily familiar with through the course of your work.
It's not something that's come up in my past work.
Okay, that's probably good enough then. Okay. Okay, and then I think at some point we heard a question for, I think it was witness Fisher, I believe, was asked by, I think it was Clean Wisconsin's witness attorney about a cap on the CP1 demand level. Do you have an opinion on that?
Just speaking from my experience with the various tariffs that our utilities in the state of Wisconsin have, it'd be highly irregular, and I can't today think of an example where an upper cap is placed on the largest tariff available to customers. That would appear to be a restriction on service, or could be. I don't want to make a legal conclusion here, but I'm not familiar with any utility that has a tariff where that largest energy user tariff has an upper cap on it.
Okay. Are you aware of any other utility that's been requested a demand level as large as what we're dealing with in these tariffs?
Sorry, by demand level, do you mean like the eligibility criteria for this?
Correct.
tariff?
The maximum. Yes.
Okay. I am not familiar with anything being requested at this level.
Mm-hmm. Okay. So this is a new scenario we're facing.
Yes.
Okay. All right. Okay, that's all I have. Do we want any redirect on that? No. Okay. Thanks very much, witness. You're excused. Okay. Is there anything else we need to address while we're on the record? Okay. So let's go off the record. I did have just one cleanup question, and I can't remember who sponsored this exhibit. I think it's either Fisher or Nelson because they have the most. But actually, Fisher doesn't have that many. But there's an exhibit that I noted in the comments where it was a table with various states and how commissions in other states were evaluating very large customer service, and I think I mentioned in the note that some of those descriptions were cut off in the PDF. So I just want to swing back and make sure that that party understood that I wanted them to refile with the entire pieces of, a complete picture of what was in there. And I don't know if whoever that is, if you know who you are. Oh, there we go. Walnut Way. Yeah, go ahead. So I just want to make sure, verify we understood that because it might have gotten lost in the shuffle. So you understand that. Okay. Otherwise, nothing else. So Great. Well, let's get back on the record. So I want to thank everyone for joining us the past 2 days and discussing this important topic. Seems like we'll be able to get all of our revised filings in by the deadline. I think there may be, if there more time is needed for some of the data requests that need to be revised and then filed as exhibits, let me know. Just email the service list to note that there more time is needed, and with that shouldn't be a problem. And then the transcripts may have a quirk to it because we have both confidential and DCI confidential. I guess one proposal I was going to make is to just instead of separating this somehow, if we could send the draft transcript that contains the confidential information only to the attorneys of record that are outside counsel for the DCI customers, and eliminate any DCI employees from the list that we send out the document to, then that would at least prevent us from having to create 2 confidential transcripts. So is that okay with everyone? Any of the DCI parties have a problem with that? No? Okay. So we will be attaching a password to the confidential transcript, and I'll send out that on a separate email, but so that we don't have a document being emailed with that's can be accessed without a password, a document with confidential information. Otherwise, I think that's all we have. So unless there's anything else, we'll close it out. Okay. Thanks very much. Then we're adjourned, and take care.
Can you stand?
Yeah.
Thank you, Justin.
Thank you.
All right. Take care.
Thank you all.
Thanks.